Hello, everybody. Good morning. Take two. Thank you so much for coming back and joining me. I greatly love and appreciate you. We had a little glitch this morning, and I'm so embarrassed, y'all. Wow. I apologize so very much. Forgive me. As I look away, I am realigning everything and trying to get all my ducks in a row again. Y'all are amazing. You know that? You know that? You're simply amazing. And I really appreciate you very, very much. Okay, we were talking about the trial for Young Dolph, and we were discussing his how it happened. And so let me give a really quick recap. Hello, Britt. Thank you for telling me and coming back over. Appreciate you. So, for those of you who don't know, Young Dolph was an up and coming rapper, and he started his own. Hello, Toxic Talon. Hello. He started his own music producing company. Things were going good for him, and long story short, he went into a cookie shop to get cookies, I presume. And two men hopped out of a car and unloaded a bunch of lead into the I got a big nail snag into the front of the store, ending his life. Oh, he was a major underground rapper. Thank you, Telon. I don't know the verbiage to use. I heard someone say he was up and coming. So thank you for the correction. He was a major underground rapper. Not in that world. But I recently listened to some of his stuff. He was good. And long story short, he was his life ended when Justin Johnson and another person opened up a bunch of lead through the storefront and ending his life. Right now, we are on day 4. We are going into closing arguments and, jury instruction, closing arguments, and verdict watch. This case is interesting for me because I was shocked that the defense didn't even put on a defense, although they really don't have to. But in this case, there's nothing they can do. They have video of Justin wearing the clothes prior to the incident that matches the video images exactly. They did have on the COVID mask, what they're calling now, we call them surgical mask, medical mask. But unfortunately for him, there's just too much evidence against him. And it really doesn't help when your stepbrother testifies against you. The people who were in the vehicle, there was one person driving, 2 people doing the lead shooting. All of this to say, he really couldn't defend it. You can't refute the video. You got that right. Talon, it is very nice to have you here. Thank you for joining. What was I thinking? Oh, I know what I was going to do. I kind of got rattled because I had to restart my life. So forgive me. I am looking for weather updates on the hurricane. We have people who we know through our live who are in the zone of the hurricane. I'm going to start it from here. This is about 3 hours ago. I'm going to share screen. Stage. Big and me. Excuse me. There we go. I'm going to play this for a moment while we're waiting. That's right. Well, I know it's your birthday today, Toxic, but we also have another birthday person. If she comes on today, but we will do birthday for you in just a minute.
Points the camera shaking. There you go. Just showing the wind gusts that we are transitioning to other coverage. 6:32 here
Oh
on the
my
East
gosh,
Coast. We're
look,
going to
you
get to
have
our second 2-minute commercial break.
whoa, y'all. I gotta go grab the door. I'm gonna let this run. Look at the second one forming right there. Ooh,
For
that
the
not
hour.
bueno.
Want to give you
I'll be
some
right
of
back.
the live pictures that we have this morning. Coming into our live now from Fox Studios. This is a live look at the Tampa skyline. You can see a lot of cloud cover at this hour, and you could even see at some points the camera shaking. There you go, just showing the wind gusts that we are experiencing from Helene. Also giving you a live look out view of Hillsborough Bay in Tampa, Florida as well. Look at those palm trees they are waving in the distance. Wind gusts, again, close to almost Category 2 strength. We do continue to monitor Helene as it gains strength this Thursday morning. We'll be right back.
Okay, I'm back. I wanted to talk about that for a quick moment, though. Thank you so much for waiting. My son has been struggling.
For our
My son has been struggling with some kind of a bug, and it's been really
region.
hard for
Talk
him.
about when
So
that
I've been
happens,
kind of
and
covering the
also
shop.
how high the
So
winds
if
will
you
get.
hear
Yeah,
the
we're still going to get some
ding
wind
and I
out of
get
this
up,
thing,
that's why.
tornadoes aside.
I appreciate you. Okay. Oh, that's not what I wanted. I want to go. Yes, I want to go right there. What do you see right here? Florida, my prayers are with you. You are getting ready to get hit something. Watch.
At this hour, as they were
Watch it form.
transitioning to other coverage. 6:32 here on the
That's
East
a
Coast. We're going to get to
small.
our second 2-minute commercial break of the hour. Want to give you some of the live pictures that we have this morning. Coming into our live now from
I'm gonna
Fox Studios. This is a live look.
You know, you have insurance, you hope something like this never happens, but, sometimes it's the cost of living in a beautiful place, living by the river. So, there's
until sometime between 6
Look at
and
that.
9 p.m. Eastern. We'll keep you updated as we do have all that information come in. Let's head to a quick 2-minute
this
commercial.
angers me.
This
They
news
took the
conference that is
interpreter
going
off
on
the
over
screen,
in
y'all.
Hillsborough County, Florida.
They should
Now,
have
you
the
are hearing
interpreter
from
there.
different officials there as they
Y'all,
provide the latest
that angers me.
details. Again, they are going into
They have
detail
an
about the storm
interpreter there.
itself. Some of this, of course, will be local to that Hillsborough County area, but we want to bring all of these news conferences to you.
Evacuation zone.
Our Fox 13 Tampa team, as they have a team of reporters who have been out in the field
So
covering this storm from
I am
each and
watching
every
this
angle.
on
Let's pop
another
up the
app.
audio here
I
and
cannot
listen
show
in
you.
on
I
Live Now
apologize
from
because it's an
Fox.
Apple
Into parts
app
of Georgia,
and I'm
South
not
Carolina
on an
as well.
Apple
So unfortunately
device.
for them, that tornado threat comes later tonight. As for our tropical storm force winds, I mean, just look at how much of the state is encompassed in that. That's the potential for 40 plus mile per hour winds. And that's going to be a big takeaway from Helene. Just the sheer size of it, this whole blob of yellow here, that's where we have the potential for tropical storm force winds.
Okay, we are coming into court. I am switching the live feed. Prayers for everybody. All right, Miss Toxic. This, my dear, is for you.
Happy birthday to you. Happy birthday to you.
Happy birthday, Miss Toxic.
Happy birthday. Happy birthday to you.
Happy birthday to Miss Toxic and Miss Kristen. Miss Kristen, you're not on yet. That's okay. When you hop in, we'll sing to you again. Miss Toxic is a fabulous friend of this channel. And we greatly appreciate you. Happy, blessed birthday. May there be many, many more. Y'all, she is one of my mods. She also owns As the Gavel Drops. And as I'm speaking about As the Gavel Drops, let's go over to... I'm trying to get two things going at once. That's not the one I want. Sorry about that. I'll pull the other one up in a minute. As the Gavel Drops is right there. Y'all, welcome as I want to share with you our fabulous partner in crime and sponsor, As the Gavel Drops. For those of you who love diving into documents and getting down into the nitty-gritty of court and knowing all the information before the trial actually occurs, please go to As the Gavel Drops in Discord. And y'all, you can't get any better than this. They have almost 500 cases that they are following at this moment in time. You can pick any case that we are covering or maybe not covering, and they will have the information you need. So, y'all, go to As the Gavel Drops and research to your heart's content. As the Gavel Drops, think I put your thing. Yep. Comment down below is where you can locate As the Gavel Drops in Discord. It really is cool. I mean, they have all the cases. They have mods that are following specific cases, so you can always know where to go to get your information. Also, we have a fabulous sponsor. I could not do this without them. Lord knows with my coffee, I mean, y'all, I couldn't stay awake. I got to have my Java and the Java. Hey, y'all, please help me welcome the Hitchman Homestead Coffee. They are fabulous. They have many different blends of freshly roasted, freshly ground coffee. They have a monthly club where you get 4 bags for $40 or a Keurig option. Also, they just came out with a half and half. Oh my gosh, I absolutely love it. So do me a favor. Go down to the link below at hitchmanhomestead.com. Order you some coffee and show them some love. Yeah, they are great, y'all. I am watching this hurricane. I've got 3 apps running. For those of you who don't know, I am a storm chaser. Tornadoes is mostly what we chase, but when we have hurricanes, those will be chased as well. But unfortunately, I'm not there because it's in Florida now. If this thing was hitting Texas, I'd be going, see y'all. We'd be doing remote. So Panama City, Appalachia, Tallahassee are already getting flooded in that little, here's Florida, in that little dip right there is absolutely getting flooded. I think they're going to bear the brunt of this storm, partially because we had the main hurricane and then you saw another one trying to form on the radar I showed you a second ago. It didn't really take full shape, but it did build up a little bit of energy. So the area, what we call the panhandle of Florida, is getting hammered, y'all, right now as we speak. So I believe the worst case scenario is really going to be up in the panhandle of Florida. So my friend Trexa, I am thinking about you. I am praying for you, y'all. Yes, hello, Brit. I actually have some photos of tornadoes. Although I'm seeing that I'm seeing the eye of the storm is following one model where it kind of curves in a little bit closer to Florida. It doesn't do that straight hook up this way. It's actually kind of doing this. So Tampa, uh, Bradenton, Sorosa, they're starting to get some really heavy bands of rain. But yeah, it's not going to be a good one. They never are. I kind of wish I was there. I'm a first responder. I did Red Cross for 15 years. I mean, I've just absolutely miss helping people. I did the disability integration work and shelter management. I am also looking, let me see what they say here. Judge to weigh in on the motion to dismiss the case against Rust Hannah Reed. The New Mexico judge is set to weigh whether to dismiss the case against Rust Armor Hannah Reed Gutierrez, who was convicted of, oh, I got somebody. Gotta go. I'll be right back. My apologies. Dang cool. So, what we're going to do is we're going to keep an eye on this storm. But yeah, y'all, I always get frustrated when people do not take shelter. So back to the Miss Hannah Gutierrez Reed situation. Let's see what they say. A New Mexico judge is convicted of involuntary manslaughter in the fatal shooting of the film cinematographer Helena Hutchins after dismissing the case against Alec Baldwin for evidence suppression. Oh, I'm so sorry, Toxic Orchid. And we are starting to come in. We do have.
So everybody out. Everybody good?
Yeah, stand with that.
Okay.
All rise.
Later. All rise.
Hear ye, hear ye, hear ye. This Honorable Division of Criminal Court 10. The 30th Judicial District of the State of Tennessee is now open for the transaction of business pursuant to adjournment. All persons having business with this court draw near, give attention, and ye shall be heard. The Honorable Judge Jennifer Johnson Mitchell presiding. You may be seated.
Good morning. Any business we need to take care of before we bring the jury in?
No, Your Honor.
So Evans, you'll be up first.
Yes, Your Honor.
You can bring in the jury.
Bring the jury, she said.
Ladies and gentlemen, before the jury comes in, I will start to read this jury charge very soon. There will be no movement during the charge. The door will be locked. Nobody will enter and nobody will exit. It's gonna take me about 15, 20 minutes to read this charge. So if you don't feel like you're gonna be able to sit still during this time frame, please exit now. Thank you.
Wow, she hasn't been doing that. They're locking the door? That's actually against fire code. What the heck are you thinking, madame? You can't lock the door. You can have an officer guard the door, but under fire code, you sure in the heck cannot lock the door. I don't know what you're thinking, honey child. Not trying to be rude. What you thinking? That's what I say about that.
Jury time enter into the courtroom, y'all.
French toast, pancakes, bacon, fresh strawberries, home fry. Ooh, yum. I know. That's what we get for thinking, isn't it? That's what we get for thinking.
Good morning.
Good morning.
I'm trustee candidate right now tonight.
Hello, Miss Ronnie.
Can I call your first witness?
Hey, lock the
Your
door.
Honor, the defense rests.
Ladies and gentlemen, we have heard
Shocker.
in this matter. What you have had in your seats, is a jury charge. This is my portion of this trial. It's the law. Now, the law states that I have to read it to you. Please don't think I am insulting your intelligence by reading to you. I know you can read for yourself, but the law states that I have to read it, and you all have to read it at the same time. Okay. That is your copy. Feel free to write on it. I have the official copy here that will go back.
Look how many pages that is.
To the jury room.
Oh, snap. This is going to take
I cannot
forever.
write on this copy, but feel free to make any notes that you'd like to make, and any changes that I have to make that I see that need to be made will be made on the official copy.
It's like 30 pages, y'all.
State of Tennessee versus Justin Johnson. Members of the jury. The evidence in this case has been completed, and it is now my duty to instruct you as to the law. After I instruct you as to the law, the state and the defense may present their closing arguments. The law applicable to this case is stated in these instructions, and it is your duty to carefully consider all of them. The order in which these instructions are given is no indication of their relative importance. You should not single out any one or more of them to the exclusion of another or others, but should consider each one in light of and in harmony with the others. Duties of the court and the jury. The law makes it the duty of the court to charge the jury the law relative to the case on trial, and the duty of the jury to carefully consider all of the evidence delivered to them in the trial and under the law given them by the court, render their verdicts with absolute impartiality. No sympathy or prejudice by the jury. You can have no prejudice or sympathy or allow anything but the law and the evidence to have any influence upon your verdicts. You must render your verdicts with absolute fairness and impartiality as you think justice and truth dictate. The indictment in this case is the formal written accusation charging the defendant with the crimes. It is not evidence against the defendant and does not create any inference of guilt. Statements and rulings of the court. At times during the trial, I have ruled upon the admissibility of evidence. You must not concern yourself with these rulings. Neither by such rulings, these instructions, nor any other remarks which I have made do I mean to indicate any opinion as to the facts or as to what your verdicts should be. Statements and arguments of counsel. Statements, arguments, and remarks of attorneys are intended to help you in understanding the evidence and applying the law, but they are not evidence. If any statements were made by the attorneys in this trial at any time that you believe are not supported by the evidence, you should disregard them. Along these lines, the opening and closing arguments of the attorneys are likewise not evidence. You must base your decision in this case on the evidence that was actually presented in this court, not on the statements of attorneys. Furthermore, the questions the lawyers ask the witnesses are not evidence. You should not think that something is true just because one of the lawyers asks questions that assume or suggest that it is true. Jury, judges of facts and law. You are the exclusive judges of the facts in this case. Also, you are the exclusive judges of the law under the direction of this court. You should apply the law to the facts in deciding this case. You should consider all of the evidence in light of your own observations and experiences in life. Presumption of innocence. The law presumes that the defendant is innocent of the charges against him. This presumption remains with the defendant throughout every stage of the trial and is not overcome unless all the evidence in the case you are convinced beyond a reasonable doubt that the defendant is guilty. Burden of proof. The state has the burden of proving the guilt of the defendant beyond a reasonable doubt, and this burden never shifts but remains on the state throughout the trial of the case. The defendant is not required to prove his innocence. The state must have proven beyond a reasonable doubt all of the elements of the crime charged and that it was committed before the finding and returning of the indictment in this case. Reasonable doubt. Reasonable doubt is that doubt engendered by an investigation of all the proof in the case and an inability after such investigation to let the mind rest easily as to the certainty of guilt. Absolute certainty of guilt is not demanded by the law to convict of any criminal charge, but moral certainty is required, and this certainty is required as to every element necessary to constitute the offense. Crimes charged and plea. The first count of the indictment charges the offense of conspiracy to commit first-degree murder. Embraced and included within the offense are the lesser included offenses: facilitation to wit, conspiracy to commit first-degree murder. The second count of the indictment charges the offense of first-degree murder. Embraced and included within the offense are the lesser included offenses of second-degree murder, facilitation to wit, first-degree murder, facilitation to wit, second-degree murder, voluntary manslaughter, aggravated assault, facilitation to wit, voluntary manslaughter, facilitation to wit, aggravated assault, simple assault, facilitation to wit, simple assault. The third count of the indictment charges the offense convicted felon in possession of a firearm. The court will now explain to you the law applicable to count 1 in this indictment. Conspiracy to commit first-degree murder. Any person who conspires to commit an offense is guilty of a crime. For you to find the defendant guilty of conspiracy to commit first-degree murder, the state must have proven beyond a reasonable doubt the existence of the following essential elements: that the defendant entered into an agreement with one or more people to commit the offense of first-degree murder. It is not necessary that the object of the agreement be attained, and that each of the parties to the conspiracy had the intent to commit the offense of first-degree murder, and that each party acting for the purpose of promoting or facilitating the commission of the offense of first-degree murder agreed that one or more of them would engage in conduct which constitutes the offense of first-degree murder, and that one of the parties to the conspiracy committed an overt act in furtherance of the conspiracy. An overt act is an act done by one of the parties to carry out the intent of the conspiracy, and it must be a step toward the execution of this conspiracy. Intent means that a person acts intentionally when it is the person's conscious objective or desire to cause the death of the alleged victim. Conspiracy is a continuing course of conduct which terminates when the objectives of the conspiracy are completed, or the agreement that they be completed is abandoned by the person and by those with whom the person conspires. The objectives of the conspiracy include, but are not limited to, escape from the offense, distribution of the proceeds of the offense, and measures other than silence for concealing the crime or obstructing justice in relation to it. Abandonment of a conspiracy is presumed if neither the person nor anyone with whom the person conspired does any overt act in pursuance of the conspiracy during the applicable period of limitation. If an individual abandons the agreement, the conspiracy is terminated as to that person only if and when the person advises those with whom the person conspired of the abandonment, or the person informs law enforcement authorities of the existence of the conspiracy and of the person's participation therein. However, mere presence is not sufficient to support a conviction. Facilitation to wit, conspiracy to commit first-degree murder. Any person who commits the offense of facilitation to wit, conspiracy to commit first-degree murder is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements: that the defendant knew that another person intended to commit the specific offense of conspiracy to commit first-degree murder, but did not have the intent to promote or assist the commission of the offense, or to benefit in the proceeds or results of the offense, and that the defendant furnished substantial assistance to that person in the commission of the conspiracy,
that was a look.
And that the defendant furnished such assistance knowingly. Conspiracy to commit first-degree murder has been defined on page 4. Knowingly means that a person acts knowingly with respect to the conduct or to circumstances surrounding the conduct when the person is aware of the nature of the conduct or the circumstances, or that the circumstances exist. A person acts knowingly with respect to a result of the person's conduct when the person is aware that the conduct is reasonably certain to cause the result. The requirement of knowingly is also established if it is shown that the defendant acted intentionally.
Ronnie, no, they will not be in the same prison. If they have to be for any reason, they will be housed in different units, but they will do their best to separate them.
Or desire to engage in the conduct or cause the result. The court will now explain to you the law applicable in count 2 in this indictment. First-degree murder. Any person who commits the offense of first-degree murder is guilty of a crime. For you to find a defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements: that the defendant unlawfully killed the alleged victim, Adolph Thornton Jr., and the defendant acted intentionally. A person acts intentionally when it is the person's conscious objective or desire to cause the death of the alleged victim, Adolph Thornton Jr., and that the killing was premeditated. A premeditated act is one done after the exercise of reflection and judgment. Premeditation means that the intent to kill must have been formed prior to the act itself. It is not necessary that the purpose to kill pre-exists in the mind of the accused for any definite period of time. The mental state of the accused at the time he allegedly decided to kill must be carefully considered in order to determine whether the accused was sufficiently free from excitement and passion as to be capable of premeditation. If the design to kill was formed with premeditation, it is immaterial that the accused may have been in a state of passion or excitement when the design was carried into effect. Furthermore, premeditation can be found if the decision to kill is first formed during the heat of passion, but the accused commits the act after the passion has subsided. Second-degree murder. Any person who commits second-degree murder is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements: that the defendant unlawfully killed the alleged victim, Adolph Thornton Jr., and that the defendant acted knowingly. Knowingly means a person acts with an awareness that his conduct is reasonably certain to cause the death of the alleged victim. The requirement of knowingly is also established if it is shown that the defendant acted intentionally. Intentionally means that a person acts intentionally when it is the person's conscious objective or desire to cause the death of the alleged victim. The distinction between voluntary manslaughter and second-degree murder is that voluntary manslaughter requires that the killing result from a state of passion produced by adequate provocation from the alleged victim sufficient to lead a reasonable person to act in an irrational manner. Facilitation to wit first-degree murder. Any person who commits the offense of facilitation to wit first-degree murder is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements: that the defendant knew that another person intended to commit the specific offense of first-degree murder, but did not have the intent to promote or assist the commission of the offense or to benefit in the proceeds or results of the offense. And that the defendant furnished substantial assistance to that person in the commission of the first-degree murder, and that the defendant furnished such assistance knowingly. First-degree murder has been defined on page 8. Knowingly means that a person acts knowingly with respect to the conduct or to the circumstances surrounding the conduct when the person is aware of the nature of the conduct or that the circumstances exist. A person acts knowingly with respect to a result of the person's conduct when the person is aware that the conduct is reasonably certain to cause the result. The requirement of knowingly is also established if it is shown that the defendant acted intentionally. Intent means that a person acts intentionally with respect to the nature of the conduct or to a result of the conduct when it is the person's conscious objective or desire to engage in the conduct or cause the result. Facilitation to wit second-degree murder. Any person who commits the offense of facilitation to wit second-degree murder is guilty of a crime. For you to find a defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements: that the defendant knew that another person intended to commit the specific offense of second-degree murder, but did not have the intent to promote or assist the commission of the offense or to benefit from the proceeds or results of the offense. And that the defendant furnished substantial assistance to that person in the commission of the second-degree murder, and that the defendant furnished such assistance knowingly. Second-degree murder has been defined on page 9. Knowingly means that the person acts knowingly with respect to the conduct or to circumstances surrounding the conduct when the person is aware of the nature of the conduct or that the circumstances exist. A person acts knowingly with respect to a result of the person's conduct when the person is aware that the conduct is reasonably certain to cause the result. The requirement of knowingly is also established if it is shown that the defendant acted intentionally. Intent means that a person acts intentionally with respect to the nature of the conduct or to a result of the conduct when it is the person's conscious objective or desire to engage in the conduct or cause the result. Voluntary manslaughter. Any person who commits voluntary manslaughter is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements: that the defendant unlawfully killed the alleged victim, Adolph Thornton Jr., and that the defendant acted intentionally or knowingly, and that the killing resulted from a state of passion produced by adequate provocation from the alleged victim, sufficient to lead a reasonable person to act in an irrational manner. Passion means any of the human emotions known as anger, rage, sudden resentment, terror, or similar emotions, which renders the mind incapable of cool reflection. Knowingly means that a person acts with an awareness that his conduct is reasonably certain to cause the death of the alleged victim. The requirement of knowingly is also established if it is shown that the defendant acted intentionally. Intentionally means that a person acts intentionally when it is the person's conscious objective or desire to cause the death of the alleged victim. The distinction between voluntary manslaughter and second-degree murder is that voluntary manslaughter requires that the killing result from a state of passion produced by adequate provocation from the alleged victim sufficient to lead a reasonable person to act in an irrational manner. Aggravated assault. Any person who commits the offense of aggravated assault is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements: that the defendant intentionally or knowingly caused bodily injury to another, and that the act resulted in the death of another. Bodily injury includes a cut, abrasion, bruise, burn, or disfigurement, and physical pain or temporary illness or impairment of the function of a bodily member, organ, or mental faculty. Knowingly means that a person acts knowingly with respect to the conduct or to circumstances surrounding the conduct when the person is aware of the nature of the conduct or that circumstances exist. A person acts knowingly with respect to a result of the person's conduct when the person is aware that the conduct is reasonably certain to cause the result. The requirement of knowingly is also established if it is shown that the defendant acted intentionally. Intentionally means that a person acts intentionally with respect to the nature of the conduct or to a result of the conduct.
Get out of
when
the
it is
car
person's
with a lead
conscious
shooter
objective
and
or
empty the
desire to
clip.
engage in the
That's
conduct
intentional.
or cause the result.
That's like
Facilitation to
totally
voluntary
intentional.
manslaughter. Any person who commits the offense of facilitation to wit, voluntary manslaughter, is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements: that the defendant knew that another person intended to commit the specific offense of voluntary manslaughter, but did not have the intent to promote or assist the commission of the offense or to benefit in the proceeds or results of the offense, and that the defendant furnished substantial assistance to that person in the commission of the voluntary manslaughter, and that the defendant furnished each such assistance knowingly. Voluntary manslaughter has been defined on page 13. Knowingly means that a person acts knowingly with respect to the conduct or to circumstances surrounding the conduct when the person is aware of the nature of the conduct or that the circumstances exist. A person acts knowingly with respect to a result of the person's conduct when the person is aware that the conduct is reasonably certain to cause the result. The requirement of knowingly is also established if it is shown that the defendant acted intentionally. Intent means that a person acts intentionally with respect to the nature of the conduct or to a result of the conduct when it is the person's conscious objective or desire to engage in the conduct or cause the result. Any person who, facilitation to wit aggravated assault. Any person who commits the offense of facilitation to wit aggravated assault is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt.
Morning, Mary
the following
Kay. How are
elements.
you,
That the
beloved?
defendant knew that another person intended
Sorry, I had to
commit
adjust my
the specific
hearing
offense
aid
of
and
aggravated assault, but did not have the intent to promote or assist the commission of the offense or to benefit in the proceeds or results of the offense. And that the defendant furnished substantial assistance to that person in the commission of the aggravated assault. And that the defendant furnished such assistance knowingly. Aggravated assault has been defined on page 14. Knowingly means that a person acts knowingly with respect to the conduct or to circumstances surrounding the conduct when the person is aware of the nature of the conduct or that the circumstances exist. A person acts knowingly with respect to a result of the person's conduct when the person is aware that the conduct is reasonably certain to cause the result. The requirement of knowingly is also established if it is shown that the defendant acted intentionally. Intent means that a person acts intentionally with respect to the nature of the conduct or to a result of the conduct when it is the person's conscious objective or desire to engage in the conduct or cause the result. Simple assault. Any person who commits a simple assault upon another is guilty of a crime. For you to find a defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements: that the defendant caused bodily injury to another, and that the defendant acted either intentionally, knowingly, or recklessly. Facilitation to wit simple assault. Any person who commits the offense of facilitation to wit simple assault is guilty of a crime. For you to find a defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements: that the defendant knew that another person intended to commit the specific offense of simple assault, but did not
Yes,
have
it
the
is
intent to
definitely
promote or
premeditated.
assist the commission of the offense or to benefit in the proceeds or results.
There's not much to
results of
catch
the
up on. They're
offense.
just reading
And that the
the
defendant
indictment
furnished substantial
and judge's
assistance to
instruction.
that person in the commission of
Jury
the simple assault. And that the defendant furnished such assistance knowingly. Simple assault has been defined on page 18. Knowingly means that a person acts knowingly with respect to the conduct or to the circumstances surrounding the conduct when the person is aware of the nature of the conduct or that the circumstances exist. A person acts knowingly with respect to a result of the person's conduct when the person is aware that the conduct is reasonably certain to cause the result. The requirement of knowingly is also established if it is shown that the defendant acted intentionally. Intent means that a person acts intentionally with respect to the nature of the conduct or to a result of the conduct when it is the person's conscious objective or desire to engage in the conduct or cause the result. The court will now explain to you the law applicable to count 3 in this indictment. Convicted felon in possession of a firearm. Any person having been convicted of one of certain specific felonies who possesses a firearm is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements.
Are you kidding?
That the defendant
He is
had been
definitely
convicted
guilty
of
of
a specified
possession.
felony,
Y'all,
and that
we
the
saw
defendant,
it.
after such felony conviction,
We
possessed a
saw
firearm,
the
and that the
firearm,
defendant acted either
y'all.
intentionally, knowingly, or recklessly. Firearm means any weapon that will or is designed to or may readily be converted to expel a projectile by the action of an explosive. Intentionally means that a person acts intentionally with respect to the nature of the conduct or to a result of the conduct when it is the person's conscious objective or desire to engage in the conduct or cause the result. Knowingly means that a person acts knowingly with respect to the conduct or to circumstances surrounding the conduct when the person is aware of the nature of the conduct or that the circumstances exist. A person acts knowingly with respect to a result of the person's conduct when the person is aware that the conduct is reasonably certain to cause the result. Recklessly means that a person acts recklessly with respect to circumstances surrounding the conduct or the result of the conduct when the person is aware of but consciously disregards a substantial and unjustifiable risk that the circumstances exist or the results will occur. The risk must be of such a nature and degree that its disregard constitutes a gross deviation from the standard of care that an ordinary person would exercise under all the circumstances as viewed from the accused person's standpoint. If you find from the proof that the defendant has been convicted of another crime or crimes than that for which he is presently on trial, you may not consider such evidence as proof of his disposition to commit the crime for which he is on trial. The defendant has pled not guilty to each and every offense charged and included in the indictment. Direct and circumstantial evidence. One type of evidence is called direct evidence and the other type is called circumstantial evidence. Direct evidence is those parts of the testimony admitted in court which refer to what happened and was testified to by witnesses who saw or heard or otherwise sensed what happened firsthand. If witnesses testified about what they themselves saw or heard or otherwise sensed, they presented direct evidence. Circumstantial evidence is all the testimony and exhibits which give you clues about what happened in an indirect way. It consists of all the evidence which is not direct evidence. Do not assume that direct evidence is always better than circumstantial evidence. According to our laws, direct evidence is not necessarily better than circumstantial evidence. Either type of evidence can prove a fact if it is convincing enough. A defendant may be convicted on direct evidence, circumstantial evidence, or both. Accomplice. The prosecution has presented a witness who claims to have been a participant with the defendant in the crime charged. While you may convict upon this testimony alone, you should act upon it with great caution. Give it careful examination in light of other evidence in the case. You are not to convict upon this testimony alone unless you are convinced beyond a reasonable doubt that it is true. Credibility of witnesses. You are the exclusive judges of the credibility of the witnesses and the weight to be given to their testimony. You should consider all the evidence presented in this case by the state and by the defendant and give it full, fair, and impartial consideration. Part of your responsibility is to determine what the facts are based on what you heard from the witnesses. If there are conflicts in the testimony of different witnesses, it is your duty to reconcile them if you can, for the law presumes that every witness has told the truth. But when you cannot reconcile the statements of different witnesses, then you must decide which witness or witnesses you believe and how important his or her testimony was. You do not have to accept or reject everything a witness said. You are free to believe all, none, or part of any person's testimony. In forming your opinion as to which witness you believe, you may consider the following factors: how the witness looked, acted, and whether the witness appeared to you to be telling the truth when he or she testified. Was the witness able to see or hear clearly? How long was the witness watching or listening? Was anything else going on that might have distracted the witness? Whether the witness was in a position to know about the matter to which he or she testified. In other words, how well could the witness see or hear what he or she testified he or she saw or heard? Whether the witness's statements were consistent and how believable the statements were. Whether the witness had a motive to testify truthfully or to testify untruthfully. And any proof presented of the witness's reputation for telling the truth. All in all, how reasonable does the witness's testimony seem when you think about all the other evidence in the case? Another factor for you to consider in evaluating a witness's testimony is whether the witness has made material statements at some point before he or she testified, which are different from his or her testimony at trial. However, unless entered as a numbered exhibit by the court and allowed to be taken by you back to the jury room when you deliberate, proof of any prior different statement may be considered by you only for the purpose of determining if the witness is telling the truth at trial. The contents of the prior inconsistent statement are not to be considered as proof in the trial. Another factor for you to consider in evaluating a witness's testimony is whether the witness's testimony during cross-examination appeared to be contradictory, unreasonable, and improbable. However, immaterial or minor discrepancies or differences should not affect the believability of a witness unless it should plainly appear that the witness has willfully testified falsely. Criminal responsibility for conduct of another. The defendant is criminally responsible as a party to the offense of first-degree murder if the offense was committed by the defendant's own conduct, by the conduct of another for which the defendant is criminally responsible, or by both. Each party to the offense may be charged with the commission of the offense. The defendant is criminally responsible for an offense committed by the conduct of another if, acting with the intent to promote or assist the commission of the offense, or to benefit in the proceeds or results of the offense, the defendant solicits, directs, aids, or attempts to aid another person to commit the offense. Intent means that the person acts intentionally with respect to the nature of the conduct or to the results of the conduct when it is the person's conscious objective or desire to engage in the conduct or cause the result. To find a defendant criminally responsible for the acts of another, it is not necessary that you find the defendant was present or that the defendant took a physical part in the crime. Encouragement of the principal offender is sufficient. However, mere presence during the commission of the offense is not sufficient to support a conviction. Absent material witness. When it is within the power of the state or the defendant to produce a witness who possesses peculiar knowledge concerning facts essential to that party's contention and who is available to one side at the exclusion of the other, and the party to whom the witness is available fails to call such witness, an inference arises that the testimony of such witness would have been unfavorable to the side that should have called or produced such witness. Whether there was such a witness, whether such an inference has arisen is for you to decide, and if so, you are to determine what weight it shall be given. This inference does not apply to the defendant because he has a lawful right not to testify, and his failure to testify cannot be considered for any purpose against him, nor can any inference be drawn from such facts. Defendant not testifying. The defendant has not taken the stand to testify as a witness, but you shall place no significance on this fact. The defendant is presumed innocent, and the burden is on the state to prove his guilt beyond a reasonable doubt. He is not required to take the stand in his own behalf, and his election not to do so cannot be considered for any purpose against him, nor can any inference be drawn from such fact. Stipulations. A stipulation is an agreement between the parties. The parties have stipulated that certain matters of fact are true. They are bound by this agreement, and in your consideration of the evidence, you are to treat these facts as proved. The parties have entered into two stipulations. The parties have stipulated that Adolph Thornton Jr. was a living person who is now deceased, and an autopsy was performed to substantiate these facts. The parties have also stipulated to the fact that the defendant, Justin Johnson, is a convicted felon, previously convicted on May 2nd of 2017 in Division 8 of the Criminal Court of Shelby County. Flight. The flight of a person accused of a crime is a circumstance which, when considered with all the facts of the case, may justify an inference of guilt. Flight is the voluntary withdrawal of oneself for the purpose of evading arrest or prosecution for the crime charged. Whether the evidence presented proves beyond a reasonable doubt that the defendant fled is a question for your determination. The law makes no precise distinction as to the manner or method of flight. It may be open, or it may be hurried or concealed departure, or it may be a concealment within the jurisdiction. However, it takes both a leaving the scene of the difficulty and a subsequent hiding out, evasion, or concealment in the community or leaving of the community or parts unknown to constitute flight. If flight is proved, the fact of flight alone does not allow you to find that the defendant is guilty of the crime alleged. However, since flight by a defendant may be caused by a consciousness of guilt, you may consider the facts of flight. If flight is so proven, together with all the other evidence when you decide the guilt or innocence of a defendant. On the other hand, an entirely innocent person may take flight, and such flight may be explained by proof offered or by facts and circumstances of the case. Whether there was flight by the defendant, the reasons for it, and the weight to be given to it are questions for you to determine. Multiple counts, finding of each required. The crime charged in each count of the indictment is a separate and distinct offense. You must decide each charge separately on the evidence and the law applicable to it. The defendant may be found guilty or not guilty of any or all of the offenses charged. Your finding as to each crime charged must be stated in your verdict. Jury deliberation and unanimous verdict. The verdicts must represent the considered judgment of each juror. In order to return a verdict, it is necessary that each juror agree thereto. Your verdicts must be unanimous. It is your duty as jurors to consult with one another and to deliberate with a view to reaching an agreement if you can do so without violence to individual judgment. Each of you must decide the case for yourself, but do so only after an impartial consideration of the evidence with your fellow jurors. In the course of your deliberations, do not hesitate to re-examine your own views and change your opinion if convinced it is erroneous. But do not surrender your honest conviction as to the weight or effect of the evidence solely because of the opinion of your fellow jurors or for the mere purpose of returning a verdict. Notes. If you have been taking notes in this case, these notes are for your individual use only, and you should not use your notes directly or indirectly, explicitly or implicitly to persuade other jurors as to the accuracy of your notes. They should not be shown to others, nor compared, nor referred to in any way as authority, but should be used privately only by you as an aid to your individual memory. Deliberation, order of consideration. In reaching your verdict, you should first consider the offense charged in the indictment. If you unanimously find the defendant guilty of that offense beyond a reasonable doubt, you shall return a verdict of guilty for that offense. If you unanimously find the defendant not guilty of that offense or have a reasonable doubt of the defendant's guilt of that offense, you shall then proceed to consider whether or not the defendant is guilty of the next lesser included offense in order from greatest to least within that count. You shall not proceed to consider any lesser included offense until you have first made a unanimous determination that the defendant is not guilty of the immediately preceding greater offense, or you unanimously have a reasonable doubt of the defendant's guilt of that offense. If you have a reasonable doubt of the guilt of the defendant as to all offenses charged and included in that count, you shall return a verdict of not guilty and proceed to the next count. That is the law, ladies and gentlemen. We will now proceed with closing arguments.
Good morning.
Good morning.
So it's almost over, and I'm sure you all are happy. My name is Iris Williams. I'm one of the prosecutors on on this case. And earlier this week, you heard opening statements. You heard opening statements from prosecution and from the defense attorney. And you were told all the things that you could expect this week. And one of those important things that you could expect was that it is not 1981 anymore, and that things have changed. But what does that mean? It means that it's hard to keep a secret. It's hard to hide who you're talking to. It's harder to hide your actions. And it's even harder to hide who you know. But ladies and gentlemen, despite all of those things that have changed, one thing has not changed, and that is the state's burden. The state's burden of proof is beyond a reasonable doubt. So what does that mean? Where are we? So the defendant, Justin Johnson, is charged with 3 counts: conspiracy to commit first-degree murder, and convicted felon in possession of a firearm. So I know that you've already gone through a little bit of this law during voir dire, and especially through the jury instructions. But a brief overview of conspiracy to commit first-degree murder is that 1, this defendant entered into an agreement with 1 or more people to commit first-degree murder. 2, each of the parties to the conspiracy had the intent to commit the first-degree murder. 3, each party acted for the purpose of promoting or facilitating the first-degree murder. And 4, 1 or more of the parties committed an overt act to help the crime happen. So what did we hear this week? This week we heard testimony from co-defendant Cornelius Smith. He testified for us and he told us that he met Justin Johnson through Hernandez Govan, and that he knew Justin was a rapper, and he was also known by the name of Straight Drop. So Smith had known the defendant for a couple of months, and they hung out a couple of times before the murder. He was able to identify defendant in open court, and during his testimony, Smith told us that on November 17, 2021, he and the defendant knew that Big Jook had a $100,000 hit on Dolph's head. Cornelius said that he and Justin agreed to kill Dolph together, and both of them receiving $40,000 apiece. Not only did he tell us that, he told us that this plan had been in process for weeks, and that Justin knew about it. And there were conversations previously or prior to this murder, and Justin Johnson was an active participant in those agreements. So there we have it, a conspiracy to commit first-degree murder. An agreement was made. Each of the parties had the intent to commit the first-degree murder. Each person acted for the purposes of promoting, facilitating, and, ladies and gentlemen, the overt act is the killing. Next, first-degree murder. In essence, a first-degree murder is a premeditated killing of another. What's required for first-degree murder is 1, that the defendant unlawfully killed the victim. The only way to lawfully kill someone is if you are in protection of yourself or others. Second, you have to prove that this defendant acted intentionally. Intentionally means that there was no mistake, there was no accident. Third, you have to prove that the killing was premeditated. And as we saw, or as we learned in voir dire last week, premeditation does not mean that you had to have this plan for months, weeks, or days in advance. It could just mean that you simply stepped out of your car, you held up your hand, you pointed a gun, and you shot and killed somebody. As long as you had a moment to think about what you were doing, that's premeditation. Next, so we heard from a couple of people this week. First, we heard from the victim's sister, Erica Thornton. She testified that the victim was a living person. He had a family, he had children. She's known him her entire life. She attended and planned his funeral service. And coupled with that, defense counsel and the prosecution agreed to a stipulation, which just means that they agreed to establish that this victim was a living person who was now deceased. Later on, we heard from Dr. Scantleberry. She was the medical examiner and performed the autopsy. she found that there was a total of 22 gunshot entry wounds, including gunshots to the back torso, front torso, head, neck, upper extremities, and vital organs. She also testified that on the property that was collected from the victim, there was no weapon. And we also heard from Raul Hawkins. He testified that he was head of Dolph security for years. He was able to identify Dolph's car in the beginning of the Makitas video, and he was also able to explain the difference between CMG and PRE, their history of conflict, rivalry, diss tracks, and even prior acts of violence that were towards Dolph. So with all of this testimony, we've established that there was a killing and that the victim was Adolph Thornton Jr. But was that killing unlawful? Was that killing premeditated? And was that killing intentional? Back to Cornelius Smith. In addition to testifying about the agreement that he and the defendant entered into, he also testified about the killing. He said that on the day of the murder, the defendant picked him up from his father's house. They both knew that the victim was doing a turkey drive with several of his PRE artists. They also knew that Big Jook had a hit out on all of the PRE artists. So it was their job that week to find them. And on November 17th, 2021, Cornelius Smith and Justin Johnson were on their way to a turkey drive in Westwood. As they were about to turn the corner, they saw a familiar car cross the intersection, which happened to be Dolph's car. Cornelius tells us that they followed the car, made a loop onto a back street, and then entered the Makitas parking lot. And this happened, I want to say, about
Honey,
30
I
seconds
was
after
just celebrating myself
Dolph
over the
and his
frame
brother
around my
arrived at
picture.
Makitas. Cornelius Smith
Shouldn't
was
be
able to
interrupting.
point out himself in that video and the defendant in that video. And he said that both of them were the shooting suspects in that video. The second suspect that got out of the car was wearing a black hoodie, gray pants, black shoes with white soles, and a Bass Pro hat. The same clothing that defendant Justin Johnson was seen in as he was exiting his apartments at the Crosstown Concourse. After the shooting, Cornelius Smith testified that they got into the white Mercedes that they committed the act in. They went to Bradley Street. The defendant parked the white Mercedes on the yard, and they both got into a white Ford Expedition. They both got into that Expedition, and on the way, a couple of calls were made, right? Cornelius tells us that a FaceTime call was made to Big Jook. In that FaceTime call between Big Jook and our defendant spelled out the word Dolph. And as they were on their way to the Gospel Gardens apartment, the defendant also contacted a few other people who we'll find out later on. So once the defendant and Cornelius Johnson arrived at Gospel Gardens, they received wound care. They change their clothes, and then they go their separate ways. After they go their separate ways, Cornelius Smith tells us that he went to retrieve his phone, and he went to go wipe down the car, the white Mercedes that was parked at Bradley. So with Cornelius Smith's testimony, we have established that the killing was unlawful. There was no evidence to show that this defendant was in fear, was protecting himself, or was protecting someone else. We also established that it was intentional. It's not an accident. You didn't mistakenly follow someone's car into Makita's parking lot and then shoot them. We also established that it was premeditated. They knew about this hit beforehand, and they committed this hit. So if that wasn't enough for you, we heard from some other people. We heard from Kirsten Gardner. He testified that he was present during the time that the defendant was able to get possession of the white Mercedes that the act was committed in. Kirsten Gardner was at the Valero gas station in the early hours of November 17th, 2021. Next, well, actually, let me go back to Kirsten Gardner. After he testified that, he told us that he didn't know anything about what was happening the next day, or a few hours after the cars were switched. Similarly, Jamarcus Johnson didn't know anything either. He just knew that he needed a ride. And his brother, Justin Johnson, could provide that for him. So he got his car, the rental car, and he took his cell phone, he fielded his calls, posted on his social media, and checked his emails. After Jamarcus Johnson, we heard from Sergeant Dabney. He was able to tell us about the 4 different bullet casings that were present at the murder scene. .40 caliber, attributable to a handgun. .762, attributable to an assault rifle that Cornelius Smith had. .223, attributable to a semi-automatic that Marcus Thornton probably would have had. And a 9mm casings found inside the store, which could be attributable to the handgun that Marcus Thornton had inside the store. That first one, though, the .40 caliber attributable to a handgun, was in the hand of the suspect with the Bass Pro hat. So, Sergeant Dabney also recovered the surveillance footage from Nikita's and Gospel Gardens, showing this suspect in the same clothing that the defendant was in as he was leaving his apartment at 10:49 a.m. that morning. The timestamps on Gospel Garden and Nikita's coincide with the times defendant's phone accessed those towers. We heard from Special Agent Garner, who summarized that the defendant's phone accessed a tower that provided coverage to the Valero gas station at 3:17 a.m. Around the same time that Kirsten Gardner said that he saw the defendant take possession of that white Mercedes at the Valero gas station. The defendant's phone also accessed towers that provided coverage for the area of 2370 Airways Boulevard, which is our murder scene. And it accessed those towers during the times of the murder, 12:22 p.m. to 12:23 p.m. on November 17th. Officer Garner also explained that the defendant's phone accessed a tower in the area of the 2-lane road and Shelby Drive from 1 p.m. to 1:59 p.m., which is the direct correlation to the surveillance footage of Gospel Gardens and the footage that Officer Sergeant Dabney identified the defendant being present for. So next, if all of that wasn't enough, we heard testimony from Sergeant Browning. Sergeant Browning said that this defendant's device placed an outgoing call to Anthony Mims at 12:25:40 p.m. on November 17, 2021. Not only did he place an outgoing call to Big Jook, he also received a text from Akiana Hooper, who is his cousin. She texted him an address of 4752 Haven Court. After he received that address, he then sent that address to an associate named Jermaine Sears. Jermaine Sears, or defendant's device, sends outgoing text to Jermaine Sears that he needs him. And you'll see in the surveillance footage of Haven Court on that day, at that time, a car that is associated with Jermaine Sears arrived shortly after the defendant arrives in a white Ford Expedition. So the next thing, convicted felon in possession of a firearm. The 3 things that we have to prove beyond a reasonable doubt is that 1, this defendant was a convicted felon or convicted of a specified felony. And 2, after being convicted of a felony, this defendant possessed a firearm. And 3, this defendant acted intentionally, knowingly, or recklessly. So the facts that we have for this charge. Well, 1, there was a stipulation or an agreement. The parties have stipulated that defendant Justin Johnson was convicted of the felony on May 2nd, 2017 in Criminal Court 8 in Shelby County, Tennessee. Next, we heard testimony from Cornelia Smith, who verified that the person in that Bass Pro hat was Justin Johnson, and that person held a gun. So based on all of that, we can see that we have met our burden of proof for convicted felon in possession of a firearm. Next, let's just talk about reasonable doubt for one last second. Reasonable doubt, it is not 100% certainty. It is not beyond a shadow of a doubt. It is not beyond all doubt. What's required is moral certainty. Certainty that allows you to sleep well at night. Will you be able to rest easy knowing the decision that you've made? My instinct says yes. And once you've had time to deliberate, I think yours will too. So that brings us to the end. The state has met its burden of proof beyond a reasonable doubt. You have all the evidence, all of the testimony, all of the stipulations, all the videos, all the photographs. And now it's time for you to consider that evidence and apply your common sense. And after you do that, I think, well, actually, I expect that you will find this defendant guilty on all charges. Thank you.
Thank you, Ms.
I
Wilson.
think she did a great job.
Thank you, Judge.
That was a very precise, clear, no fluff. This is the fact. Boom, we're done. And let's see how he does. I'm getting a mild headache.
It's good to see y'all again.
I'm here. I'm just going to eat.
This is the last time you're going to have to hear from me. And as I see all of your faces, I know that's something you're looking forward to. And that's okay. I know that you all want to get back to your lives. And I can tell you on behalf of Mr. Johnson that your attention during this trial is greatly appreciated. What you've had to set aside in order to provide this service, I have no doubt that the court and Mr. Hagerman, Ms. Iris, all of us agree you're indebted to you for that. Because like I said in opening, this is important. And you're about to have to roll up your sleeves and go to work. And it's going to be a difficult job. This young man's fate is in your hands. The concept of justice, right? We talked about that in Fort Dyer. We talked about that again in opening, right? And it's in your hands. Meting out justice. And it's difficult because what you've heard is the tragedy of someone losing their life, of their family members not having that person in their life. And that is terrible. And the court will tell you, as terrible as that is, you can't consider that when you're determining guilt or innocence in this case. But it's heavy. And on the other hand, you have Mr. Johnson. This young man that you heard in the evidence is a young man, aspiring rapper. Wanted to make it as a rap artist. When you're going back through these exhibits, you're going to see a picture of him in front of the house on Bradley. You know, engaged in a music video, right, for his rap. Hat kicked to the side, kind of grin on his face. Because that's what he wanted to do. And his fate is directly in your hands. And like we talked about, it's never justice to wrongfully convict someone. And so that determination that you're going to make beyond a reasonable doubt is the heaviest one. Maybe one of the heaviest decisions you'll ever make. And you've had an opportunity to sit through the trial and hear the evidence, observe the witnesses, and you've been told, keep an open mind. And I hope you have. I'm sure you have. And not to talk about the case. You know, the thing that you've been listening to for days, with people all around you that have going through the same thing, and then you have to be around them even when you're not here, and you can't talk about the elephant in the room. But today that changes. And not only are you allowed to talk about it, the judge has instructed you that you have to talk about it. And to engage in deliberations meaningfully, to listen to one another, to review the evidence that you've heard, to talk about it, and render a decision. But to the degree you're working together, what you never have to do is abandon your conscience. Now, I don't mean conscience like Cornelius Smith, that conscience, right? Because I don't think he really meant that when he heard from him. He said, oh, the reason I decided to tell the truth is I got a conscience. And we all know that's not the type of thing you're dealing with. You take that more seriously. You mean it. He did. You've heard a lot of concepts, you know, the terms of art and the law, the burden of proof, presumption of innocence. And when we started this, I told you, Mr. Johnson sits before you innocent. And I'm again telling you today, after the state has closed its proof, he remains that way. He didn't kill Adolph Thornton Jr. He didn't conspire to kill Adolph Thornton Jr. And he wasn't the man holding the pistol in the Makita video. And it's going to be up to you to decide that, to watch those videos. Watch them closely. They want to talk about those videos, and I'm encouraging you to study them. Give them a close look. The state doesn't want to acknowledge what I told you in opening, and that is similar. It doesn't mean the same. Plenty of people have gray sweatpants, black shoes with white soles, black hoodies. And as we learned through the proof, in Memphis especially, and elsewhere, Bass Pro has. You can look at it, if we had a window, you could look at it and you could see the Bass Pro, which is the pyramid here. You also heard testimony about it being a fad
same walk.
at that point in time. Famous rappers wearing it. Other famous artists. I think I mentioned Gwen Stefani wearing Bass Pro. One rapper has a signature Bass Pro hat. You heard from one of the detectives that they even interviewed someone who gave them a potential suspect that wasn't Mr. Johnson, and said that person always wore a Bass Pro hat. And you have to consider that. And then you have Sergeant Dabney, who, for the first time, and I think he acknowledged this, sitting on the stand, says, I think those underwear are the same. They're both blue. You look at the underwear from Tulane Apartments, you look back at the Makita video, those are the same underwear. Look at it. Look at the steel shots. And for yourself, determine, can you tell if those are the same? And as jurors, you get to make that call. You get to look at it for yourself and compare those. We've heard a lot about it's not 1981 anymore. And I agree, right? You know, we've got cameras, but like I told you in opening, what also has advanced tremendously since 1981 is the world of forensics, right? Fingerprints, DNA, touch DNA. And you have to ask yourself, why is Justin Johnson's DNA nowhere in that car? There's DNA in that car. You heard a lot about they wiped it. Cornelius Smith said he wiped it. And we'll get to whether you believe that or not in a minute, okay? But he says he wiped it. But he didn't. There's fingerprints on it. Kristen Garner's, Trayon Ingram's, and Cornelius Smith. There was DNA found. One of it coming back to Trayon Ingram, right? Not Justin Johnson. Now, there's a lot of talk about gloves, right? They made a big point to say, you see gloves in the video. Now, they want you to believe that Mr. Johnson's running around in this Mercedes, and the reason that his prints aren't on it are because he's wearing gloves. And mind you, Cornelius Smith, when he said he wiped the car, never said he wiped the driver's side of the car. Okay? If you believe that. And they want you to believe Mr. Johnson's driving around this white Mercedes, including with his daughter. Look at those videos. You think he's not wearing gloves. And he's got a little girl in tow that would presumably be in that car with him. No DNA recovered. None. Now, during proof, it was interesting because they would show the Mercedes go into crosstown and the Mercedes leave crosstown, and they would show a video of Mr. Johnson getting out and walking in the building or walking out of the building. There is no video that shows Mr. Johnson in that Mercedes. And you heard they had a reel, right? The video was a reel when they're doing crosstown. And when I asked it, I think it was Detective or Sergeant Dabney, about there was surely other cars going in and out at this very time. And he said, yeah. But you have to ask yourself, was Justin Johnson ever in that Mercedes? So let's go to Kristen Garner. Kristen Garner gets up here and tries to tell you that. He tries to say he didn't know the car was stolen, that Trayon was driving around in the car. And at first, he acts like, even under questioning from Mr. Hagerman, that he wasn't even present when the car was exchanged, because he tries to say, well, Trayon told me. And if you recall, Mr. Hagerman had to kind of go back at him. I think he said something like, I can't tell you that. And then he eventually started answering some questions. You also remember that this is the same guy that went into law enforcement and said, I've never been in that car. I don't know a guy named Justin Johnson other than on Instagram. He's a rapper. And then suddenly, he starts evolving through the story. Still lying to law enforcement. He even looks at a video of himself, right, pumping gas, and goes, that's not me in the video. And he's like, okay, it's me. But they're trying to tell you Justin Johnson's at the Valero gas station, right, when he's pumping gas. Where is he? Now, they want you to believe that this shadowy figure up in the right, top corner was Justin Johnson. And that he was the other passenger in the Infiniti, but you can't really make out who he is.
Sorry, cleaning off my microphone.
You have to rely on Kristen Garner. That's what you have to rely on. And we talked a little bit about, proof beyond a reasonable doubt. And I said one of the ways that you could use to kind of understand it is proof so convincing that you would not hesitate to rely upon it in making the most important decisions of your life. And it's really simple, right? You look there and you go, would I trust Kristen Gardner with anything? If he told me something, would I believe it? The answer is no. Because the more he talked, right, the more you realize he and Trayon are in the Mercedes. They're driving around with a Draco rifle, assault rifle, the same one described as being held by Cornelius Smith in the shooting of Adolph Thornton Jr. Their prints are in the car. He says they have, well, he said a ton of guns in that car. And then he starts talking about how he's related to Dolph, and they were trying to dump the car before, right? And he's reaching out to Dolph's people to try to get rid of a car, which is the reason why after this happened, immediate day after, he's calling Trayon going, my name's in this. My name's in this. Why would his name be there? And B, why couldn't he just say, oh, I have anything to do with this? And at Valero, you do see Trayon and Kristen. They're there front and center. Now, there's been a lot of talk about the phone and location. And in the state's argument just now, you heard her saying what the expert said, a phone using, a tower that could be and he said could be. He said was in the service area of the Valero gas station. Or then he said, I didn't do any drive testing, so I can't say what the coverage area would have been, right? And when you're looking at his slides, you've got that really thick PowerPoint exhibit. You'll be able to look at it. And you notice, right, that you're going to notice that the pictures are all really small. They're really zoomed in on the map. And he's talking about, like, this, do you think this is thorough? This is thorough. I mean, he's going through all these calls. Look at what he's doing. I mean, but then you have to ask yourself, well, what happens if you expand the map? And then you realize, and this is the exhibit I entered, you realize he's not even counting all the data and calls, because when you show what he left out at 12:23, right, at the time, immediately after Adolph Thornton Jr. was shot, there are several towers that Mr. Johnson's phone gets off of that are, one's 3 miles away in one direction. The other one is 3.2 miles away down by the Memphis airport. And then he has to go, I left those out. Not a really good explanation for why, right? Important. When there are a group of fine people that are looking to find the truth and have to make this decision and need to evaluate the accuracy of what he's telling you. And then you realize that when you talk about coverage areas and where things are in relation to these phones, somebody could be anywhere in a 3 mile radius, either any direction. And then you have to go, what is it? What does it show us? How did that help? How does that make you any more certain of someone's presumed location at a given point in time, because he said it's not an exact science, and I'm not here to tell you that I can pinpoint where he is. And I didn't do drive testing, and I don't know. The next available tower is what a cell phone normally would look for, but also I can't even tell you if the towers were down at the time. That could make a difference. That could put you further out. I couldn't tell you if they were down for maintenance, if they were overburdened. And he said, look, if the tower's real busy, it'll direct you to the next tower. But what it doesn't establish is that Justin Johnson was involved in the conspiracy to kill Adolph Thornton. It doesn't establish that he killed Adolph Thornton or possessed a firearm. Now, a little bit about conspiracy and some more of the facts as you heard them from some of the other witnesses. Now, I have to take a little bit of an issue with the state on something that was said during their initial argument. And that is
Antenna
this.
went up.
There was no evidence at all that Justin Johnson was present for any meetings discussing this hit. What Cornelius Smith said was he met with Hernandez Govan and Jook, and Justin Johnson was not there. And then he said he met with Hernandez Govan and others on another occasion to discuss it, and Justin Johnson was not there. So to suggest that he was present and agreed, where's the agreement? He wasn't there. Now, you get to Mr. Smith. The court has already instructed you about accomplice testimony and is already warning you that when you're considering that, you have to use caution. Now, you also have to apply the credibility factors that are in the jury instructions, but they're not an exhaustive list, right? Like we talked about in voir dire. Some of you, most of you,
That's on their end. Well, what happened? They froze. Houston, we have a problem. Whoops. See if somebody else has a feed. That's not good. Don't want to get in trouble by playing that. Mm. Mm. Okay, so we're live there. I'm looking, loves. I'm looking.
what did it? Services rendered, right?
I know we may be not up to par, but we'll see. We'll see where this lands. Right now, they lost
And the
their
lawyer,
feed.
he's talking about with his sisters. He's saying, oh, well, My lawyer's telling me to cooperate. I'm walking. I'm not doing it unless I can walk. Now, he was asked by Mr. Hagerman, have I ever told you you're not going to have to go to prison? And he said, no, you haven't. But you have to keep in mind two things. At the time he was giving all this information that made him valuable to come in here and talk, he thought he was getting out. That's when those letters are going out. Those letters are going out, and he thinks he's getting out because he's got the lawyer, they got the cooperator from Holly Bobo to walk. And that's the type of thing you have to remember when you're assessing whether you can rely upon Cornelius Smith and anything that he said. The guy that sat in that chair, and he was asked by Mr. Hagerman, when you killed Adolph Thornton, what did you feel? And like it was nothing, said, I didn't feel anything. Let's try to get paid. And that's the guy that they want to put in front of you and say, believe it. You know, he went and talked about exchanging money, right? Getting $800, right? At one point said, do you find people that he got that Mr. Johnson somehow came back into town and he talked on the phone with him and brought $500. And then some other time, some other guy in a Chrysler 300 showed up and provided money to his girlfriend. Well, two things. One, that's not what Mr. Smith originally said to law enforcement. He said
They
that
very well
Chrysler
may be.
300 came twice. And then Mr. Justin Johnson.
When you see me
had
looking
none-
down here, I'm
went
looking
anywhere
at that
inside.
radar.
Well, and what do you know about the Chrysler 300? Jamarcus Johnson, right? Did Jamarcus Johnson say when he was here in front of you, did you ever hear the state ask him, did you deliver the money? As part of you being involved in helping Mr. Johnson, did you deliver money for him? I mean, he asked about the email, or the text rather, about Cornelius emailing Justin's phone and saying, essentially, I need money for the birthday party. That's because Cornelius Smith is lying from start to finish. And then for the first time ever, here in court, he says he wiped the card out. Who's in contact? Who's in contact with Govan? According to Mr. Smith. Mr. Smith. Who's not in contact with Govan? Mr. Johnson. Did you hear anything about that? Now, when you go back in the jury room, you're going to be reviewing, obviously, these videos. And one of the things that you have to kind of ask yourself is timing. When you see Mr. Johnson in the elevator with his little girl leaving Crosstown that morning. And of course, you know there's going to be one exhibit that's the reel where the state had on it 11:51 in the morning. And then, of course, Mr. Hagerman came in, acknowledged the mistake to say that wasn't the right time. And put an officer on the stand, the lieutenant, to talk about getting access to the time, how he got the timestamp. But what that shows you is this. They don't know what time it was that day on that video. They don't know. I mean, mistakes get made. I'm not here to suggest that they don't. But you have to ask yourself, okay, the mistake got made, and then there's a timestamp. Okay, we want to put the timestamp one in. That seems like the logical choice. But then you have to listen to the lieutenant, right? And go, Lieutenant, what did you do to check and confirm that these were accurate times? Well, I looked at the live feed when I was in there. I had to have a technician. It's a computer. I don't understand it. But when I was there, I looked up at the screen and it appeared to be the right date and time. But not one person, you didn't hear from anybody that could say, that was confirmed, that's accurate, nothing happened with the system beforehand. And you even heard him say, it is not uncommon at all to pull surveillance cameras that have inaccurate date and times. Because you have to ask yourself about timing. You have to ask yourself about timing of leaving Crosstown, Mr. Johnson presumably going all the way to Whitehaven, if he's in that Mercedes and dropping his daughter off, right? And he said 20 minutes, something like that. Then he's supposedly driving all the way back to Wild Rose, 20 minutes, thereabouts, to pick up Cornelia Smith. They got to leave, then turn around and go to Bradley and go back to the white truck, right? And then get out and be in front of the Makita Cookie at 12:21. Now, that part of common sense and your everyday experiences, what does that tell you about going one place to the other, right? Takes longer, right? If you're stopping places, if you got to park, if you're presumably dropping a child off, there's going to be some kind of a exchange of a child, maybe a discussion with a person, and you build all that in. That's a lot of time. And I would submit to you that one of the reasons that became an issue is about correcting that time is when the state realized that I was asking questions of that witness and asking him how long it would take to get from point A to point B to here to here to here. Because when you do the math and it's 11:51, it doesn't work. It doesn't work. And all this about Bradley, even the exchange of the Mercedes for the Infiniti, the dropping of the Mercedes at Bradley and picking up the SUV, whether somebody cleaned the Mercedes or didn't, who moved their Mercedes to the backyard, all of that, according to Cornelia Smith, should have been captured on Hernandez Govan's home security system, right? He said Govan had a security system directly facing Bradley because that's why when he decided that he was going to go wipe the car down, either the day it happened or the day after, he couldn't quite remember, he texted Govan and said he was coming through there because he didn't want Govan to mistake him for somebody trying to come up on him. I asked Detective or Sergeant Dabney, did y'all canvass? Yes, we canvassed the neighborhood. He didn't do it personally, but he would have presumed they would have talked to everybody, including Hernandez Govan. Right? We don't necessarily know if they did or didn't, because we and get to hear from Mr. Govan. You know, I asked Detective Browning if he was aware of any video from there. No. But if Cornelius Smith, right, is this person that's telling you the truth, because the truth doesn't change, then the fact that there were videos would have been known as early as March of 22, when he was meeting with law enforcement. And you know, I mean, I'm not saying law enforcement doesn't want to find out who did this. They would have absolutely went and looked. But we don't know. We don't know. And there's a lot that you should know that you don't. Because there's a material witness that should have been called by the state that wasn't called. Hernandez Govan. And maybe some of you sat through this and thought, I want to hear what he has to say. And when I told you in the opening statement, I said, it's important, right, for you to weigh out and be able, as part of your duty as jurors, to be able to compare those two testimonies together. I'm sure some of you were thinking, yeah, that would make sense. I know we talked about that in voir dire, about getting two people to talk to kind of differentiate. You know, some of you that may have been a teacher, talking about that is one of the ways that you try to figure out who's telling the truth, who isn't. But you weren't able to do that. You weren't able to do that. You were deprived of that. And to be clear, as you heard about Hernandez Govan, he was cooperating in this investigation. He met with law enforcement on at least 2 occasions pursuant to a proffer agreement.
Yes,
which meant
ma'am,
he
it
was allowed
is.
to go in and give information and not have his words used against him later. I don't have the ability to make good on a proffer letter. Only the state does.
If the
I
storm
don't have the
keeps
ability
turning
to
towards the
wave
east,
a
it may
magic
hit,
wand and give him a reduced sentence if he comes in and testifies for me. So he's to my exclusion.
north of
He's to
Spring
Mr.
Hill
Johnson's exclusion.
and go
And
between
ultimately,
Tallahassee
your
and
exclusion.
Spring Hill, headed kind of towards
And if
Jacksonville.
this is a truth-seeking
If it
function,
doesn't change course,
why didn't the state call?
it's going to hit a little southeast than they thought. But
And
we'll
it
see
is.
if it
Your
changes
job's to
course.
find the truth of the matter. And ultimately to go,
I'll tell you
did
what,
they
Red
prove their
Cross and
case
all
or
the other
not?
organizations are starting to rethink the landing.
But you were deprived of that. And the judge instructed you about a jury instruction. And that's the law. That's part of all the different things she told you. This is important.
It may even
anyway.
hit just north of Spring Hill near Cedar Key,
And the law states that it creates an
kind of
inference
curve towards Daytona
that the
Beach. That's the way it's
testimony
curving.
of that witness, Govan, would have been unfavorable to the state. Now, it's up to you to decide whether or not he was unavailable, a material witness, and whether or not there should be the inference. But you're allowed to make that inference in here. And unfavorable, I would tell you, unfavorable to the state means favorable to Mr. Johnson. And knowing that, can you really render a verdict of guilty
Photo
and have your mind rest easy?
worth 1,000 words. Yeah, I can.
and not walk away and go, I just don't know if I did the right thing.
You're good. Give you that.
Knowing that there was information out there that could have been presented to you and wasn't, that would have been favorable to Mr. Johnson, that I couldn't give you.
Y'all just want to say that wall, that inner wall is starting to tighten up, which means it's picking up speed. And the line, the way it's going, is kind of hooking more northeast than they thought it was originally. They expected it to go right over Tallahassee, maybe just slightly to the east of Tallahassee. If this does not stop hooking towards the east, northeast east, then it's gonna fall a lot lower than they thought. So more people may not be as prepared for this.
Can you be morally certain in that instance? In order to be convinced beyond a reasonable doubt that Mr. Johnson is the one in that Nikita video, you have to consider everything. You have to consider what you heard. And you have to go, what I heard from Kristen Garner and Cornelius Smith, was that so convincing that I wouldn't hesitate to rely upon it in making those most important decisions in your own life? Will my mind rest easy if I convict this young man based on their word in conjunction with that video and the other videos and what you didn't hear? The answer is no. When you examine your conscience back there, after you've taken the time to deliberate, I think you'll find the answer is no. Two things I want you to remember, and I'm wrapping up. The way the burden of proof works. You've heard the statement, right? They ain't got nothing to prove. You may say that to somebody, like, I ain't got nothing to prove here. Justin Johnson, he doesn't have anything to prove here. They do. And we've all heard the term benefit of the doubt, right? Everybody likes to give somebody the benefit of the doubt. You are legally prohibited from giving the state the benefit of the doubt. You can't carry their water for them. Again, I appreciate it. This is, as I said, last time I get to speak to you. The state's going to get one more opportunity to talk to you this morning. They get the last word. That's how the system's set up. But it has been my honor to represent Mr. Johnson in this case. And it's been my honor to present this case before you all. And thank you so much.
Thank you, Mr. Chairman.
We started this with a little Memphis talk. Those cookies are fire. I think that's how we started it. A little more Memphis talk. What y'all even talking about? What y'all even talking about? A missing witness? Fernandez Gomez? A missing witness? Hernandez Govan? Absent material witness. And the defense wants to say that is Hernandez Govan? What do we know about Hernandez Govan? He's a defendant in the case. He is charged with murder and conspiracy to murder. Whether it's from television or whether it's in black and white at the bottom of that same instruction, a defendant has the right not to testify and incriminate himself. He is a defendant. He is not a missing witness. That would be insane. I could willy-nilly just start calling every defendant. And they just have to come in here, testify. That's crazy. It doesn't even work like that on television. It doesn't even work like that in black and white in front of you. That would be insanity, and that wouldn't be a legal system where you had a Fifth Amendment right. That would be an inquisition, actually what they used to call it, where you didn't have that right not to come in court. So the idea that the defense would call a defendant who's charged with this crime an absent witness shows you how desperate it is. And then we'll talk about things in isolation. Look at Kirsten Gardner. I'm sure he knew that car was stolen. I'm sure he did too. Well, then how can you believe him? Or look at Cornelius Smith. I'm sure it's not his conscience that made him talk. I'm sure it's not either. He talked because he's caught. So don't believe him. So I made a mistake on one slide about the time, so it was corrected. So we can't believe the video. You know, there's a word that actually exists because it's a thing. It's corroboration. It's corroboration is what they call it. Like, can you look at something somebody's saying and compare it to something else and then determine whether or not that person's telling the truth about it? Because that's how we should judge stuff. Did Kirsten Gardner know the car was stolen? I bet he did. Does he think Treon Ingram actually paid for it because of something? No, we didn't pay for the car. They're riding around with guns in a stolen car, and they're trading it with their buddy, Mr. Johnson. But how do we know that? Corroboration. Is there evidence that shows us that? Well, there's the Valero video, which shows something strange. Shows something strange. Shows Kirsten come up in the car and somebody else get in and drive off. Strange. Another little piece of corroboration, where's Justin Johnson's phone at the time? Well, in the area of the Valero station. Can you say it's in the parking lot? No, you can't. But it's in the Valero, in the vicinity of the Valero station. But my God, is there something else? Yeah. And this is what is ignored throughout the entire talk we just heard. We don't just have towers. We just don't have cell phone towers. We don't just have a Valero video. We just don't have a Havenport video. We don't just have a crosstown video. We don't just have a defendant who's like, Cornelius Smith, I'm guilty and so is he. That's us two in the parking lot shooting him. We got Justin Johnson's actual phone. We got his actual phone. In this case, it's been over so many times. Things that happen that are actually really dramatic just sort of happen. Because as soon as we saw the video of the Makeda shooting, and as soon as you see the video of Crosstown of him leaving in the exact same outfit in the white Mercedes, case is over. But we keep going. As soon as you hear from a co-defendant who's like, that's me in the parking lot shooting Dolph, I'm going to prison, and Justin Johnson's the guy next to me doing it, case is over. As soon as you see the Haven Court video, 40 minutes after the shooting of the two shooters and his cousin, case is over. But then things kept on happening. That if you didn't have all that proof, it would have even been more dramatic, or would have been dramatic. When they happened, I would see in your eyes a little thing, a little twinkle. We have his phone. And the night before, we had a text. The night before the homicide, we had a text. From who? Treon Ingram. To who? Justin Johnson. Sending him what? A picture of the white Mercedes. What do we have next? Another text. Justin Johnson. Treon Ingram. Dropping his location. Bradley. Kissed and said. They met on Bradley. Then they drove to Valera. And they switched cars. That's corroboration. So do you have to be willing to trust Kissing Garter with the keys to your car? Of course not. You think I trust Kissing Garter with the keys to my car? But do I know he's telling the truth about this? Well, yeah, I do. Because it's on video of Valero. It's documented in his phone with literal pictures and locations. This is plain and simple. Do I have to believe that Cornelius Smith is talking because of pangs of conscience? No. No. He's talking because he got a call. Is he hoping that the truth will help him? Absolutely. He's hoping that the truth will help him. Is he going to prison after this? Absolutely. He's going to prison after this. Is there anything about his testimony, like Kissing Garter's, that we can corroborate? Oh my goodness. What's the first thing he tells us about that day? Justin Johnson calls me. I think I missed a call, and then I get a second one. And what do we got? Justin Johnson's phone. You can delete your call logs, which he did from that day, but they're still in the phone. And what do you know? 2 calls to Cornelius Smith from him right before he comes and picks him up at Lamar and Sons. That's corroboration. What does Smith tell us? We go to Bradley directly after the shooting, but dump the cars. Dump the cars is important. Because here's another little, real tricky truth test. Justin's driving the white Mercedes. You see it in the video, of course. When he testifies to it. He says, we drive to Bradley. He hands me the keys to the Expedition. I jump out of the car. I get in the Expedition driving while Justin parks the car in the driveway or there on the front. Well, we know the white Expedition is also Justin's car. They're saying it across town for testimony. What do we see at Haven Court? Cornelius says, from there we end up going to Justin's cousin's apartment. It used to be called the 2 Lanes, Gospel Gardens, the address on Haven Court. We see the white Expedition arrive. And who's driving? The white Expedition. Justin's car. Who's driving? The dude with the messed up shoulder and the messed up shirt. Cornelius Smith. I mean, how do you make that up? How do you make that up? They pull up at Haven Court with Cornelius Smith driving and Justin in the passenger seat. just like it had to happen, just like Cornelius Smith told you when he testified. We do the shooting, Justin's driving a white Mercedes, he hands me the keys to the Expedition, we get to Bradley, I jump out, I get in the driver's seat of the Expedition, Justin parks the Mercedes, jumps in, Haven Court. And what do you know? That's what we see. And what do you know? If you're lying, that detail is almost impossible to account for. Corroboration. We plainly see in the video, Haven Court. We plainly see them go inside. We plainly see Justin Johnson come out, meet this character in the Dodge Challenger, get some other clothes, get some bags, go in. We plainly see the Chevy Trax come, Angela Arnold, pick up Cornelius. We plainly see Justin get in his car, the Expedition, and the two pull out. His testimony is corroborated over and over and over. And that's so incredibly important as we do trials. That's how we make decisions. Corroboration. That's why we have evidence. That's why we don't just call one witness and say it's over with. We put evidence in front of you. And one of those moments when this trial was just over again for the 5th time was when we were showing the slide from his phone, from Justin's phone. Cornelius says right after the shooting, Justin calls and FaceTimes with somebody. He says it's a big joke. The guy that put the money down for this. Number 2 is CMG. Guy that put hits on the other artists too. Cornelius says it's a FaceTime. Spelling out Dolph with your hands. And what do we find in Justin's phone? I mean, the lead.
Yeah, I know. Toxic. I mean, he's retrying the case.
Hold that. November 7th.
We've heard all this, dude.
But it's
Short,
still
simple. Bye-bye.
a call and FaceTime interaction with him. Justin Johnson with Big Joke. Who Big Joke? Cornelius tells you. And there you see it in black and white. It's not 1981. No, that's true. Call on camera and everything else, but you're also walking around your pocket with a phone that you can delete a call on, but it's still there. The times you called Cornelius Smith that morning, still there. The time when you called and then FaceTime with Big Joke right after the murder of Dolph, still there. The videos from Haven Court that show you arriving, still there. The videos of Haven Court that see you changing clothes. Did he have enough time to do it? He didn't have enough time to do it. He left crossing at 10:51. He had over an hour and a half to go drop off his kid 20 minutes away and drive 10 minutes. Total trip probably take you 30 or 40 minutes.
I think he's harming them a little
He didn't
bit
have
by
enough
going
time to
on.
do it. We saw him do it. Memphis talk. All the times. All the times. Before the murder, we see him at Crosstown in the murder outfit. Similar clothing? No. Identical clothing. Patch on the legs, Bass Pro hat, everything. Before the murder, the Mercedes. Similar Mercedes? No. Back end damage, just like we saw in the video. During the murder, again, caught on video. White Mercedes, back end damage. The exact same clothing across town. Looks like him. Right-handed like him. Gloved up, like Cornelius said. Driving away from the murder. Who you calling, who you texting, Big Joe. Caught before, caught during, and then caught after at Haven Court. Video of them arriving and leaving. Caught before, during, and after. That's called being caught all the times. All the times. He is literally caught before, during, and after. Caught all the times. And then what does he do? Then what do we have? Another Memphis phrase. Get on down. Get on down.
Too long.
Cross town the last video. Packing my suitcases
I'm having more fun watching the radar than I am listening to him.
to head out of town.
Just saying. And I can't speed this up.
Packing my
'Cause it's live.
suitcases to head out of town and get on down. Like the police tell us, a man, not just in Memphis, well beyond Memphis. As Jamarcus tells us, he's going in and out of town. As Jamarcus tells us, he sees pictures on social media, Rolls Royce, stacks of money. Get out of town, get on down. The crime has been committed, Dolph has been killed, and we literally see him at the elevator with his suitcases getting on down.
Oh.
Flight can create an inference of guilt. Well, yeah. Well, yeah. This case was over when you saw the videos. This case was over when you heard from the co-defendant. This case was over when you saw him at Crosstown with the suitcases leaving, knowing that the manhunt was coming and he was out of town and leaving. Really. Really. Now it's time for us, though. Now it's time for us to get on down, but we don't get on down by fleeing. We don't get on down by hiding. We don't get on down with pictures of Rolls Royces, stacks of money. We get on down by doing what's right and doing our jobs and looking at the evidence, the witnesses, the corroboration, and applying the law to those things. We get on down by doing justice. We get on down by saying you are called all the times. You are called all the times and you're guilty of all the things. Conspiracy to commit murder? I just heard, okay, let's at least cut him a break on the conspiracy to commit murder because man, he wasn't there for at least like one of these meetings with Big Joe. That's what I just heard. Let's cut him a little break on the conspiracy to murder because he's not at this meeting with, Big Joe and Govan and Cornelius. So let's cut him a little break on that. That's what I heard. Let's cut him a little break on that. There's no requirement in the law that every conspirator have to be at every single meeting with each other. There has to be an agreement and an understanding. And there was clearly an understanding. Big Jook is going to pay money to take out PRE artists, and at the top of that chain is Dolph. Now, does he demonstrate any understanding of that? Is there anything he does that shows he's part of this understanding that this is going to happen? Yeah. He literally shows up with gloves and guns, has a white Mercedes he gets from Treon, has Cornelius driving next to him, and they drive and go do it. So the idea that, okay, he committed the murder, but give him a break, no. He's guilty of the conspiracy just like they're all guilty of the conspiracy. And of course, he's guilty of the murder because we watched it on video. Last short thing. Just one lyric. Just one lyric. You too real. Dolph, you too real. He rapped about what he calls come up. What he saw in neighborhoods, what he saw in his family, growing up. Too real. He rapped about people that he had a rivalry with. Too real. Dolph, too real. Included disses of dangerous people like Big Chuck. You're too real. Too real. Too real. Last moments of his life, last seconds of his life. How long does the video take? 30 seconds? You're too real. Dies on the floor. A neighborhood cookie store in Orange now. It's real. You're too real. Your family misses you. Erica and Mia and the kids.
Oh, shush already.
You too.
You could tell the judge is even getting bored.
This is real. This is too real. And when the killer, one of the two, is caught on video, all times, we even watch it get on down. It's time for us to be real. And we don't need Memphis talk for that. It's called just do what's right. It's as simple as that. Just do what's right. Cornelius Smith and Justin Johnson killed Adolph Thornton Jr. November 17th. We watched it happen. And Cornelius Smith, Justin Johnson, Hernandez Govan, Big Chuck, they all conspired to have it done. And it was done. November 17th, 2021. And as he did, he was already a convicted felon. He should be found guilty of all counts. We do what's right. That's how we do. Guilty conspiracy to commit murder, murder in the first degree, and convicted felon in possession of a handgun.
And that's good. Gone. Bye-bye.
I got a few more pages of the charge to read to you. I'm gonna pick up on page 29.
Dude, you hurt yourself. Oh, I got adjustment hearing aids. I felt like this actually hurt the defense a little bit. I think that the original person that got up and spoke did a phenomenal job of laying it out. He just should have come in for 5 minutes, done, out the door. He didn't need to love to hear himself talk. We'll see what happens now.
The first count of the indictment is conspiracy to commit first-degree murder. The lesser included offenses in order of consideration from greatest to least are facilitation to wit, conspiracy to commit first-degree murder.
I don't think this is going to take long,
If you
y'all.
are hired to consider your verdict in the first count of the indictment, you will first inquire whether the defendant is guilty of conspiracy to commit first-degree murder as charged in the indictment.
Jeez, it's bad when I'm falling asleep on my own live.
If you find beyond a reasonable doubt that the defendant is guilty of this offense, your verdict will be: we, the jury, found the defendant guilty of conspiracy to commit first-degree murder as charged in count 1 of the indictment. If you unanimously find the defendant not guilty of this offense, you will next inquire whether the defendant is guilty of facilitation to wit conspiracy to commit first-degree murder as charged and included in count 1. If you find beyond a reasonable doubt that the defendant is guilty of this offense, your verdict will be: we, the jury, found the defendant guilty of facilitation to wit conspiracy to commit first-degree murder as charged and included in count 1 of the indictment. If upon all the proof you have a reasonable doubt of the defendant's guilt of the offense as charged and included in the first count of the indictment under the law defined and explained to you, it is your duty to acquit him. Your verdict will be: we, the jury,
All
find the
posted.
defendant not guilty as to count 1. You will write your verdict on the outside of the jacket and sign one of your names to the verdict as foreperson.
God, it was so hard to stay awake during my own live. That
The
sucks.
charged offense in the second count of the indictment is first-degree murder. The lesser included offenses in order of consideration from greatest to least are second-degree murder, facilitation to wit first-degree murder, facilitation to wit second-degree murder, voluntary manslaughter, aggravated assault, facilitation to wit voluntary manslaughter, facilitation to wit
Wake up.
aggravated assault, simple assault, facilitation to wit simple assault. You will next inquire whether the defendant is guilty of first-degree murder as charged in the indictment. If you find beyond a reasonable doubt that the defendant is guilty of this offense, your verdict will be: we, the jury, found the defendant guilty of first-degree murder as charged in count 2 of the indictment. If you unanimously find the defendant not guilty of this offense, you will next inquire whether the defendant is guilty of the next lesser included offense, second-degree murder, as charged in the indictment. If you find beyond a reasonable doubt
Here we
that
go on the
defendant is guilty
lessers.
of this offense, your verdict will be: we, the jury, found the defendant guilty of second-degree murder as charged and included in count 2 of the indictment. If you unanimously find the defendant not guilty of this offense, you will next inquire whether the defendant is guilty of the next lesser included offense, facilitation to wit first-degree murder, as charged and included in count 2 of the indictment. If you find beyond a reasonable doubt that the defendant is guilty of this offense, your verdict will be: we, the jury, found the defendant guilty of facilitation to wit first-degree murder, as charged in count 2 of the indictment. If you unanimously found the defendant not guilty of this offense, you will next inquire whether the defendant is guilty of the next lesser included offense in order of consideration from greatest to least, as set forth on the previous page. If you find the defendant guilty of a lesser included offense, your verdict will be: we, the jury, found the defendant guilty of, as included in count 2 of the indictment. Insert a lesser offense in the blank. If upon all the proof you have a reasonable doubt of the defendant's guilt of the offenses charged and included in the second count of the indictment under the law defined and explained to you, it is your duty to acquit him, and your verdict
Yeah,
will be:
I'd hate to have him as a
we, the jury, found
professor
the
in
defendant
college.
not guilty as to count 2. You will write your verdict on the outside of the jacket and sign one of your names to the verdict as foreperson. Count 3. The charged offense in the third count of the indictment is convicted felon in possession of a firearm. There are no lesser included offenses. You will next inquire whether the defendant is guilty of convicted felon in possession of a firearm.
Well, he definitely is going to
as charged in
get
the
that
third
one.
count of the indictment. If you find beyond a reasonable doubt that the defendant is guilty of this offense,
I
your
know.
verdict will be: we, the jury, find the defendant guilty of convicted felon in possession of a firearm as charged in count 3 of the indictment. If upon all the proof you have a reasonable doubt for the defendant's guilt of the offenses charged and included in the third count of the indictment under the law defined and explained to you, it is your duty to acquit him, and your verdicts will be, we the jury found the defendant not guilty as to count 3. You are right to verdict on the outside of the jacket and sign one of your names to the verdict as foreperson. When you retire to the jury room, you will first select one of your members as foreperson who will preside over your deliberations. When you have reached a verdict on a particular count, the foreperson will write your verdict as to each count on the outside of the jacket and sign his or her name to the verdict as foreperson. Take the case, consider all the facts and circumstances fairly and impartially, and return to the court with verdicts that truth dictate and justice demand. All right, as I told you before, this is the official copy. Please refer to it. There's just been a couple of minor changes made, but nothing substantial, nothing substantive. Let's put it that way. A few typos I ran into, but other than that, please use yours, make notes on yours, refer to yours. But this is the official copy if there's any discrepancy. The jacket, please. You will have all of the exhibits. We'll go back with you. Please look them over. If at some point you want to watch videos, please let us know. Do you have did you make the list? Okay, is it?
It's been numbered as an exhibit, Your Honor.
Okay, so it's with the exhibits. Do you have a clean laptop so they can you get us a clean laptop so they can watch videos as they want to watch videos? Thank you. So you will be provided a laptop that's clean, so you can watch videos how you want to watch videos, and there will be a list accompanying the video to show you, to tell you, describe to you which video is which. That makes sense? Okay. So, is everybody in good shape to deliberate? You can ready to choose alternates. Everybody good to deliberate? I'm going to call three numbers. Once all 3 are called, the deputy will escort you back to the back to get your belongings. And then if the 3 of you could come back out here, because I have a few remarks for you. And then the rest of the jurors, the 12 of you that will be seated to deliberate, will go back and begin your deliberations. Okay. Juror number 18. Juror number 13. Juror number 12. You guys can look at these if you'd like. You can review these
Sorry, I was saying a bad word. That wind just driving me batty. Okay, toxic. Thank you. I do have the New York mayor indictment. I got it myself, y'all. Oh, I found it myself. Hell has frozen.
Deliberate at the same time. There should never be an opportunity where 2 or 3 over there eating and the rest of you are deliberating. You decide you're gonna eat, everybody eat.
Verdict clock
Decide
is
you're gonna take a
wrong.
break, everybody take a break.
Long crime.
When it's time to deliberate, everybody deliberate.
Yeah, I said a not nice word, so I'm glad I was
Know
muted.
that you're doing something different besides deliberating.
Toxic, we'll watch it. Now it starts. Y'all, I don't like how that hurricane's behaving. Unless something comes along and pushes it more north, it's going to hit further southeast than they thought. So if anybody is in between Spring Hill, well, Tampa's going to get it bad, just the bands. But landfall may make it directly between Tallahassee and Springfield, which would be Horseshoe Beach, Cedar Keys. I think that's where it's going to hit, somewhere in that area, which is further south than they anticipated, unless it changes direction. Not looking good for those areas that probably weren't as ready as Tampa, Tallahassee, Apachiola, however they say it. As soon as she says we gone, I'll be right. We'll move. We got a lot to talk about, y'all. So the verdict clock on long crime, I'm not going to accept that time because they started it well before the jury was dismissed. Technically, I would wait 10 minutes because they got to get their stuff. They get in there and da-da-da-da. But I started it as she dismissed the jury. I take it back. She dismissed the 3 jurors. Maybe I'll restart it. Let me see what happens. Y'all, I figured out how to make these squares. Isn't that cool? Kind of like it. Not gonna lie. I just let you know they have flooding in Dothan, Alabama,
Jurors, you are excused.
Atlanta. Now I'm starting the clock. Georgia, Carolinas, from Knoxville all the way Tennessee to Greensboro. They're going to have flooding. Atlanta, Augusta, Macaroon, Athens, Georgia. So y'all be safe.
Court stands in recess.
Court stands in recess.
Okay, we are now officially on verdict watch. So I'm just going to let this lie over here. I want to share a few things, and this is devastating to me because my father has a ministry in Africa, and in the same area in Nairi, I think that's how they say it, Kenya. 21 students on Thursday, they had a memorial who died in a boarding school fire in Kenya earlier this month. Oh my gosh, y'all, 21 boys. Can you imagine? That is so horrible. So I just want to say, y'all, there's a lot of bad stuff happening in our country, but Oh man, these families need your prayers. Okay. Here's another one. Y'all ready for this? Da, 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 da. The world's longest serving death row inmate has been acquitted. I'm all like, oh my Lord, y'all, this is amazing. Iowa Hakamanda has been awaiting his potential execution for 56 years. An 88-year-old man is the world's longest surviving death row inmate, has been acquitted by Japanese court. Iowa Hakamada, who was on death row for 48 years, was found guilty in 68 of killing his boss, the man's wife, and their 2 teenage children. He was granted a retrial last year amid suspicions of investigators may have planted evidence that led to the conviction for the quadruple murder. The verdict brings an end to the Japan's longest, most famous legal saga and makes Hakamada only the 5th death row inmate to be granted a retrial in the court's post-war history. Oh my gosh, y'all. His sister standing next to him is 91 years old, and she was instrumental in getting him freed. The next thing we're going to talk about, and we're going to actually watch, is the Hannah Gutierrez Reed motion hearing. So I'm going to begin this and get this playing. And we're going to up the speed on this a little bit. Now, I think this is all by Zoom. Oh, I forgot about this attorney.
Everyone, the calling is B101CR 2023-00040, State of New Mexico versus Hannah Gutierrez. Party state their name.
Carrie Morrissey on behalf of the state of New Mexico.
You're still alive?
Jason Bowles from
You're still representing? Holy crap!
Okay.
Sorry.
Let's see.
That woman is.
All right. So what
bye-bye.
I think we should do is start with the second motion, the more substantive motion, and then go into the other motion.
But Your Honor, no.
All right. I'm prepared. Go ahead.
Thank you, Your Honor. And so just to clarify, Judge, you want me to argue the motion for new trial or for dismissal first?
It's not going to be.
No, not the release one. Okay.
Yeah, okay. Yes, Your Honor. That's what I thought. Okay.
Okay.
Thank you, Judge. Judge, on July 31st, 2024 of this year, this court filed an opinion in the Baldwin case, and this followed a July 12th hearing in that case. In paragraphs 59 and 60, this court went through the findings of the state's egregious discovery violations, deliberate and intentional withholding of evidence, and in the court's inherent power, stated that dismissal with prejudice was warranted to ensure the integrity of the judicial system. Now, part of the court's findings, and I'm going to relate them to this case, part of the court's findings also included that Ms. Morrissey, when she testified, called herself as a witness in that hearing on July 12th. Her testimony was inconsistent internally. Her testimony also conflicted with at least one other witness. Now, we have since supplied this court with affidavits from her former co-counsel, Erlinda Johnson, to highlight additional, we believe, false testimony that Ms. Morrissey gave to the court. Now, that's important because I think this court has to view through the prism of the prior findings of the affidavits, the comments Ms. Morrissey is making, and what I consider to be shade on the truth on her statements. Now, part of the court's findings at paragraph 10 in Baldwin's case included that the state had continuously made late disclosures and that the state had filed a certification, specifically Ms. Morrissey had certified that she had supplied all of the evidence required under the rules under 5-501. Now, that same thing occurred in this case. And Your Honor, post-trial, we have now learned that Ms. Morrissey never disclosed to us, and I'm going to get into these and why they're important, the Hague report from August 31st, the Seth Kinney interview that I've highlighted in the motion, and the third one are these Teskey rounds. And I'm going to explain that in a little more detail as well. Now, the same thing the court found in paragraph 10 applies here. The state made that certification and it was untrue. Your Honor also found in paragraphs 27 and 28 that CST Popple, that testified in Ms. Gutierrez-Reed trial, had given false testimony in Baldwin's trial. Specifically, there was a interchange between Ms. Morrissey and Ms. Popple, in which the idea came up in testimony before the jury that these rounds were not similar. The Teskey rounds were not similar to the rounds found in the rest set. The court then held a hearing on July 12th and actually ordered those rounds produced. And despite Ms. Morrissey's continued assertions to me, to the jury, and also part of her testimony that they were not similar, there were 3 very similar or identical rounds, Starline brass with silver primers. Now, as part of that aftermath, Corporal Hancock testified that Ms. Morrissey was part of the meeting to what I consider to be bury and hide the Teskey rounds that were turned in on March 6th in a separate case file under a separate number. Now, Ms. Morrissey stated that the first time she saw these rounds was July 12th. Then the court asked a question during that hearing to Corporal Hancock. Corporal, was Ms. Morrissey present in the meeting to put those rounds in a different case file under a different number? And she said, yes, she was. Well, and that's part of the court's findings in this court's order, that Ms. Morrissey was part of the decision to hide those rounds, hide the supplemental report, and to not have that produced. Now, in Mr. Baldwin's case, the standard, and as this court notes in paragraph 48, was evidence disclosed within a trial. Ours is obviously the standard post-trial. And so this court delineates that standard and how it's different for post-trial discovery of evidence. Now, that is that we have to show that there was a reasonable probability that the outcome would be different. And I'm going to get into that with each of our pieces of evidence. Judge, the fact of the matter is, we would have never discovered the Teskey supplemental report or what they had done with that if Baldwin's case had not occurred, if they had not done those interviews. We would have also not discovered the Hague August 31st report, because those came out in Baldwin's interviews in that subsequent case. Those were never turned over, as was Seth Kenny's. So they were all suppressed. Now, were they favorable? The court finds, as part of its order in the July 31st order,
Slay the wicked, how are you?
There, the defense had outlined a progressive trail of how the rounds got from Troy Teskey to the set of rust. And that was in paragraph 30 of this court's order. The court went through how they went from Teskey to Seth Kenny. They went to the 1883 set and how they ended up on October 12th being given to Sarah Zachary. Now, the court also said that any additional information as to the source of live rounds or how they arrived on set would likely affect the jury's determination as to proximate cause and as to negligence of third parties under 14-251 UJI. Now, it is the same thing in Ms. Gutierrez-Reed's case, but the facts are different. The reason why the facts are different are that Ms. Morrissey, in effect, suppressed them in our case by telling Mr. Teskey she would retrieve these. She told him in his pretrial interview, and that's detailed in our motion,
And the
that she would
hurricane's
retrieve
taking,
these and the
maybe
state was
taking a
going to
little
collect.
further south,
That never
southeastern
happened.
path than they
But
anticipated.
by telling Mr. Teskey that,
So that's going to
Mr.
hit you even
Teskey
more.
didn't want to do anything with those rounds. He didn't want to touch them, and he wanted to keep them secure and safe. Now, I was not able to see those rounds until the second to last day of trial was the first time I saw them. Mr. Teskey didn't want to bring them. He didn't want to be accused of tampering or obstruction, and I didn't want to, and Ms. Morrissey said I didn't want the evidence. She, again, shades the truth. The fact of the matter is I didn't want to be in the chain of custody, nor did I want there to be any allegation that I had anything to do with something nefarious with regard to those rounds. So I directed Troy Teskey to turn those in to the sheriff, which he did, because we wanted law enforcement to have them, because
That was good
naively,
advice.
the state would do the right thing and would test them. Never in a million years did I think the state was going to hide those in a separate file under a separate case number, which then came out on the Baldwin trial. So that's what Mr. Teskey did. He turned those into the state. In the aftermath of that, we weren't told what happened. We weren't told there was a separate file. We weren't told any of that. Because Miss Morrissey basically held those in place with Mr. Teskey, it's the same thing as the court found in the Baldwin case. We weren't able to test those. We weren't able to utilize those rounds. We weren't able to even touch them because the state was going to seize them. Now, had we been able to use them, it goes back to the court's paragraph 30 on outlining the trail of how the live rounds got on set and how they got in the hands of Mr. Kinney and got to Rust. The state's theory at trial against Ms. Gutierrez-Reed was based on a series of pictures that they put together that Ms. Gutierrez-Reed must have introduced the live rounds because here's the pictures. Well, in reality, now that we learn that Mr. Kinney could have introduced those on October 12th through Sarah Zachary, and the jury could have been shown and seen those rounds. I asked the state repeatedly to test them, and they would not. Even though they tested every other piece of evidence in this case, except the live rounds, they didn't test those for DNA and fingerprints, but they didn't test the Teskey rounds. They refused to. Your Honor, second, as to the Hague report, I think this is very critical. The Hague report and the one we're talking about, this is one that we never got during trial. Mr. Hague, the state's chief expert as to the firearms, made a report that says it seems unlikely, although it cannot be excluded, that these tool marks on the firearm are the result of the damage incurred during the FBI's impact testing. He goes on to say that they do not appear to be original manufacturing marks or use and abuse tool marks. Now then he follows with these tool marks are unlikely to have had any bearing on the operation of the revolver at the time of the incident based on the FBI's trigger pull data. However, the fact that he made the comments that they seem unlikely to have occurred during the FBI's impact testing and not consistent with original markings, we could have used that at the trial. And in fact, Your Honor, what's even more important is I asked Mr. Hague on the stand a very open-ended question. My question was, did you see any other evidence of modification or damage to that firearm other than what the FBI's testing did? He said, no, sir. Now, Ms. Morrissey tries to again spin that by saying that was in the context of the functionality of the firearm. I did not include the word functionality in that question. It was a very open-ended question. Mr. Hague said, no, sir. When in reality, both Ms. Morrissey and Mr. Hague knew at that time he had authored a report that showing that there was other damage to the trigger and to the sear.
Sorry, guys. I was trying to move the captioning, but I cannot.
Now, later on, Ms. Morrissey points out in a response, after Hannah's trial, Mr. Hague is able to learn more about the firearm, and then he's able to change his conclusion. But at the time of the trial, Mr. Hague got a report saying there were unexplained tool marks and on the trigger and sear, and they weren't explained by the FBI's testing or the original manufacturer. Your Honor, we would have used that in the questioning and potentially raised an issue in the jury's mind regarding that jury instruction 14251, which is critical in this case. The jury sent out a question on that jury instruction. And that is, was this an uninterrupted chain of events? Or did something occur that interrupted the chain of events that would have been a proximate cause issue? If there was damage to the trigger or sear, and we're able to cross-examine Mr. Hague on that, the jury doesn't have to believe his conclusion that this didn't affect the functionality. They don't have to believe that. And again, this goes back to Ms. Morrissey, who stated to this court repeatedly, certain items of evidence are not relevant. And it's her determination. She did things because they're not relevant. But that's not her call. That's not her call under the standard, under Brady and under exculpatory evidence, because the defense may have a different use for them. I guarantee I would have altered my strategy at trial, as the court said in the Allison case. And that case is where the court reversed a conviction of a defendant's arrest record that wasn't disclosed to him. Obviously, he knew about that arrest record, but the court said it could have altered strategy of the defense at trial had we known about. They were going to use it. Well, the same thing is here. If I had known about that report, we would have highlighted that and we would have made a strong argument under 14251. You can't be sure as jurors that this didn't affect it because we have a report here showing from Mr. Haig there was damage that he can't explain. And he was a very important witness in this case. It's inexplicable that we didn't have this report. And Miss Morrissey only, this trial ended March 6th. It was August 31st that Miss Morrissey first indicated in an email that this report would be turned over, and it was her failure why it didn't get turned over. There wasn't a very good explanation. There is no good explanation for not turning that report over that we could have made use of. The other thing that's critical to understand is this was coming out during the Baldwin interviews, which was going on simultaneously as we were having our trial. So it's just inexplicable that Miss Morrissey would have hidden this evidence for use in our trial. And Your Honor, finally, the Seth Kenney interview, that interview had several things, and this interview was suppressed. I would have crossed him on several of the statements. Now, Miss Morrissey's comment is that we knew about these other items through other witnesses. That's kind of the general statement she's made in response. The facts of the matter, however, is that Miss Morrissey vouched for Mr. Kenney improperly in closing argument, saying he was, in essence, anybody that disagreed with what he said was lying, and basically that Mr. Kenney was telling the truth. So it would have been very effective for us to be able at trial to have used Mr. Kenney's own words in this interview that we did not get to cross him on statements he had made. So that is the import of that as to impeachment. These items are material, they are favorable, and Your Honor, I think the most significant thing that came out of the Baldwin hearing, and this court appropriately and was warranted dismissed that case with prejudice because of the egregious and continuing pattern of discovery misconduct. And it didn't just start after Hannah Gutierrez Reed's case. That's not, they didn't conduct themselves ethically and then all of a sudden unethically in that case. This pattern of discovery abuse occurred in Ms. Gutierrez Reed's case in the same manner as it did in Mr. Baldwin's case. And because of that, we are asking the court to consider dismissal in this court's inherent power, and the court lays out in its order the court's inherent power to issue a whole host of sanctions, or in the alternative, a new trial, Your Honor, because it's the significance of the items that were suppressed, favorable and material to Ms. Gutierrez Reed that could have been used. We also have a situation, Your Honor, where I'm going to ask the court to order in this court's inherent power, if this court orders a new trial, to remove Ms. Morrissey as special prosecutor. She has testified before this court, and I submit, and I don't do it lightly, her testimony was false in several material aspects. This court's findings in its order indicate that at the very least, she didn't exercise reasonable diligence to ascertain the nature of those Teskey rounds because she was at that March 6th meeting. But I would say at the worst, because Ms. Morrissey's been thorough in other aspects of this case, she did see those rounds. She did know that they were, there was 3 silver primer rounds before July 12th. And so, Your Honor, I'm asking that this court in its inherent power remove her from further prosecution of the Russ case. And we are asking for a dismissal on the same basis as this court dismissed Mr. Baldwin's case.
Whoa. Okay, hold on, Doom.
All right, thank you.
I want to say this. Do I believe that Hannah had some responsibility in this? Yes. It was her job to ensure that the lead or bullets that were entered into the weapons were not live rounds. But do I think that she got a fair trial? No, I do not. Not after what Ms. Morrissey was caught doing. Do I believe we should have another trial? Yes, I do. Some of you may disagree with me with that, and you're welcome to it.
Thank you. Response?
Initially, I want to just ask, Mr. Bowles indicated that there was an affidavit provided by Ms. Johnson. I don't have that. I haven't seen it attached to any of the pleadings, so I'm not sure what
I
he's
don't
referring
believe you.
to. So if, obviously he mentioned it, can I get some insight into when that was provided?
Hello?
Your Honor, I will try to locate this in the pleadings, but there was an affidavit filed with, that's in the court record in the recent Baldwin response. But I think I've attached one in this case as well. I just would have to find it.
I agree, Ronnie.
Well,
Seth Kenny needs to be looked at again.
is it in here? When did you file it?
Judge, I thought I filed it with our motion, our reply to dismiss, but I'm not seeing it right away.
He's looking for it. Why don't you continue arguing while he's looking for
The
it?
motions I printed out don't have the exhibits, Your Honor, so I'm not seeing it.
Well, I just went through every motion that's on Odyssey that has the exhibits attached, and it's not there. So.
All right. If you can't produce it, I'm going to strike that part of the argument regarding Ms. Johnson.
Yes, Your Honor, and I would just say that part of the court record in the Baldwin case is there is one filed in the recent response. Mr. Nika's filed.
But it's not in this case.
Yes, I
Better
can't
find
find
it.
it readily, Your Honor.
Okay, so I'll strike that part. Go ahead, Ms. Morrissey.
I will say though that this is an issue that Mr. Bowles raised in his initial motion for a new trial. I responded to it. I stand by my response. I summarized the conversation that I had with Ms. Johnson, and Ms. Johnson indicated that she wanted the case dismissed out of issues that she was concerned about for self-preservation. I disagreed with that. I don't think self-preservation is a reason that you dismiss a case. There's a legal analysis that has to be done in order for the court to consider disqualifying a prosecutor. Mr. Bowles hasn't cited any of those cases, and he hasn't put that legal analysis in any of his motions. So I would ask the court certainly not to consider granting that without a motion that actually addresses the law and the facts as they relate to the law. This isn't something that you just randomly ask for. The legal analysis has to be conducted, and it hasn't been conducted here.
Then he's going to ask for it.
So having said that, I responded to Mr. Bowles's concerns about
I'm going to read
the
it in a
veracity of my testimony. Quite frankly, I'm not sure that it's relevant to his motion for a new trial. But because it's something that he's put in his motion and it's something that he has argued, there was no meeting about these Teskey rounds. I did not attend a meeting.
Y'all, I'm going to take a comfort break. I'm going to leave this running.
I did not see the rounds until July 12th. I did not see the doc report until I believe it was July 12th or July 11th. I'd have to check my email. Whenever I got it and I provided it to the defense attorneys. I had no idea that there were 3 rounds that had the same characteristics as the live rounds from the set of Rust until July 12th. Mr. Bowles can complain all day long that he thinks that's not true. I'm telling you it's true. And how that ended up happening is actually quite clear, because what happened in this case is that Mr. Teskey took a photograph of the rounds that he had in his possession and he sent it to Seth Kinney. We ended up with that photograph. I've included that photograph in my response to this, to Mr. Bowles's motion for a new trial. It does not show any ammunition that looks remotely similar to the live rounds that were found on the set of Rust. He went further than that. Mr. Teskey said, I looked at these rounds. I couldn't find any with silver primers. okay, so at this point in time, the state, this is long before I ever came on the case, but the state understands at that point that the ammunition that he is in possession of does not look remotely similar to the live rounds on the set of Rust. That doesn't make them material. It's okay for us to say we're not going to collect those because he sent pictures and they're not material. Then we go ahead and we do his pretrial interview. And I decide maybe I should go ahead and collect those. So I make that statement to him during the pretrial interview. Mr. Bowles can argue all he wants that he was assuming that we were going to take him. He had no idea that we weren't going to collect him. I had an email exchange with him in January that's attached to my response where I explained to Mr. Bowles, I am not collecting that ammunition. If you want it collected and you want it tested, go ahead and do it and ask for a continuance of the trial. That is a conversation that took place over email and it is attached to my response. So Mr. Bowles understood we were not going to collect it. And it was during that email exchange that Mr. Bowles then provided more photos of the Teskey ammunition. And those photos matched exactly the photos that were provided to Mr. Kinney by Mr. Teskey. And they showed rounds that were completely dissimilar to the live rounds on the set of Rust. This is information that is coming from Mr. Teskey and it's filtering through Mr. Bowles. So Mr. Bowles doesn't get to come to the court now and say, hey, they should have collected these. The information that he gave us caused us to reasonably believe that they were completely immaterial. We had no idea that any of those rounds matched the live rounds from the set of Rust. Mr. Bowles provided us a photograph in January, a month before the trial, for heaven's sakes, that showed that they were completely dissimilar. So then let's jump to the trial. This is where Mr. Bowles' argument completely fails. He wants to rely on the court's dismissal of the Baldwin case.
Her voice
but he can't rely on that because what happened was
sharp on my ear.
These rounds were in the possession of his witness. He told his witness to bring them to court. He got to look at them. He told his witness, I'm not going to call you as a witness, and I'm not going to take these rounds. We're not going to touch any of this. I understand why he did it. Because, again, as I have said, sure, in a world of infinite possibilities, can you argue that these rounds somehow came on through Seth Kinney? I guess, but you can certainly you have a much stronger argument that this is how they came on through Ms. Gutierrez. Her father had these rounds that were exactly like the rounds that she brought on. So Mr. Bowles knew about this during trial. So when we're doing the legal analysis for whether or not Ms. Gutierrez gets a new trial, she does not get a new trial based on this ammunition that was in the possession of her father's good friend and that she and her lawyer had during trial. The state did not have. She and her lawyer had them during trial and chose not to use them. That is exactly what happened. So the legal analysis, the 6 factors that this court has to look at when deciding to grant a new trial, the second one is that the newly discovered evidence has to be discovered after trial. That's not the case here. This evidence was discovered by Mr. Bowles during her trial when the state had no idea what those rounds were comprised of. He made the judgment call, hopefully after consulting with his client.
Are you going to continue to lie about this? Are you kidding me? Yes, I'm going to lose my shit. Yes, I said it. This woman, I'd love to see the word fired after her name. I can't stand her. I don't mind lawyers having different personalities and being kind of weird and quirky. What I mind and what drives me batshit crazy is when they break the law to try to prosecute somebody. I don't go for that. She hid evidence. She is a proven liar. She got on the stand and said one thing, and then in the interview, just minutes later, lied about what she said on the stand. She's lying here. She knows exactly. I mean, she knows everything about these. Everything. Pisses me off. I hope the judge will shut her butt down, but I don't think so.
Not to call Mr. Teskey and not to use the rounds. They don't get to now come and say, we made a strategic error, so give us a new trial. That's not how this works. So the issue of the Teskey rounds with regard to Ms. Gutierrez's motion for a new trial, it is absolutely, it's not permitted under the law. It was not discovered after trial. Here's the other thing that the court needs to take into consideration. A motion for a new trial can be filed for almost any reason.
It wasn't very godly,
10
but
days
it's true.
Of the conviction. Mr. Bowles is limited to a.
My sister's favorite phrase is, and I know some people may not like it, but I'm going to say it because it is so appropriate for this. It is so appropriate for this. It really is. Mm-hmm. And she's going to appreciate that I did it.
Bitch, please. Yep. Bitch, please.
A motion for a new trial based on newly discovered evidence beyond the 10 days. So Mr. Bowles, having seen those rounds for himself on the second to last day of trial, having infinitely more information about those rounds.
Wait a minute. Seeing rounds, meaning seeing a case with a bunch of rounds. I wish I can bring it up, but I'll get banned. Box full of holes. The bullets are put in those holes and it's in a box. The capsule didn't go down right. It's stuck. Me holding a box and seeing it and me looking at each individual is two different things. You need to qualify and quantify what
rounds than I had easily could have filed a motion for a new trial within the 10 days, but he chose not to do that.
Yeah.
So he has given up. He has waived his right to use that in a motion for a new trial. Furthermore, I want to point out to the court.
Furthermore,
Mr. Bowles filed a lengthy motion for a new trial, and never once did he articulate or argue the legal standard that is required for a new trial. Never one time. And I'm glad that Ms. Gutierrez is listening to this, because the legal standard that
bitch, please. This person's about ready to go off. Shade, salty much?
That he is required to meet was never mentioned one time during his motion. The state mentioned it in the state's response because these are the 6 factors that the defendant has to meet in order to get a new trial. So let's move on to the Kinney interview. Mr. Bowles outlined, I think, approximately 20 statements in that interview that he had specific concerns about. And he's absolutely right. I want you to know this was suppressed. The moment that I found out that this audio.
Did she just admit to something? Hell's frozen.
Recording existed at the district attorney's office. I immediately provided this to Mr. Bowles. I couldn't believe that there was an interview,
and she's
an audio recorded interview of this witness that had been sitting at the district.
Ah, damn it. I'll get it back. I'll get it back. I'll get it back. I'll get it back. I apologize. I don't know what the hell happened. Probably my fat thumb. That's not who I want.
I apologize. I guess this is their way of telling me to calm my butt down.
Put that legal analysis in any of his motions. Had the same characteristics as the live rounds from the set of Rust. Understands at that point that the ammunition that he is in possession of does not look completely fails. He wants to rely on ammunition that was in the possession of her father's good days of the conviction interview. So now we're down to the 5 issues that Mr. Bowles ends up relying on, because the other 15 turned out to be things that really were already in his possession, were already within his knowledge. So when we go through and we look at these, I'm sorry, there's I think he narrowed it down to 8. He had no idea that we weren't going to collect them.
I'm trying to find.
It was going to seize.
Okay, so we were here.
Messages between Mr. Kinney, Ms. Zachary, and Ms. Gutierrez. Hannah has more experience on Westerns than Mr. Kinney did until 1883. Well, I would hope so, because Mr. Kinney is not an armorer. So the comparison between Ms. Gutierrez's experience and Mr. Kinney's experience has absolutely nothing to do, is completely immaterial with regard to this case. And importantly, the factors that this court is required to consider do not create a situation where Mr. Bowles gets a new trial because there's something out there that could be potentially impeaching. The law actually doesn't give him that with regard to a new trial. His third issue, prop masters who handle guns won't call out armorers to test bullets. I don't understand. I mean, I don't understand how that could even be remotely material. We had plenty of evidence from people who were on the set, who work on movie sets. Mr. Kinney does not, by the way. He doesn't work on movie sets. And we had an expert come in and say that armorers are supposed to test the bullets. So how is this material? The sheriffs confuse the replica guns with the real guns. What does that have to do with the elements of the offenses that Ms. Gutierrez was charged with? It has absolutely nothing to do with those. Mr. Kinney heard nothing but good things about Hannah on set, and all of the concerns about safety that came out later he hadn't heard about. Judge, that's all in the text messages that Mr. Bowles had. He had all of that. Mr. Kinney actually, there's an exchange between Mr. Kinney and Ms. Gutierrez where she talks about the director saying what a good job she was doing, and Mr. Kinney responds. All of that is in the text messages. This was always in Mr. Bowles's possession. Mr. Bowles didn't review it. He didn't use it during the trial. That was his decision.
Okay, that may be his fault.
Sabotage could be anyone on set. Mr. Kinney doesn't work on movie sets, and he was never on the set of Rust. Okay, so this is his speculative opinion. It was also something that Mr. Bowles had the opportunity to fully explore at trial, and did in fact fully explore at trial. Because Ms. Gutierrez left the ammunition unattended, anyone could have messed with it. Yes, we went through all of that. Because these firearms were left unattended, yes, anyone could have messed with them. We knew all of that. All of that came out during trial. The idea that if the camera crew had gotten their hotels, would they have still felt unsafe? This is number 7 in Mr. Bowles's reply. This has absolutely no material value with regard to the case against Ms. Gutierrez in any way, shape, or form. That the assistant director and Alec Baldwin didn't give Hannah every ounce of support and she got pushed around. Well, this was Mr. Kinney's opinion, but you also have to keep in mind, Mr. Kinney was never on the set of Rust. Mr. Kinney never met Mr. Halls, the assistant director. He also never met Alec Baldwin. So this is a statement that he made that has absolutely no foundation, and also is completely immaterial to the case against Ms. Gutierrez. Now, we get into the issue of
what the hell just happened?
At State v. Crone, which was provided photographs that the Haigs took, and the microscopic markings reply. This has absolutely no material value with regard to the case against Ms. Gutierrez in any way, shape, or form. That the assistant director and Alec Baldwin didn't give Hannah every ounce of support and she got pushed around. Statement that he made that has absolutely no foundation.
We've already read it.
And also is completely immaterial to the case against Ms. Gutierrez. Now, we get into the issue of the third Haig report. And look, I understand that to a certain degree, the job of a defense attorney is to make things seem perhaps a little worse than they are because it helps their arguments. Nothing was intentionally buried. This case had a terabyte of discovery. There was new discovery coming in constantly. This was a report that I believed I had forwarded on to our staff to have it uploaded to the server. When I realized during the Baldwin preparation for trial that did not occur, I immediately I took full responsibility for it. Mr. Bowles points to the email where I took full responsibility for it as though I've done something wrong by taking responsibility for it. I believe that it had been forwarded on. I went back, I looked, it had not been. We did the best that we could to resolve it at that point in time. And listen, the problem with Mr. Bowles' argument with regard to the Haig report is twofold. First of all, the Haig report clearly says the microscopic marks on the tip of the sear did not affect the functionality of the gun. Furthermore, Mr. Haig
may disagree with that.
since learned exactly
I may disagree with that. It depends
the
on how it got
testing
there
of the gun
and when it got
was
there.
being done, and has now come to the opinion that these microscopic marks were made by the testing at the FBI. So Mr. Bowles wants to say, Judge, it doesn't matter.
No, you're still
the
held
fact that the guy
accountable.
has changed his opinion after he got new evidence, that stuff shouldn't matter. Well, it most certainly does matter, because when you look at the 6 factors that this court has to consider when granting a new trial, is the probability that the result would be different if the new trial was granted. So if you have an expert who said, initially, I'm not exactly sure where these microscopic marks came from, but I don't think that they came from the FBI. Then he goes and he talks to the guy at the FBI, gets more information about how that testing was done, and the expert then says, okay, now that I've got this new information, I've changed my opinion. I think that they did come from the FBI. Well, that goes directly to the first prong of the 6 prongs, which is whether or not a new trial would result in an acquittal if the court were to grant the motion. It's not going to, because Mr. Haig got more information about the testing, modified his opinion.
I wish I had something that goes wah, 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 wah,
and
wah.
And the other thing is that Mr. Bowles hired, although I don't think he paid him, but he had his own firearms expert. Not only did he have his own firearms expert, he used an investigator in this case who purports to have a fair amount of expertise in firearms.
Who pointed the
So
gun
you've
at you, Your
got
Honor?
basically two people who have expertise in firearms working for the defense, and you have the photos of the sear and the microscopic markings on the sear that were provided to the defense for their review. Not only did they have the photos, but the gun was sitting over in evidence. They can go, they can look at the gun, they can take the gun, they can test the gun, they can do any of those things, and they opted not to do any of them. Now, presumably, either the defense expert, Mr. Kuski, or the defense investigator was tasked with going through all of the photographs that Mr. Haig took. What Mr. Bowles has actually said in his reply is, oh my gosh, Judge, there were so many photographs. We can't be responsible for having to review all of those. They certainly can be. They needed to review each and every photograph. I know how long that takes because I did it myself. So the basis of the Haig opinion was always in the possession of the defense. And they seem to just basically ignore the fact that they had the photos, that they had their own expert, and they basically had their own expert come in and say, we agree with Mr. Haig, the gun worked fine. That was the reason that they called that expert, was just simply to say, we agree, the gun worked fine. They had everything that they needed. But listen, I'm not trying to take away from the fact that this was a report that should have been provided and wasn't provided. I have taken full responsibility for it. I will continue to take full responsibility for it. So I want the court to know I'm not trying to get around that. But one of the factors that this court has to consider is, would the newly discovered evidence have been discovered before trial by the exercise of due diligence? They had a photograph of it. They had a photograph of the markings on the sear, and not only was it a photograph, right next to it is a photograph of a sear without those markings. It was in the possession of the defense the entire time. So this easily could have been discovered by due diligence. That due diligence meaning simply go through the discovery that you have. Go through the discovery that you have. And you know, New Mexico is unlike so many other states, in fact, perhaps all states, because defense attorneys actually get to interview the state's witnesses. So that is the opportunity for the defense to exercise their due diligence to discover things. That's the whole point to the pretrial interviews. So in this case, what happened was, we had a pretrial interview scheduled of Mr. Haig. Mr. Bowles did not attend, because Mr. Bowles did not attend, I think, 95% of the pretrial interviews. So he opted not to attend. He left it to his investigator. His investigator conducted a 25-minute pretrial interview, and not a single question was asked by the defense investigator about any of the photographs that the Haigs took. They asked about the damage to the gun. Mr. Haig indicated there was damage to the gun. He further indicated that the sear was damaged. That came out in the pretrial interview. So when you look at the 6 factors that the court has to consider when granting a new trial, the defense doesn't get there. They simply do not get there. I further have some concerns for the record. So one of the issues that Mr. Bowles,
Your Honor, I have a concern for the record. May I be heard, please?
has made an issue in these motions, which is a little confusing to me, is the issue with regard to the standard of state v. Ware. So what he's arguing is that the ammunition that's in Teskey's possession, under Ware, the state had the obligation to go and collect, and by not collecting it, that resulted in a due process violation to his client. here's the problem with that argument. I sat and went through every single New Mexico case related to where. I can give you the list, and
No,
for the
thank you.
record, because we have so many potential appellate issues. I'm going to tell you, Judge, not only did I look at State v. Ware, I looked at State v. Crone, which was provided by Mr. Bowles. I looked at State v. Kinney, State v. Torres, State v. Martinez,
It
State
was
v.
not
Camden,
requested
State v. Rodriguez,
information.
State v. Bailon Escobedo, State v. Baca, State v. Garcia, State v. Kant, State v. Taylor, State v. Perkins.
Wah, 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 wah.
Those are the New Mexico cases that discuss the where standard. Every single one of these cases says that the obligation of the state has to do with collecting evidence from the crime scene. And they make it very, very specific. And where indicates this is very limited. The state is not required to scour the planet Earth for potentially exculpatory evidence. It is evidence that is from the crime scene. This is not evidence that was from the crime scene. This is evidence that was in the possession of a defense witness. Mr. Bowles knew in January that we weren't going to collect it. He knew that it had never been collected. He certainly did know that because he was in contact with Mr. Teskey. Mr. Bowles could have had that ammunition tested.
Okay, she's putting me to sleep.
I mean, the chain
guys.
of custody was shot. There was never going to be any chain of custody with this anyway. This isn't something that was located at a crime scene and was taken into evidence. This is something that was sitting in a defense witness's garage. So Mr. Bowles could have had this tested. He opted not to have it tested. He could have had it tested. He could have had those test results compared with the test results of the FBI. And the best case scenario for the defendant is that would indicate that the same powder that was used in the ammunition that was in Teskey's possession is the same powder from the powder, or consistent rather, with the powder from the ammunition from the set of Rust. And that exact same powder is used in millions and millions of rounds of ammunition everywhere. One of my concerns since this issue arose has been the fact that Mr. Teskey 2 times sent photos of the ammunition in his possession, twice, and never sent a photograph of a round with a silver primer. In addition to that, he indicated, I have looked at these rounds and there are none with silver primers. And then 2.5 years later, he shows up with ammunition that looks just like the ammunition from the set of Rust. And again, you can buy this ammunition at any gun store. This isn't special. You can get it anywhere. You can get ammunition with these exact same characteristics at any gun store. So out of, to be thorough and complete, the where analysis doesn't match in this case. It absolutely is really irrelevant to this case, because the defense had more access to this ammunition than the state did prior to Ms. Gutierrez's trial. Now, with regard to the Baldwin case, that's a completely separate issue, because that is information that was in the state's possession prior to his trial. So there are real issues with regard to that disclosure.
She finally said it, y'all. Did you hear it? She finally said it. She finally actually said it. Listen.
Sure. That's completely different. This case, Mr. Bowles had it in his hand. He had it in his hand during trial. And Mr. Teskey, I'm not making things up. Mr. Teskey told law enforcement on video I offered this to Mr. Bowles and he said he didn't want it. That's what Teskey says on the video. So, you know, Mr. Bowles
could
acts
be
like
lying.
I'm pulling this out of thin air. I'm not. That's what Teskey said. He said Bowles didn't want it. And again,
Teskey
Judge, I
doesn't always
understand why he
mean
didn't.
just because he said it doesn't mean he's telling the truth, my dear. Just like
So
because you said
I
it doesn't mean
also
you're telling
want
the truth.
to articulate, because I think that this
Teskey
is an
has
issue that
reason to lie,
Mr. Bowles is raising and is
protect
arguing,
himself.
specifically with regard to the reply that he filed. And let me be specific in his reply, if you'll give me just one moment.
No.
I'm just reviewing my notes here real quick. So with regard to Mr. Bowles's reply, he says both parties, the defense and the state, knew that Teskey had ammunition from the same batch that Reed and Kenny took to Texas. I disagree with this statement insofar as it oversimplifies what happened. So both parties knew that Thel Reed possessed a variety of .45 caliber ammunition with a whole lot of different characteristics. That was that was proven by the photographs. It was proven by the ammunition that was taken from PDQ into the sheriff's department. So, but what there's no proof of, absolutely no proof at all, is that each type of ammunition that was in Mr. Reed's possession went to Texas and then went to New Mexico. So if Mr. Reed has 20 different types of .45 caliber ammunition, and it strikes me that he had about 20 different types of .45 caliber ammunition, there's absolutely no evidence or testimony that the ammunition that is silver primer starline brass with that particular projectile shape ever went to Texas, let alone ever came to New Mexico. So when we say it came from the same batch, I guess my concern is, what do we mean by batch? If there is evidence, actual evidence, that these specific rounds went from Arizona to Texas to New Mexico, I've never heard it. Mr. Bowles actually went so far in his reply to say that the Teskey evidence was deliberately hidden from him. The Teskey evidence wasn't deliberately hidden from Mr. Bowles. It was provided to him by his own witness. He could have had it tested at any point in time. I would respectfully ask the court to deny Mr. Bowles's motion, and if Mr. Bowles wants to file a motion to disqualify me, he can file that motion. That is a separate motion. There is case law on that motion. I would ask the court to deny this motion.
You are so
Thank
cocky.
you.
I said it. If you were a
Thank you,
man,
Ms.
a lot of
Morrissey.
people would love you.
Reply, Mr. Bowles.
Yes, Your Honor. Thank you. Your Honor, I
She's
want to
like,
start off by telling the court
I'm so
several
over this.
initial points. The Teskey evidence that was deliberately withheld was the Teskey supplemental report. We still have Brady rights on appeal. That was not given to us, the March 6th report. So Ms. Morrissey
Multiple
misconstrued
things
that.
weren't, not just one.
She also
thing.
misconstrued the idea that I didn't want the evidence. What I told Mr. Teskey was that I didn't want to be in the chain of custody of those rounds.
And he's
And
smart.
I was actually a good idea that I did not, because Ms. Morrissey's now accusing Mr. Teskey, in essence, of planning silver primer rounds in that group of rounds.
Good
She
for
just made
you.
that argument. Now, Mr. Teskey originally, way back when this case started, did a cursory search through the rounds and did not locate any silver primer rounds. He thereafter didn't touch them and that's where the text came from very early on. He didn't touch them. Miss Morrissey was saying she's going to come get them. That's what she said at the interview. So by the time we have the email exchange, which by the way, Your Honor, she didn't email me. I emailed Miss Morrissey trying to figure out where this was at. And then she responded, I'm not going to get these rounds. It was too late. This court had made clear, and I don't remember the exact date, but that we weren't going to continue the trial. There was not sufficient time at that point to test them. And we could not test them, Your Honor, because the FBI had the powder for the live rounds on set. We don't have an ability to match those unless they're tested at the FBI. So the state did suppress those. And we're not asking on the WARE standard for them to go to the ends of the earth, as Miss Morrissey said. They knew the individual who had them. They knew this early on. And that, as the court put in paragraph 30 of the court's opinion from July 31st, there was a progressive trail established.
Guys, we do
how
have
these rounds could have
movement in the
gotten to the
courtroom.
rest set through Mr. Kenny. Now, Miss Morrissey wants to
But
denigrate that idea.
I'll let you know if
But
it's
finally
more
today
than
she
that.
said, well, I guess in a wild speculation, you could say Mr. Kenny brought him.
Justin
No, that's a
Johnson.
real possibility. That's something the jury should have been able to consider, but they never wanted to acknowledge any possible defense theory, which is why they suppressed everything. Because Miss Morrissey didn't think it was relevant. With regard to the Hague report, Miss Morrissey made extensive argument about how we should have divined these microscopic or very small damage to the trigger and sear through looking through thousands of pictures and having our experts somehow divine the opinion of Mr. Hague that this or come to the same opinion as Mr. Hague. But what she's ignoring and trying to get this court to ignore is the failure to produce that report from the main state witness who was opining on whether the gun functioned correctly. And I just accepted that at trial because I accepted his answer that there was no modification that affected and no modification other than the FBI testing, which that was the case in the pretrial interviews. That was the case at trial. Ms. Morrissey said pretrial interviews are where we can figure these things out. Well, we couldn't even figure out at trial because he didn't answer the question in a truthful manner. What he said was there is no other modification to that trigger or sear. Now that's false. And Ms. Morrissey wants to conveniently skip over that and the idea that we should have had this and it's no harm, no foul, even though we have abundant proof of false testimony, and she's admitted we didn't get the report. That's something we could have absolutely crossed on and used under 14-251 on this idea that the court pointed out in Mr. Baldwin's order on the negligence of third parties and the proximate cause argument. Your Honor, regarding the Seth Kenny statements, I did read it all. I boiled it down in the reply to the 8 most important, and that's why I wanted to get to the court to consider. Ms. Morrissey tries to, again, run away from the idea that she suppressed something by characterizing as we had it all. Well, we didn't have it all, and we didn't have it specifically all from Seth Kenny's mouth. So that's not true, the arguments that were just made, and we could have crossed him on that, and he was an important state witness, as this court knows. Your Honor, with regard to the Teskey rounds, what Ms. Morrissey didn't address at all is not the new trial grounds, but we've asked for a dismissal under the court's inherent power. And the whole Teskey argument, and I've been open about it, I didn't see those till 2 days before the end of the trial. At that time, there was no way to do anything with them because they had been suppressed in essence by the state not getting them, Mr. Teskey not wanting to touch them. For the exact reason that Ms. Morrissey accused him today of planning rounds. That's the reason why he didn't do anything with them. But Your Honor, the Teskey evidence and the court's opinion in Baldwin goes to the remedy of dismissal because the egregious nature of this prosecutorial misconduct in this case, specifically by Ms. Morrissey, her false testimony does a blow to the whole system of justice. It's not just to this case. As this court appropriately found and was warranted in Mr. Baldwin's trial, this affects the whole system. Why people respect the system, they voluntarily turn themselves into jail when a judge rules, is because they have respect and confidence and public trust. What Ms. Morrissey did in this case is she destroyed public trust across the board in the Rust prosecutions on a case that was watched by the nation and the world. A case being paid by the taxpayers, one of the biggest debacles, ethical misconduct, probably in the history of New Mexico.
Yep.
But this court appropriately dismissed that case to restore and maintain and uphold the integrity of our system. And so I'm asking the court to consider doing that in this case as well, because it's not fair and it's not right when
we
the
have
prosecutor
judge.
doesn't play by the rules
We
and
may
it doesn't
have a
engage in
verdict.
fair play. That undermines our entire system.
All right, thank you for your presentations today on this particular motion. I will consider these arguments as well as
Take
the
it under
pleadings. I will
advisement.
issue an order. I plan to issue the order early next week. All right, but at least next week. All right, let's move on to the motion for immediate release.
Yes, Your Honor.
Okay, guys, we have actual movement. I don't know what's happening, but the clock for law and crime is still ticking. But the judge's head has been bopping in and out. So we'll see.
And that really, I think, is predicated upon the court's ruling, whichever way the court would rule on the instant motion we just argued. So I'm open to suggestions of this court or counsel. Judge, I don't know if it's ripe until this court rules.
I think it's ripe. You've got section 3111(1)(c), and you've also got the case law.
Yes, Your Honor. And with that, I am asking for immediate release, and some of the same arguments we've already presented with regard to the Hague third report. Judge, this is on appeal. It's been remanded on a limited basis for this court to rule on the motion for new trial. I know that the state has responded that there are issues that Ms. Gutierrez-Reed has had with regard to statements she's made. But Your Honor, the fact of the matter is, while she was on pretrial release in this case, she didn't have any violations. She didn't go anywhere. She's not intending to flee. She's not intending to try to avoid prosecution. Your Honor, and I would submit that if or to avoid her obligations to this court, I would submit that she's not a danger. If this court were to enact conditions, she doesn't have firearms. She could be on house arrest or whatever conditions this court deems appropriate. While this case is pending, whatever decision this court makes early next week, that she'd be allowed to be released pending the appeal. One of the problems, Your Honor, is that the length of time of this appeal, if this case proceeds to appeal, is likely to take longer than her sentence. And that's just a fact of how the system proceeds. And so we're asking, with the issues we've raised, for this court to consider releasing her while this court considers this motion and the appeals court considers our arguments.
Yeah, that would be horrible if she served it all and then she's released from, and then she wins.
Your Honor,
and she
the
served
state
all that time for
objects
nothing.
To the release of Ms. Gutierrez, Mr. Bowles indicated that she didn't have any violations of her conditions of release. I think we didn't have any evidence of those violations that we could bring to the court, but we did discover when listening to Ms. Gutierrez's jail calls that she was in possession of alcohol during the trial.
Don't do it.
Discussed violating the court's order that she not possess firearms during her jail calls. And she has already signed a guilty plea to a felony in her other case. So Mr. Bowles' argument that she doesn't have any other criminal history, I know that he argued that initially in his motion, and she has now since signed a guilty plea in that case. So I'm not trying to beat him up over that. When he made that assertion in his initial motion, it was accurate in terms of her convictions. It is no longer accurate.
Really? Your choice of words, my dear.
Based on those issues, we would ask the court to deny Mr. Bowles' request to release Ms. Gutierrez. And I will say that one of the things that has mystified me in terms of the way that Mr. Bowles is handling his appeal. He's filed more than one motion before Your Honor asking that the court release Ms. Gutierrez. I think this is the third such motion that I have responded to. I think the court has only heard two of them because one of them was never set for a hearing. But if Mr. Bowles has concerns about the fact that his appeal is going to take so long that essentially Ms. Gutierrez will have served her entire sentence by the time his appeal is over, I don't understand why he isn't addressing that with the Court of Appeals. I think that he can do that. I think that he should do that, and he should have already done it. So we would ask this court,
So you're
based
attacking
on
his ability.
everything that we've gone through this morning
Lawyer?
with regard to Ms. Gutierrez's motion for a new trial, the 6 factors that have to be met in order for that to be granted.
It is, Ronnie.
I have never seen a case in the state of New Mexico where the district court dismissed a case post-conviction based on discovery issues, and I don't think that Mr. Bowles has pointed to such a case. So I don't know that asking the court to dismiss the case against Ms. Gutierrez based on the 2 issues that Mr. Bowles was unaware of during the trial is appropriate. The appropriate remedy is motion for new trial. He can't meet those 6 factors. So I remain confused as to if Mr. Bowles has concerns about the length of time of the appeal and how it relates to his client's sentence. File a motion asking for release before the Court of Appeals, because they have a better idea of how long their appeal is
I'm
going
trying
to
to
take
find the right thing.
than
Sorry,
we do.
guys.
But for some reason, he's not done that. So we would oppose Ms. Gutierrez's release. It sounds like the court's going to rule early next week. So certainly if the court rules that Ms. Gutierrez gets a new trial, the court can immediately release her. I'm not sure the court even needs to have a hearing on that. I think that's well within the court's power. But the state objects to it, for the record. Thank you.
You're welcome.
Your Honor, just briefly. Yes, Your Honor, thank you. Just briefly. Your Honor, the reason why we are asking for dismissal in this case is that it is the most egregious case I have ever seen of prosecutorial misconduct. And there's always an instance where you have to ask a court for something you're compelled to do on behalf of your client, because there is no case I've ever seen that is this bad. Mr. Baldwin's lawyers wrote that in their response they recently filed. And this court appropriately dismissed that case. That's why we have asked for the dismissal remedy. Because this case is so egregious, what happened? Lying, cheating, hiding evidence. Second, Your Honor, with regard to the release, we wanted to go through the chain of command. We wanted to address that with this court first. And then we will, depending on this court's ruling, we would go to the Court of Appeals next. But I wanted to respect the chain of command and respect this court's authority over the proceedings. And this court had previously ruled on those issues. So that's why we filed it. So, Your Honor, we would respectfully agree with Ms. Morrissey. If this court rules in our favor early next week, this court wouldn't have to have a hearing and could just release her.
All right, thank you, counsel. Again, I appreciate your presentations today, and I do appreciate your briefing. I'm going to consider your motions. I will address them in 2 separate orders. Your motion for release, immediate release under 5402, and then the order on discovery violations and inherent power, new trial and dismissal. All right. Thank you.
Thank you.
We are in recess.
Wow. What do you guys think? I think that they both have good grounds, but you have, in my humble opinion, need to err on the side of the defendant. I think the charge that they gave her, I thought, with knowing what I know now, was the wrong charge. There needs to be several people held accountable and I think one of them is walking around in that Seth. I think there's something going on there. But in the end, she will have to serve some time on the other federal charge. She will never be able to own a weapon again. That's all understood. But I think we're going to get into a bunch of craziness if we get a retrial. Oh my gosh, that's going to be insane. But he's not asking for that. He's asking for a total dismissal with prejudice. All right, here we go. Now we're jumping to the Mayor Eric Adams
Associated
indicted.
Press that Mayor Eric Adams has been indicted by a federal grand jury, making him the first mayor in New York City history to face an indictment. Good evening. I'm Natasha Verma.
And I'm Steve Lacey. Rumors have been swirling that this was imminent following the federal raids on the homes of members of Mayor Adams' inner circle and the wave of high-level resignations from his administration. We have live Fox 5 coverage tonight. Let's start with Morgan McKay, who joins us now on set with this stunning development. So right now we know the indictment's coming, but we don't know for what. That's what we find out tomorrow, I guess.
Exactly. Now, we know there are at least 4 federal investigations surrounding Mayor Eric Adams right now. But from what I'm hearing from sources is that this indictment could be tied to the federal investigation looking into whether Mayor Eric Adams accepted illegal campaign donations in part from the Turkish government. Now, we first learned about this investigation on November 2nd of last year. You'll remember that the FBI raided the home of his top campaign fundraiser, Brianna Suggs, and Adams at that time was flying to D.C. and he quickly just turned around and came back. Right. But it's still very unclear. We do not know what's inside this indictment. We do not know what charges or if there's multiple charges in this indictment. That indictment will be unsealed, I'm hearing, tomorrow morning. So we'll hopefully learn more there. But we just also recently found out as of this week that the federal investigators have broadened their search and have included other countries such as Israel, South Korea, Uzbekistan, Qatar, and China. Now, we know that Adams has traveled to China at least 7 times. He's traveled to Israel last year. He traveled to Qatar in 2022, I believe. And so he said he has also been to South Korea when he was a state senator. And as far as we know, he has not made a trip to Uzbekistan, but maybe there's something there. Maybe they just saw some sort of piece of information. It's also really unclear if this is tied to any of the other investigations, particularly looking at the NYPD Commissioner, Edward Caban.
So we don't know the specifics, but at its face, I mean, this is a stunning development. I mean, it kicks off now in an indictment of a mayor for the first time in New York City. What happens next in the process with Mayor Adams?
So this is huge. There's only 2 New York City mayors who have ever resigned in history. That was Jimmy Walker in 1932 and William O'Dyer in 1950. So right now, if Adams doesn't resign, the only person who can remove him from office is Governor Kathy Hochul. If he does decide to resign, then this kicks off a pretty quick process. So the public advocate, Jumaane Williams, would step in as acting mayor, and then they would have an election about within 80 days of when he steps in. And after that, all the candidates would come forward and it would be ranked choice voting, and there would be no party affiliation. So it would be just an open election because there would be no primaries.
Right. And we have heard a little bit from the mayor tonight, sort of previewing what we think is going to be his likely defense strategy, right?
Exactly. We got a statement from the mayor, and he said, quote, "I always knew that if I stood my ground for New Yorkers, that I would be a target, and a target I became. If I am charged, I am innocent, and I will fight this with every ounce of my strength and spirit." Now, obviously, they're reading a little bit between the lines. Something that he's kind of been hinting at, and some people have said out loud, is that he believes in part that he has been targeted by the federal government because of his criticism of the Biden administration when it comes to the migrant crisis. He was one of the most open critics of Biden when it comes to migrant crisis, since New York City has seen over 200,000 migrants come to the city in just the past 2 years. Obviously, that's not exactly what he's saying, of course, out loud, but hopefully we'll hear more from him tomorrow, because another question, too, is when will he surrender to the feds?
That's right. I mean, you're always at City Hall. And over the last few weeks, I mean, really since September 4th. I mean, when the federal investigators seized electronic devices from city's police commissioner, schools chancellor, deputy mayor of public safety, first deputy mayor. I mean, since then, top aides have been investigated by feds. What has been the energy, the feelings at City Hall?
Right now, people have becoming growing increasingly frustrated with the distractions. And they say it's hard to do their job. It's even hard to communicate with the press about something that they want to talk about, some initiative that they want to do, because everyone is just talking about this right now. Now, since, in just the past hour, we have seen just an outpouring of people and lawmakers coming forward, calling on Adams to resign. I think at least 5 more lawmakers on top of the 8 that have already called on him to resign.
AOC being one of them too?
Exactly.
Yeah.
And so I know from one of my sources, they were saying that, there was possibly some indication maybe to her that this was coming down. Now, the House Minority Leader, Hakeem Jeffries, he kind of was defending Adams a little bit earlier today when he was asked, because he said, we need Eric Adams to be successful because he is the mayor of New York City. So I don't know if he'll have more comments after this indictment.
All righty. And I have it. I'm trying to get it to respond. I've got too many windows open. I'm trying to close them all. We also have the trial for Turtle Boy that is waiting to go live. Here we go. I'm going to share this page. I'm going to kind of finagle this a little bit so y'all can read it. There we go. Okay, y'all, this is a very long document. I got to bring it in front, bring this over here. Got to make some changes. Sorry about that. This is going to be a very long document. It is 57 pages. So we're going to skim through this. Okay. We may have enough time to go the whole way. I don't know. I do want to wait. I'm watching 2 things right now. I'm watching the courtroom for the Justin Johnson case and the courtroom for Turtle Boy. All right, here we go. United States of America versus Adams Eric. 24th Circuit, IRM 556. God help me. Here we go. In 2014, Eric Adams, a defendant, became a Brooklyn president thereafter for nearly a decade. Adams sought, and I got to make this a little smaller for me. It's just a little too big on my end. Oh, there we go. Put it on focus. There we go. Mo better. Became the Brooklyn borough president. Thereafter, for nearly a decade, Adams sought and accepted improper valuable benefits, such as luxury international travel, including from wealthy foreign business people and at least one Turkish government official seeking to gain influence over, I don't know, him? Yeah. By 2001-8, Adams, who had by then, 2018. So I'm going to say 2018. Y'all, do you guys not proofread your crap? 2018, who had by then been known his plans to run for mayor of New York City, not only accepted but sought illegal campaign contributions to his 2021 mayoral campaign, as well as other things of value from foreign nationals. As Adams' prominence and power grew, his foreign national benefactors sought to cash in their relationships with him. Particularly when in 2001 it became clear that Adams would become the New York mayor. Adams agreed, providing favorable treatment in exchange for illicit benefits he received. After his inauguration as mayor of New York City, Adams soon began preparing for his next election, including by planning to solicit more illegal contributions and granting requests from those who supported the 21 mayoral campaign with such donations. I'm kind of bouncing everything, checking. Eric Adams, the defendant, sought and accepted illegal campaign contributions in the form of nominees or straw contributions, meaning the true contributors conveyed their money through nominal donors who falsely certified that they were contributing their own money. By smuggling their contributions to Adams through U.S.-based straw donors, Adams' overseas contributors defeated federal laws and served to prevent foreign influence on the U.S. election. Wealthy individuals evaded law designed to limit their power over the electoral offices by restricting the amount any one person can donate to a candidate, and business circumvented New York City ban on corporate contributions by funneling their donations through multiple employees, frustrating a law that seeks to reduce the corporate power and policies. Adam increased his funding by accepting these concealed illegal donations, at the cost of giving his secret patrons the unique influence over him and the law tries to prevent. Eric Adams, the defendant, compounded his gains from the straw contributions by using them to defraud the New York City and steal public funds. New York City has matching fund program that matches small dollar contributions from individuals, city residents, with up to 8 times their amount in public funds to give the New Yorkers a greater voice in the election. Adams' campaign applied for matching funds based on known straw definitions, fraudulently obtaining $2,000 in public funds for each illegal contribution. Adams is those workers at his direction falsely certified compliance with the acceptable campaign finance regulations, despite Adams' repeated acceptance of straw donations, relying on concealed nature of this illegal contributions and falsely portray his campaign as a law-abiding. As a result of those false certifications, Adams' in 21 mayoral campaign received more than blank of public funds. Millions is what they're saying. Eric Adams, the defendant, also sought to receive other improper benefits from some of the same co-conspirators who funneled straw donations to his campaign. In particular, a senior official in the Turkish diplomatic establishment, the Turkish official, who facilitated many straw donations to Adams, also arranged for Adams and his companions to receive free or discounted travel on Turkey's national airline, which is owned insignificantly by part of the Turkish government, to destinations including France, China, Sri Lanka, India, Hungary, and Turkey itself. The Turkish officials and other Turkish nationals further arranged for Adams and his companions to receive, among other things, free rooms at opulent hotels, free meals in high-end restaurants, and free luxurious entertainment while in Turkey. Eric Adams, the defendant, and other working at his direction, repeatedly took steps to shield his solicitation and acceptance of these benefits from public scrutiny. Adams did not disclose the travel benefits he obtained in annual financial disclosures he was required to file as a New York City employee. Sometimes Adam agreed to pay a nominal fee to credit the appearance of having paid for the travel that was in fact heavily discounted. We're going to hold here.
Is represented by Special Assistant District Attorney Robert Cosgrove. The matters are on for various motions.
We'll come
The
back to
parties
that.
Please identify themselves for the record. Commonwealth.
Good afternoon, Your Honor. I'm Robert Cosgrove for the Commonwealth.
Good afternoon, counsel.
Hello, Your Honor. Timothy Bradle on behalf of Aiden Carney.
Good afternoon.
And for Mr. Carney, Mark Bedero, Bederow. I've been admitted pro hoc vice for this matter, Your Honor.
All right, good afternoon. Good afternoon, sir. All right, a couple of things. I believe counsel was advised, but I just want to say on the record, we are having an FTR issue, so I don't think the white noise on your tables is working. So I just say that to make sure whatever you say to each other is being recorded. So just keep that in mind. If at some point you do need to have a private conversation, let me know when you can step out, but otherwise just be aware of we're being recorded. All right. I know there are a number of matters that we need to address. I'm going to start out with some more administrative issues, which are the motions to impound, which are, so for each one, everything that's filed, there are two because there's two docket numbers. So the motions to impound are 24, 25, 39, and 40. I did allow those pending any further discussion here in court. So let me start with the Commonwealth. Do you have any objection to the allowance and the continued allowance of those motions?
No, Your Honor.
All right, so those will be continued to be allowed. As far as the motions themselves, where should we start? What would you like to start with?
So, Your Honor, I think we were speaking downstairs for a moment, and the first thing I think logically involves the protective order issues.
Yes.
And to avoid kind of ringing the bell before you make a ruling, I suppose we should do this at sidebar relative to the content of the protective orders and what we're proposing. One of them, we're not far apart on an agreement to memorialize it. The other one, I think we're disparate on the Verizon Records protective order, and the Celebrate Extraction protective order, I think we have it pretty close to agreement. So I don't want to say anything about that in open court.
All right, why don't we approach sidebar?
Thank you.
Thank you.
All righty then. Yo, I know a little bit about this. I don't know as much as others. Y'all, I am going to post this document on our Discord because it's 57 pages. I don't want to sit and read 57 pages if I don't have to. That's a whole heck of a lot. I may have a breakdown. No, I'm not going to do that. Okay, I do. That drives me crazy. Okay, so here's the breakdown. The allegations. Oh, wait. Never mind. That was an older one. But I'm going to put this on our Discord because y'all, this is a lot. I need to make a new folder. Happy birthday to Toxic and Karen. I mean, Christy. Happy birthday, y'all. Why is my computer freezing? Shouldn't be freezing. Oh, that's why. Text channels, add. What was his name? Already starting the sidebars. I know, right? Really? Okay, I've created the channel, guys. I'm going to download that document into that channel. Y'all can read it and go to our Discord to do so. And there it is. We are waiting for Turtle Boys to pop back up. I guess the judge was just coming in to get something. We are now at an hour, 38 minutes, and right about now. So we're an hour, 38 minutes. I wonder, I think they're just trying to get everything right. There's a lot of, if it's not this, it's that. The lessers, I personally find that the lessers really start killing the juries. How are you today, Miss Ronnie? How's the weather? I was right, y'all. The worst part of the hurricane will hit from Cedar Key, northwest to Horseshoe Beach to Jenna. The eye is going to hit north of Cedar Key. I think Horseshoe Beach is going to take the brunt of this storm. So Cross City, maybe High Springs, Branford, Fort White, and then it'll hook up to Live Oak. But yeah, this is going much further southeast than they originally anticipated. Gosh, everybody, I'll play this again while we're waiting. This is the wonderful game show that
hang out at the mall. Now, what do you do while you're
was
just
on.
hanging at the mall, Sarah?
Well, check out guys and spend money.
Check out the dudes and spend the cash.
These two teams go head to head.
Let's greet the video jocks on today's show, starting off with the red team. John and Sarah, say hey! Your partner there, Sarah, likes to hang out at the mall. Now, what do you do while you're just hanging at the mall, Sarah?
Well, check out guys and spend money.
Check out the dudes and spend the cash. Your cash or like parents' cash?
Mine.
Oh, okay. Listen, hey, John, you pulled out the face-off for your team, so that means red team, you have 25 points, and you get to move the big M. Yes, red team.
Naval orange.
Naval it is. Yeah, there you are. And you are up to 100 points. And you still have control. The audience likes the navel thing. It's the belly button lint thing. Move, Mikey, please, red team.
Down.
Belly button
Andrea,
lip
tell me
sync?
what they just snagged. Say
What?
cheese, red
Belly
team.
button
That's
lip
yours.
sync?
And you get to move. Oh, yes, red team, do you have a?
C.
See, conga is it. Yes, red team, you have the goal. And the 50 points. And Sarah of the red team gonna play the face-off Crater Ranger. You have to avoid craters and explosions and other pitfalls. In positions, please. Ready, set, go. And at the end, it is going to be the red team pulling it off. All right, head back over and play some more arcade. All right, Sarah, you steered yourself there to the face-off victory. Red team, you pulled off the face-off, and you're up to 200 points, and you get to move Mikey first in round 2. What direction? Video challenge, yeah. Starting off video challenge. Round 2 is going to be playing.
I am.
You're going to play Sarah? Okay, John, hang on to the board. Sarah, which one of those 4?
Robo Army.
Robo Army. Head down to Robo Army. Come on with us, John. Robo Army. I turn around Sarah. Ready, set, go. Right, that's her Robo Army. Oh, she got knocked down. Couple more will do it, maybe. Oh my goodness, not enough time. Listen, you played a great game. Time ticked a little too much. Okay, Sarah, we're gonna have to take the 50 points away. You're down to 150. You're still in the lead, but control is now in the hands of the red team. Move, Mikey, please.
Down.
The Ring of Fire is the ring of active volcanoes encircling what ocean? Yes, red team.
The Pacific.
That is exactly right. You have the goal. 100 points
Hey,
to your score.
Luigi.
Red team, 250. You are going into the video zone. Yeah. Please come on back, because when you come back and we come back, John and Sarah heading into the zone. They're going to try to battle Scortia. Hey, she's a hot cookie. She's tough, but I think these two can extinguish her flame. And hey, I'm here with Sarah and John, and they're psyched to go to that door into the video zone to battle Scortia. Now, you have 1 minute to get through all 3 levels. After the first 2, with the time left, you will go and battle Scortia in the wizard level. Now, for each level you get past,
You are so welcome, Squeegee. It was awesome. I thought you did a great job. I did not get my homework done. I did not get the test done. That'll have to happen tonight. No choice. Tonight's the deadline. I just couldn't stay off your live. I couldn't. Y'all. Hey, Toxic. Thanks for coming back. We have Turtle Boy's trial on one screen. We got the jury deliberations on another screen. Waiting for that. And then we are now watching again this fabulous footage of the young Sarah Boone.
you will get a great prize. For each item you pick up, you will get $50. Here is your challenge. All right, into the zone there with you and extinguish Scortia's flames. Go through that door. Yeah.
This
All right,
is so
Sarah's on her
silly.
way.
It's a green
You can ride
screen.
along. That was a great time. Hey, she's up. Bam, there's one ring. She's staying low. All right, bam. Oh, she missed the ring at 40 seconds. She's down to 2 units of power. She got all of her power back now. Great. Bam, there's 2 rings at 32 seconds. Oh, at 28 seconds. All right, bam, 3 rings. They're going to go on and try to battle Scortia now. They're at 22 seconds. Down to 2 units of power. There's 1 orb. They're down to 1 unit of power. There's 2.
So stupid. That is not much to be very prideful for. That is so freaking stupid. Sorry. Just can't. I know, I kept saying, I want to do my homework. I'm going to hear my homework. Yeah, you had a really good first live. Really good and greatly attended. Oh, this week has been boring. Yeah, she won a trip to space camp here in Texas. Woo! Well, I'm watching this hurricane, and I guessed right. I'm going to boast about it. And a boom box. That's right. Ping pong table. Woohoo! Man, those boom boxes, I had a long, narrow one, but those really big, and I mean, where your arm, you literally, your fingers just hit the play buttons and the rewind, and you walk like that, and you're all boom, boom. Yeah, it was stupid. Fly me to the moon. Gosh. Yeah, it's crazy. But we are watching for the verdict, and then we are waiting. They had a few words in the Turtle Boy trial, and then they decided, oh, I think we'll just have a long sidebar, yeah, Anna. So that's where we are on that. Yes, how are you guys doing, Trial TV Live? We hope you stay safe. I don't know what city you live in, but I nailed it. I told them that it was going to fall between Cedar Key and Horseshoe Bay and up near Jenna from day one. And it is. That's where it's going to be. We're watching it now. It's on right now. Nothing's happened. They came in and talked about a few motions, and they were going to hear those later, and then they asked for a sidebar. So Trial Live, get it going. I'll switch over to your feed. Right now I'm on Young Jerks. But if you get it up and going, I'll watch it on your feed. We'll use your feed. But yeah, I don't Trial TV, where are you? We are on the east side. Okay, what do you mean the cone? The bottom part? Yeah. Yeah, I get to prepping. Oh, east side of the cone. Yeah, I got you. I'm tired. Yeah, but understand that cone is not going. I mean, the eye of the storm is going much more of a kind of an eastern northeastern route than the north. It Yeah, cone of destruction in the path. Yeah, I figured it out. So, it's kind of curving more this way than they thought it was. They thought it was just going to kind of do this and that and hit more up near Tallahassee, right in that area, but it's actually going to hit down north of Spring Hill. So Tampa's getting hammered, going to get hammered. Spring Hill, Gainesville is going to get it. Tallahassee's going to get a lot too. They're on it's like direct north. So, yep. It does, but I think I'm looking at the projected path, and at 8:00, it is right off the beach of Horseshoe Bay. So I think between the circle, or depending on how big the eye is, definitely between Horseshoe Bay and Keaton Beach are going to get the eye. Unless some unusual, massive change in trajectory, which I'm not seeing, and the eye is still quite formed. Part of me wishes I was there with the Red Cross. I miss it so much, guys. I really, really do. I miss it a whole lot. I miss doing all of that stuff. My job was disability integration, taking care of all the disabled people. If you were disabled, you were my responsibility. Oh, y'all, that felt real good. My son has not been feeling good, achy body, headachy, and guess what? That's kind of how I'm feeling. Where is that camera at? literally, is that a city camera that you're hooked into? Yep, getting pretty choppy, and that wind is nice and strong. Whew, that's making me nauseated. Um, I don't know why people are still driving in it and have their vans parked up there. It's came up in downtown Florida. Well, I don't understand why people are parked on the side of the road watching this. I'm not trying to be mean. I've just done too many rescues to know what the hell this can do. I really hope you guys stay safe. Trial TV Live, if you go down, I don't mind streaming whatever your watchers would like for me to stream. I have nothing that I'm connected to at this moment. So why don't you email me and let me know if y'all go down. Yeah, I know, right? Stupid is as stupid does. Email me what if you go down and it's y'all can't go live. I will be happy to stream whatever you were streaming. I can do multiple streams with my streaming program. So I can stream for you guys and then even if it's 2 or 3 different streams, whatever you want me to do. I'll be happy to help bridge the gap for you. And I'll make sure that people know that I'm streaming for you and that way they can hop on and not lose what y'all are watching. So let me know in the comments if you would like to do that, and if so, email me what you would like for me to do. I mean, even if that's the case, email me your logo and I'll throw it up on the screen. Actually, Trout TV Live, can you email me your logo? Because I would like to, when I have trials and I have to cover like I am now with the interpreter, to be able to throw it on another part of my screen and I can set that up. Because that way I can, and email me what you want me to stream. And I will go in and make sure people know that I'm streaming on your behalf. And then definitely I need your, yeah, check on a friend. I need your logo so I can pop it up when we use your lives. Right now we're at 1 hour, 53 minutes and 42 seconds in deliberations. I would guess between 3 and 4 hours because they had a lot of lessers they had to contend with I don't agree with. Trial TV Live, do you know, or Squeegee, do you know how to set up the ATM Mini Extreme? I'm having a hard time getting a hold of Mr. R.A. I need to get that up. My problem is when I download the program, it tells me it's missing something. Yeah. I that's why I live where I live. I mean, we get heat and drought and sometimes flood. That's the worst of it. But we deal with a lot of scorpions and weird, crazy stuff. But I've been through too many hurricanes and tornadoes and other fires, and I no bueno. No, don't want that. Yeah, it looks like the eye is literally going to hit just north of Horseshoe Bay, right where 360 on Highway 361, I think runs into the beach. And it looks like that's going to happen at, I'm looking at the predictions, National Weather Service, and and special radars that we use for storm chasing. Does it say what? No, it just looks like the highway ends. And it looks like that eye is going to hit within about 9:30. There's nothing much. It's north of 351, and I see Highway 361 going south, and then it just kind of dead ends. But it's going to hit. It's going to hit directly between Jenna and Horseshoe Bay at 9 o'clock. Probably 9:15, 9:30 at the max. Literally about 9:30. Literally. Oh, that. I can try it and let you know. That would be no problemo. Give me a second. This beeping is driving me nuts on that thing. I'm turning it off. Sorry, not sorry. Let me go see what I can do. Support. They do have a new download that says today, so we'll see if it works. I'll give it a second. Aiden's Zoom is, they're on a big sidebar right now. Yes, I do believe it is. Young Jerks has it up on their site. Do you want me to? Yeah, give me a minute. Let's work on that. Oh, it is a webinar. Recording of this webinar is prohibited. Okay. I've got about every window under the sun open right now. I can't see comments. Let me go back and see if I can find you guys. Did I lose my feed? Nope, we're right there. I know. I'm working on it. Working on it, working on it. I have Turtle Boy. I mean, I'm sorry, the Young Jerks is the only place I can find it. Seriously. I'm searching for you, hon. No, I'm trying to find it for you, babe. Um, I'm not finding it. Where's Young Thugs getting it from? Yeah, definitely. Okay. I'm trying to find the court feed. I don't know how to find that court feed. I'm really struggling. Anybody else know? I'm struggling, y'all. Oh, yeah. Really? I know what I need to maybe search. I'm closer.
Thank you, everyone, for the patience. All right, other than the issues we addressed at sidebar, what can we do, what else do we have to do to address and help us move forward on these cases?
Your Honor, today I filed a motion to suppress for unreasonable delay, and I would ask for a hearing date on that. Whatever time counsel needs to respond is not a problem from where we sit. The way we see it, Your Honor, that issue needs to be handled before any of the Commonwealth's motions relative to taint teams, and we decline also to accept the offers from the Commonwealth to receive back the discovery. The Commonwealth filed a motion that I'll give you the title.
I can't.
Okay, great, thank you.
Oh, snippy much.
I think it was in the form of a letter to the court.
Is that the letter? I believe I got a letter this morning.
No, it would be a letter to Judge Callahan.
Okay, I'll look at that.
Judge, I have two actual motions that were filed.
We've
last
now
time.
hit 2 hours,
Commonwealth
10 minutes
response to
in the
court's
jury
inquiry
verdict
relative
watch.
to providing the defendant with copies of seized electronic devices.
That would be it.
That's basically a list of conditions that they want us to comply with that we think are completely beyond the pale, and we decline to accept those conditions. And instead, we filed the motion to suppress for unreasonable delay. It's been over 300 days since these devices were seized, Your Honor. And if you look at the case law, I'm not going to argue it today, Judge, of course, but if you look at the case law, it's well beyond the pale. So our position is that obviates the need for spending any time or taxpayer money on a taint team for a phone that should be returned right away for unreasonable delay.
You want to do the motion to press first?
Correct.
What do you say to that?
No.
Okay, and why?
Well, I think Mr. Bradel has it backwards. The normal order of things is that first the search is conducted, and then if evidence is found, the defendant brings the motion to suppress. I'm happy to have the court, or it doesn't really matter whether I'm happy or not. I don't have any choice. I'm willing to have the court, except that the court will hear and act
Google
on Mr.
Canton,
Bradell's motion. And
Mass,
I appreciate the
Court,
offer to
Zoom
set it at
access.
a
See if you can make sense of it.
convenient date for myself.
Got 5 things going on here.
The history of this is, Your Honor, that going back, I think, 1 or 2 hearings ago in front of Judge Callahan, Mr. Bradel raised the issue that the Commonwealth had not moved forward on examination of these digital devices that had been seized by his client. And he pointed out that he had spoken to Mr. Mello sometime earlier, that Mr. Mello had made a proposal as to who would serve as the electronics expert on the taint team, and that he was agreeable with that. And Mr. Bradel argued the law of taint teams. I, for my part, conceded that there had been an inordinate delay. And I went into the extenuating circumstances, which I won't rehearse again today. You've heard some of them at sidebar.
Yes.
And at that point, since Mr. Bradel had also made a pitch for return of his client's electronic devices immediately, supposedly because they were necessary for his journalistic so-called pursuits, I was asked by Judge Callahan if Commonwealth would consent to return copies of those devices, and I replied that we would not, but that I was willing to take another look at that issue. He asked me to notify the court after I had taken that second look, so to speak, and I did so on the letter that the motion that Mr. Bradel just referred to. This is the first response to that I've heard from Mr. Bradel. I'm sorry he's not happy with the conditions, but in any case, Judge Callahan also asked that I file, as I said I would, I think by August 18th, I'm not quite sure of the date, a proposal to set up a taint team, and I complied with that order, Your Honor. I may have been a day late, I'm not sure, but not much. And Mr. Bradel has had that motion now for a couple of weeks. I find it ironic, in light of his complaints about delay, that 2 months after he was served with that motion or thereabouts, he now comes into court, files a motion, demands that it be heard before the taint team motion, thereby pushing off the whole process of examination of the devices until after I have time to respond, court has time to schedule a hearing, we have time to argue it, and the court has time to rule on his motion to suppress. I would suggest to the court that all that's going to do is delay the case unnecessarily. I would ask the court to allow the Commonwealth motion to establish the taint team, and I think the usual remedy applies. If the court then goes forward And in due course, here is Mr. Bradle's motion to dismiss for undue delay, and allows that motion, then the usual remedy would apply. The evidence would be suppressed, and Mr. Bradle hasn't lost anything. On the other hand, if the court postpones action on the taint team motion, and I thought we were in agreement that a taint team procedure should be employed. Indeed, the Commonwealth stopped all examination of Mr. Kearney's devices because the defense requested a taint team procedure, and we agreed to it. If we do not go forward on that, every day that we don't go forward is going to add at least 3 months or so, because as Your Honor knows, there's a whole process of examination and opportunity for the defense to object and so forth and so on before the fruits of those search, whatever they may be, are shared with the Commonwealth, and then the Commonwealth designates those pieces of evidence and turns them over to the defense.
Thank you.
Judge, if I may, thank you. I appreciate the Commonwealth's newfound desire to get this done, but it's too late, Your Honor. That's the essence of the motion. This is not an agreement between the parties, Your Honor. This is the government's legal duty under the preventive medicine case to, upon being notified that those materials have privileged items in the phones and computers, it's their legal duty to come forward to the Superior Court. It's their legal duty to include the defense. So in this case, prior Prosecutor Mello completely took a different tack. And the emails are quoted in my motion, Your Honor, that he opposed a taint team. He refused to give the devices back. He refused to give the data back. And he already committed delay beyond what all the case law allows for in terms of unreasonable delay before Attorney Cosgrove even got on the case. All the cases that you'll see cited in my brief in terms of unreasonable delay, they hold it's like 20 days is unreasonable delay, 30, 40, 50 days is unreasonable delay. We're over 300 days here, Your Honor. And the government acknowledged that they needed to do further search warrant work on this case. Mr. Cosgrove acknowledged it himself a few months ago in open court as well. Detective Tully acknowledged it on page 31 of his search warrant ending in number 70. He said, I will file further search warrants. We haven't received anything. And here we are at over 300 days. This case is the most extreme case in the body of unreasonable delay case law. There's no case with more time. Further, Your Honor, the nature of this case is such that Mr. Carney's been deprived of source material, First Amendment things, attorney-client conversations from several other bits of litigation that he's been involved with his attorneys in those cases. He hasn't been able to get into this stuff. I've given the government notice of this at least 2, if not 3 times, that we need these devices. We can't get the information. The information in these devices concerns source material, and here's the hook, on the very same police officers that took it from him. He's investigating them. And under this case, they took his devices in what can only be a blatant conflict of interest.
Just putting a seed in the head.
They've sat on this stuff for over 300 days. It's coming up on a year now.
Maybe next week.
And they haven't filed any of this stuff. We haven't been served with anything.
Please reach out.
So I think the Commonwealth, frankly, is happy to just sit on Mr. Carney's devices to stifle his further investigation. And that's the real motive for the Commonwealth, just holding on to these devices and not doing anything. So I spoon-fed this right to ADA Mello in October of 2023, giving him the preventive medicine case. And he rebuffed it. And they do that at their own peril. And the time is ticking, and they never did anything, and here we sit. So there's no question, Judge, that it would be an absurd waste of time to set up a taint team and start paying experts to start looking at the things, to only then, after the fact, say, oh, this has been gone on for too long, it's an unreasonable delay. There's no reason why the court can't handle that right now. That happens all the time. And so I would ask that the hearing be set up. I don't see how the Commonwealth has any argument whatsoever after 300 days of sitting on my client's devices, refusing to give them back, stifling his journalism, that where they could say there's any good reason why they should keep going. So I would ask that we proceed right to this motion to suppress at the earliest possible date, Your Honor. Thank you.
Thank you. All right, so I'm going to take the issue regarding the taint team under advisement. In the meantime, we are going to set a motion to suppress date as well as a date for the motion to disqualify. I'm thinking motion to suppress in November, motion to disqualify in January, but that's just kind of putting it out there. What are everyone's thoughts on those November and then January?
That'd be fine with me, Your Honor.
Attorney Cosgrove?
Well, January is fine with me for the motion to disqualify. I would rather reserve my answer on the applicable date for the motion to suppress. If Your Honor winds up ruling that that is to go forward ahead of consideration of the motion for the taint team, I don't want to put it out to November. I'd rather do it within a couple of weeks. If, on the other hand, Your Honor decides to allow the motion, then I'm in no particular hurry, having already expressed the view that the remedy of suppression is fully available to Mr. Bradel whenever the motion is heard, if it turns out to be allowed.
Is there any reason why we can't sort of do let's just say for sake of argument, I allow the motion for a taint team and that starts, we could also do a motion to suppress. I'm just trying to move things along a little bit rather than delay.
That's what I would suggest, Your Honor.
Okay. All right. So let's work backwards. January date for the motion to disqualify. When works for Madam Clerk?
We are wide open in January. No Tuesday.
No Tuesday. Okay.
How about January 9th, the Thursday?
God almighty, how long are they going to drag
this? Do you
this?
anticipate that this would be an evidentiary motion?
It's an interesting question, Judge, whether this is an evidentiary motion, and I've been thinking about that, and right now I would ask for 2 or 3 hours just in case.
Okay, we'll put you on in the morning then.
Right.
Okay, that day will not work. We'll have to do a Monday or Friday morning.
We're talking, forgive my confusion, I'm a little slow in the afternoons. We're talking now the motion to disqualify?
Yes.
All right, I will definitely want to call at least 3 witnesses.
Okay, then we'll just definitely do it 9 o'clock to give ourselves the full day then.
Okay, one moment.
All right, so we have a day that works for full day.
That's insane.
So that's January 9th, Your Honor?
Actually, we're going to pick another one to give us more time. That'll give us a full day.
We have to do a Monday or Friday morning start date. Right out of the bat, January 3rd.
I know, this is insane.
Actually, that'll be the last day. How about January 10th?
That's fine.
Yeah. Sounds fine? Yeah.
All right, January 10th at 9 a.m. for the motion to disqualify. Right now, I am going to pick a November date. The motion to suppress, counsel, would you anticipate calling witnesses on that or just arguing delay in general? What are your thoughts?
I think, Judge, that'll likely be a non-evidentiary motion.
Okay.
I would ask for maybe 2 hours just in case we do have to call 1 or 2 witnesses.
Okay.
But I don't think so.
Okay.
And I would certainly advise the court and counsel if I decide that I want to call a witness.
Right.
I would not anticipate
Look at her. She's like,
calling
I am
witnesses
so over
for the
this.
Commonwealth, but if I decide otherwise, I'll advise both the court and Mr.
Okay.
Bradel and Mr. Bradel.
Thank you very much. Why don't we put that on for 9 o'clock as well, again, just so we're not feeling rushed at 2 to get it in before 4.
Judge, could we do the week of November 18th?
I'm just checking the judge who I anticipate being here, Judge Kropp. I'm just checking his schedule.
We're actually available October 25th, and the next available date is December 2nd.
You guys, can we do December 2nd?
Yes, who would be sitting here on December 2nd?
Likely Judge
Sorry.
Kropp. Judge
Yeah.
Kropp would be
None
here.
of your business.
The short answer is yes, but I do have a trial scheduled that I don't expect to go. I just wanted to put it out there. I think it'll go away, but I do have a trial that day, but I think I can do it.
All right, Attorney
Well,
Cosgrove, you want to say
the
something?
other issue that I would raise in light of my last appearance here is that Judge Kropp is a judge who sat here regularly when I was sitting as a Superior Court judge in Norfolk County. So I don't know if under those circumstances, Mr. Bradel would be inclined to bring another motion to recuse. So I just want to surface that issue now.
Thoughts, Attorney Bradel?
I'd leave that to Judge Kropp, Your Honor.
Okay, so you're not going to make a motion, but if he decides to recuse himself, he can. Okay. Why don't we, can I say counsel sidebar about this?
Oh, holy crap. Poor guy. This is ridiculous. I really feel bad for him. I really do. This sucks. It really does. And I feel bad. That's just the way I feel right now. I'm just, I don't understand. I mean, this poor guy is this just drags on and on. It's like that song goes on and on, my friend. I mean, really? That's horrible. I I'm a little flabbergasted, honestly. I'm trying not to be all dramatic and everything, but this is really surprising. I'm a little perplexed. And while I'm sitting here being perplexed, I'm cleaning up my screens. I've had so many things open on my screens. I have 3 screens, so I've got a lot of space that's open. So I'm kind of like, this is not fun. I feel bad for him. I really, really do. And the fact that they're going to do this is preposterous to me. And I'm kind of confused what he's actually being charged for. I'm going to put this, rewind it because I accidentally.
Otherwise, I'll advise both the court and Mr.
Okay,
Bradel and Mr. Bradel.
thank you very much. Why don't we put that on for 9 o'clock as well, again, just so we're not feeling rushed at 2 to get it in before 4.
Y'all, I'm getting a little closer with this paper. Oh my gosh.
Judge, could we do the week of November
Yeah, but
18th?
I'm just checking
trying
the
to-
judge who anticipate being here, Judge Crop. I'm just checking his schedule.
Did he really intimidate them, or they just crying wolf because they didn't want to? I don't understand why they're doing this to him.
We're actually available October 25th, and the next available date is December 2nd.
You guys, can we do December 2nd?
Yes, who would be sitting here on December 2nd?
Likely Judge
Sorry.
Crop. Judge
Yeah.
Crop would be here.
The short answer is yes, but I do have a trial scheduled that I don't expect to go. I just wanted to put it out there. I think it'll go away, but I do have a trial that day, but I think I can do it.
Gus,
There we go. We're caught up now. My bad. Okay.
all right, so for scheduling purposes, we're going to do that December 2nd date with caveat of what we talked about at sidebar for a motion to suppress, and January 10th, 2025 at 9 a.m. for disqualification. I will rule on the taint team issue. And as far as that other issue regarding the first issue we discussed, I did allow the motion to allow Attorney Cosgrove and myself to look at them, take a look, counsel, and then see if you have any further objection. I think once you look at them, the three of you can probably come to an agreement on that, but if you can't, I will then rule.
Judge, I would like to just leave the building today with the celebrate extraction protective order language worked out.
Okay.
I think my brother's indicating to me that he can do that.
That sounds great. I can, please discuss further. Just, if you come to an agreement, put it on a yellow legal pad that is legible, and then I will sign off on it, would be great. I do believe we have an interested party who is here who may wish to address the court. I'm just checking on that. Is she? Counsel, please.
at 9 a.m. for hearing on the motion to suppress, and January 10th, 2025 at 9 a.m. for the motion for disqualification. Thank you.
Thank you very much, gentlemen. I'll be here for another 45 minutes or so if you want to get me something. If not, you can get it to me tomorrow. I'll be on trial, but I'll be here,
Thank you.
okay? Thank you, everyone.
Thank you, Your Honor.
All right. Oh, boy, I think that you entered that forum. Thank you.
Madam Clerk, would you mind getting me a copy too? Thanks so much.
One 11:34 a.m. 1:11:34 a.m. 7,000 pounds, 25 miles an hour. 1:11:34 a.m. 7,000 pounds, 25 miles an hour. That's what this case is about. On May 7th of 2023, at 1:11:34 a.m.,
The defendant, William Bud Ackerman, drove his 2019 Ford F2.
Why didn't anyone tell me my mic was off? How long has it been off? Dagnabbit. Okay, we're going to watch this trial here. It's another jealous husband murder trial, opening statements, and it deals with another vehicle, 25 miles an hour. Sound familiar? I'm so sorry my mic was off. The Kathy Bates' new Madlock show is freaking awesome. She's amazing. I don't usually like to watch those kind of shows very much. Part of the reason is because I'm not free enough to watch every week. I watched the premiere last night on YouTube. What caught with 10 minutes, I was hooked, line and sinker. I was like, oh, this is going to be good. And the ending through the end of that program last night threw a curveball that you just don't expect. It is a fabulous first show. So I'm going to watch this series. I am hooked. I'm beyond hooked. It was amazing. And I don't go around boasting about TV shows very often because I just think everybody has their own opinions and everybody, has different styles and tastes, and I don't like to get into that. But oh my gosh. I got to be honest, sometimes a lot of the stuff Kathy Bates did was scary and I don't do that. So she was not somebody that I really would follow. But oh my gosh. Oh, don't tell me. We're going to have to wait on this series. We had the Kohlberger had a hearing today. I didn't even know about that one. I've been so involved with everything else. So let's see if I can find the live Kohlberger hearing. Standing by. Okay, we're standing by. So we'll go back to that other one in a minute or tomorrow, whatever. But we got the Kohlberger hearing coming up. Really? Y'all, this is getting crazy. We've had so many things happening today. Hannah Kohlberger, Turtle Boy, we're watching this. It's been a busy day. But we're here for it. All right. So now that's up and running. I'm waiting for that. Is physically in the courtroom today. That's freaking cool. So I get tired of shows like Madlock, and I loved it. Angela Lansbury's show, loved it, but it gets into that same old predictable, boring, you kind of can guess what's going on every week. This one kept me going, and I had no idea what was going to come next. Absolutely love it. yes and no. But we'll do the hearing, definitely. I think I wanted to cover all of it, but we had two conflicting cases at one point, and I had to choose. And that's hard because I didn't know I could run two lives at the same time. So that's awesome. But that said, so guys, if you like lawyer that kind of stuff, you're gonna love this because there was curveballs every 5 minutes. It was awesome. And I don't ever boast, and I'm boasting. All right. So I'm going to keep that up and going. Gosh, y'all. So, what was I going to say? I'm almost willing to do a watch party on Discord for that show. I would. Toxic, let's talk about it. Because that show is freaking awesome. For those who can't watch it, I'd do a watch party. It's awesome. I can't wait. I can't wait for the next one. I'll probably rewatch it. There is a boat speeding down the flooded Tampa streets. Okay, Tampa streets are flooded, and the boat is speeding down it. It's got a political flag on it. It just looks funny. I won't say which one. I'm not going to get in a debate. Wow. We're waiting. State of Idaho, we're waiting. Yeah, I will go back and find out when it's on. Yeah. I will go and find out when the first season airs, but I would love to do like one day this one that just did, and then when they do the show live as us go live. Because it's fabulous. Loved it. Sorry.
Be seated. All right. Good afternoon. This is State v. Koberger. I want to go over the appearances this afternoon on behalf of the state. Would state attorneys please represent themselves for the record?
Thank you, Your Honor. My name is Bill Thompson. I'm the Lake County prosecutor. This is Ashley Jennings. She's my senior deputy. And then we have Mr. Nye and Ms. Bailey.
Do you want to do it Sunday?
And then we have
Or
support
Saturday night?
Right,
You let me know what's a good night for the premiere that we
Ann
can
Taylor,
host.
attorney for Brian Koberger, Elisa Massa, and Jay Logston, counsel for Mr. Koberger as well.
Thank you. All right. Like to tell you I'm happy to be here, but why start with an untruth? I am accepting of my responsibility to be here. I want to go over with you some expectations of mine, given that I don't think any of you, other than Ms. Massoth, have appeared in front of me before. When you file memorandums of law, briefs, etc., please provide a Word copy by email to my staff attorney. After today's hearing, you may get that from staff here today. Today, I know there was an issue that was brought up with respect to Mr. Koberger's attire for today. I did issue an order yesterday permitting him to appear in civilian clothes for this hearing only.
Oh, how nice of you.
That is a matter in terms of future hearings that we will take up in a closed hearing the day of, but in advance of whatever our next hearing date will be. My intention will be that Mr. Koberger will not be present for that hearing because part of what we will be discussing are security measures. I expect to hear from the transport deputies and the bailiffs regarding security issues that they want to address or that I have questions for them about, so that I can make an appropriate ruling in terms of his appearance here, but weighing that not just against, of course, his rights, but also against the needs of security in this case. I do expect, as it probably will come to no surprise to you, for you all to get along. I understand the stakes in this case are as high as they can possibly be in any case, but you are professionals. You have taken oaths, both as of officers within your jurisdictions,
So
but
act like
also
it.
as attorneys before this bar. So I expect at all times for you to remain civil to one another, that you not engage in personal attacks, ad hominem attacks, that you not engage in theatrics, not misstate the facts or the law to the court, and that when you cite arguments in your briefs, if there is contradictory precedent, I expect to see that.
Come here, Cindy.
I appreciate in advance what should go without saying that I've just said in terms of your responsibilities. But again, I just want to highlight that because I understand when the stakes are high, sometimes victory seems to be the objective when our first objective is to conform to the oaths that we've taken as members of the bar, as officers of this court. All right. I do have some matters with respect to scheduling that I want to go over today, but before I do that, I'd like to hear from you with respect to the matters that you either need to make me aware of or want to make me aware of. The other thing before I do that, though, I do know that Judge had entered a non-dissemination order. That still remains in place. And unless I, for some reason, remove that order, it will stay in place, and I expect it to be religiously adhered to by all parties.
What happened to
Counsel,
Judge?
victims, counsel for the victims. I will not tolerate violations of that. Likewise, I know that much of the evidence in this case has been subject to orders sealing under that dissemination order or otherwise have been sealed by the court. I likewise expect everyone that has access to that information, whether it's sealed documents or information in sealed hearings or the information itself in the documents, to adhere to the confidentiality expected as it relates to those. Okay, that's my one and only lecture for you for the remainder of this case. With that, let me hear from you. We'll start with counsel for the state.
Your Honor, I don't know that we have specific questions we want to propose today. We're looking forward to hearing the scheduling. I think that's going to drive for us, particularly the distance involved, any questions that we may have. I appreciate what you've already mentioned to us, and we will certainly honor all of that. Thank you, sir.
Taylor?
Thank you, Your Honor. There are a few issues that I wanted to make the court aware of as the court decides on the scheduling order. We want the court to know that our team has been working towards the June of 2025 trial date that had been issued by Judge in the case. But in candor to the court, I need to let the court know some issues that have come up that we face that causes me concern. First, I think the court's probably aware of the vast amount of discovery that's been exchanged in the case by reviewing the record. But since August, we have received about 398 gigabytes of new information, and I can tell the court that nobody on the team has read every bit of that yet. So there's a vast amount of discovery to continue to go through, and I wanted the court to be aware of that. The second thing is that during the course of this case, we had an expert that we were working with, and that expert passed away. We have been able to refill that role to have a new expert to do the work that that expert was hired to do, but we are not progressed to the point that I'd hope to be through no fault of the new expert. The court should be aware of that as well. And last, as the court is very well aware, the system of delivering public defense is changing next week. As appointed counsel in the case, I do not have a contract yet. Nobody on my team is under contract for this case. I'm concerned about what that means, and I thought the court should be aware. Further, we have been able to access funding to help us prepare this case through Idaho Criminal Rule 12.2. At the current time, we're working with about 25 experts and investigators to prepare the case. I don't know if 12.2 will continue to be the way to get funding for those experts and investigators, or if that's changing. And I thought the court should know those things. Thank you.
Thank you. So I am hopeful that Mr. Frederickson will ensure that the contract is available for you and your team next week. I have no control over that, of course, other than to, as it relates to who I permit to withdraw from this case or not withdraw from this case. As to 12.2 funding, my understanding is, and I've had a discussion with Judge Munson, who has been serving, as I understand it, as what we refer to as the money judge. I've asked him to remain in that capacity at least through the transition to the state public defense system in next week on October 1. My understanding is, and perhaps I will come to find out something different, but that once it goes to that system 12.2 as it relates to public defense funded attorneys on contract seeking 12.2 funding, that's no longer a thing, that would come through the state public defense budget, essentially. I guess we'll find out if that becomes a problem down the road, but that's my understanding, because that whole system that 12.2 is based upon is coming to an end. So given your statement about the trial date, my proposal to move this case forward into May is probably not going to land well with you, but that's what I wanted to talk about, is the timing of the trial. I'm concerned with a trial as currently set for a number of reasons, but first I want to find out from you, as you sit here today, what that trial looks like in terms of the number of weeks of trial, starting from after a jury is selected through the end of the evidence and before any potential sentencing phase. So what are your estimates of that?
Your Honor, I think it would be a fair estimate based on what we know at this point to have a month and a half or perhaps a bit more just for the evidence for the guilt phase of the trial. I say that knowing.
Is that just your evidence, or does that include defense evidence?
Well, I was just getting ready to say, I say that understanding or acknowledging that Ms. Taylor has estimated 2 to 3 months total. I do not know. We do not know what the defense has in mind for their case right now. So all I can speak to is what we anticipate for ourselves. But I would think the state's evidence in chief should be able to come in a month and a half or so.
Okay. Ms. Taylor?
Your Honor, we estimate 4 weeks for the defense portion of the trial case.
Of the guilt phase?
Yes, Your Honor.
So 10 weeks In terms of if there is
Wow,
a,
another Karen Reed.
penalty phase, should the defendant be convicted of one of the statutory qualifying offenses, how long do we estimate the penalty phase being?
Your Honor, from the state's perspective, I believe we're going to be relying heavily on the evidence that's introduced during the guilt phase, and the additional evidence that would be brought in, unless there's something we learned from the defense about their experts. It is probably taking no more than a week.
Taylor?
Wow.
Your Honor, I would estimate 2 weeks for that part of any trial.
That's
for our evidence.
For your evidence.
Yes.
13 weeks total, not including jury deliberation.
Okay.
Yes, we do.
So my concern, because this trial is currently set to begin June 2nd and end approximately August 31st, is
Oh, geez.
having it set to run the entire course of the summer. I think we will find to be difficult on jurors.
Yeah.
In particular, jurors who may have children who are out of school, in terms of being able to spend time, go on vacations with them, et cetera. That's one concern. Second concern is with school that typically starts in mid to late August, and jurors or parents who may have kids going off to school, the timing of that through August. And that's my primary concern about that time frame. I had two proposals. One was to start the trial in the evidence portion of the trial the first week of May. And the other would be to start the evidence
True, Ronnie.
in early September. And I'd like your thoughts on those.
I would think it'd be harder in September because you got September, October.
I'm not saying I'm have or necessarily will vacate the June trial date, but I want to look at alternatives here because I am concerned about that spread that takes the entirety of the summer.
Yeah, that would suck.
We hear you, Your Honor. By way of history, the summer, we advocated for that in Latah County because the courthouse is right across from the high school and the summer would have the students gone. If we were looking at the other two choices, we would propose May.
Taylor?
Yeah.
Thank you, Your Honor. Your Honor, I would have to advocate for September at this point, based on the 3 reasons that I gave the court before.
So he's going to go June in the middle.
So I'm not going to worry about the public defense change because I think that will take care of itself. The one thing that you brought up the most, I mean, I understand there's a lot of evidence, but May is not tomorrow. May is many months away. So the one that concerns me that you brought up is your expert. And I'm not asking you necessarily to give away any secrets prematurely that you may have in terms of defense strategy, but can you help me understand this expert if you're able to, and what their role is and what the prospects are?
Your Honor, it's really difficult to tell you much about the expert without giving away a lot. I can tell you that this is a very necessary expert for us to have on board. We've been able to find somebody to fill the role. I'm confident in the person that will fill the role. There just hasn't been enough time to get the work accomplished yet. I know that that doesn't tell the court a whole lot more than what I said before, but
yeah, I know, but still
really feel that that would disclose too much for me to say more. I
Ron,
do so,
but
on an ex
May you have
basis
graduation,
with Judge Monson, our resource judge,
things
but not
of
in a public
such.
setting.
I understand.
Oh, I'd say September would be better.
Do you anticipate being able to
They're not
fulfill your
thinking about all
obligations for
that.
your current
Mother's
expert
Day,
disclosure
you
deadline
got graduation, you got,
that was set by Judge?
no,
No, not.
10 weeks for trial. Then another 3 weeks for the guilty phase if they go there, not including deliberation for the jury. I'm looking at 14 weeks.
With a lot of confidence. I
We gotta
think
add
that the work
jury
is going to
deliberation,
take
14 to
longer than to
15.
meet that deadline.
Depends on how long
I
they
think if
take
we
for
met that
each
deadline,
phase. I
I would
give a
have
week
additional
each, that's
information
15
that I
weeks.
would want to be able to present. And maybe I would have
That's
been
3
stopped
months,
from that.
3.5 months. I think we'll be following this one. Who knows? My little pupper, my dog, my lab, got her head on my toes. Oh, oh, pause. Okay, we're gonna switch. We have a question. She didn't give anybody time to do anything. She just sat down and started reading. No time. Here we go.
So you can be thinking about it. It's a question that says, is there a legal definition to the term agreement relating to section 1, page 5?
I'm having a hard time hearing her.
I don't think it's a legal definition. I think they're overthinking it. Yeah, like it's a common term, right? Common term.
Let me go back because I didn't catch that.
Is there a legal definition to the term agreement relating to section 1, page 5?
What?
I don't think it's a legal definition. I think they're overthinking it. Yeah, like it's a common term, right? Common term.
Anybody get that?
I don't know that I can even say all of that to them. I probably can just say no, or
I think you could say no. The only other thing I can think of is you could direct it back to the part of the jury instruction that says, based on your everyday experiences, you know, that one line, I can't remember where that's at, but I think you know what I'm referring to.
Is there a legal definition to the term agreement?
Oh, to the term agreeing. Lay down. Go, 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 go.
Court's back in session.
so for the record, the jury had a question. Their question is there a legal definition to the term agreement relating to section 1, page 5? Agreement is in quotation marks.
Read what that is, please. We don't have it in front of us.
So I don't think there is a legal definition to the term agreement.
So, I sort of I remember struck as answering a question before with a jury saying that when a word doesn't have a legal definition, as applied here, go with the common, usage. But beyond that, I don't think anybody can comment on that.
Right. Or I can say, no, there is no legal definition, which leaves them with their common knowledge about the word.
I would just suggest to say common, like you said, there is no legal definition. And when there's not common meaning of the word, but everybody.
They haven't said yet. We'll go back to that. Oh, June 1st? Okay.
I think based on.
We'll go back to it in a minute.
For a minute, I think that you can only, I would suggest just saying there's no legal definition. I don't have a problem with saying.
If that's what Mr. Rogers is asking for, that's fine.
With saying something to the term of, everyday usage or, what I was referring to is consider all the evidence in light of your own observations and experiences in life, but that's not really specific to defining a term, so that may not be helpful to them, but I think either way it's phrased, it would be fine.
All right, and I'm just gonna respond to this in writing. We don't even have to bring them out. Okay? There is not a legal definition for the term agreement. Okay. I think the less the better here.
I agree.
Okay. All right. Thank you. Adjourn court.
Okay. Back to the other. We are now 3 hours, 20 minutes. We are looking at the 1st of June, but they have been given the option, possibility May or September.
So
I
I
think
don't
May
have a
is hard
motion to
because you have
extend that date,
graduation.
obviously, and with the changes that occurred, I understand why you didn't file one out of the box, but the deadline, I think, is January 6th, something like that, if I'm not mistaken, for experts on the defense side.
That's one of our deadlines, Your Honor, yes.
There it is.
I guess the state have anything to say in response?
Not knowing the details of the challenges Ms. Taylor and her team are facing, I don't really know how to respond further, Your Honor.
That's fair.
What do you think is a realistic deadline for you to be able to disclose your experts for everything? I'm assuming it was January, all save that one expert. But with respect to the expert you had to replace, when do you think you could disclose consistent with the scheduling order?
Other than the expert that had to be replaced, Your Honor, there were two separate deadlines. One was for trial experts and one was for mitigation experts. And I believe that I can make that deadline other than that one expert.
Can you tell me if the one expert is a mitigation or a trial expert?
A mitigation expert, Your Honor.
And what do you think you need for that mitigation expert in terms of a deadline? Compared to that mitigation deadline was,
I believe it was March. I don't recall the exact.
yeah, so that's a long time from now. So, I have a lot of questions, but I'm hesitant to ask you the questions because I'm sure you're not in a position to answer them currently, given the forum. So, but March is a long time from now.
That it is.
Runner, the time passes very rapidly, and I appreciate the court not asking questions I can't answer. I think if I had an end of April deadline for that one witness, I think we could make that deadline.
Ronnie, do we have any other trials in June of 25? I don't think we do. I'm trying to transfer the calendar. I just want to make sure I didn't miss something. Yeah, that would be mine too, but that's still almost what? Pushing a year out?
So understanding this is a
11 months?
mitigation expert.
And he's still in prison,
Thompson,
right? Or jail?
How concerned are you about getting that disclosure
Good.
Closer to trial?
Closer to trial is somewhat relative. The end of April sounds like it would be on the eve of trial from the date the court is proposing. I think that would be, I'm not sure that would be realistic. And again, I'm not in a position to second guess what Ms. Taylor and her team are representing to the court. She had told us some time back that one of her experts had some health issues, and I think that she did tell us that that person had passed away and they were working on a replacement. If we're looking at a mitigation disclosure at the end of April, I don't know that we could be ready with all the final trial preparation for a May trial. I hate to say that. I feel like I'm cutting my own throat in a sense, but that's realistic.
Well, I can do one of two things. I can set a separate hearing ex parte to explore this further, but I frankly don't know how far that's going to get me. I mean, I can set a date, and my experience tells me that date will be complied with regardless, right? 24 hours in a day, but if you use enough of those hours,
right,
enough days in a row, you get it done if you have to. At the same time, I don't want to put unrealistic deadlines. And so I can do that. I can have an ex parte hearing, or we can go ahead and reserve September. I will throw it to you, Mr. Thompson, is what you want, what you would advocate for.
Yar, could I have just a moment? Your Honor, we would trust the court to do the ex parte hearing, see what's there, and make the best decision, and tell us what the expectations are.
Well, do you want to do that later today, or you want to do it tomorrow? You need more time? You want to come back next week?
Your Honor, I had planned to leave town today. I have other case-related obligations tomorrow. I could do it as soon as this hearing's over if the court has time, or I can come back next week at the court's convenience.
I think we'll probably be finished in here by 3 if we were to do it immediately after. Are you comfortable with that? Does that give you enough time to get to the airport?
Yes, I believe it will, Your Honor.
She's like, oh, if I have to.
We'll give that a shot. All right. If, well, if I move this one way or the other, I will adjust the various deadlines that are in here. I won't adjust the next deadline that you have, understanding that you may be already committed to it, which I think is the motions related to the defense's motion regarding the death penalty, if I'm not mistaken. Is that the next set of hearings that we have?
Those are now scheduled.
I believe that our briefs are due the 10th of next month, with the hearing later this fall and a reply brief deadline for the defense. And we are on track to meet those.
I'm sorry, you were saying, counsel?
Your Honor, I'm guessing the court has received our motions already. I believe we were set for November the 7th.
I think the state's deadline for discovery has passed. Has the state complied with its discovery obligations, including those outlined in judge's last order and other orders?
We have, Your Honor, and in fact, Ms. Jennings prepared a lengthy summary of all the discovery that was filed with the Latah County Court when our discovery deadline hit. It is lengthy, but there's a lot of discovery.
Sure.
We recognize
How
that
much of the, would you say 300 gigabytes?
398 since August 13th.
How much of that is new information?
Ms. Jennings could speak to that.
Ms. Jennings, can you speak to that?
Your Honor, the defense was given, and I'm not sure if this is what they're referencing, but they were given a copy of the OneDrive from the FBI. Most of that was cumulative discovery that they had already received in another fashion. I'm sure there were portions of it that was new information.
Oh,
I
that's
don't. I've not calculated
awesome.
how much of that was new.
She'll
So I
have
can only rely on Ms.
community now.
Taylor's,
Sorry, that didn't sound
what
right.
she's represented to the
She'll
court on
have a
that.
community now, you know, kind of growing it.
Well, I don't think she knows because it doesn't sound like she's looked at it yet.
Ronnie,
All of it
I
did.
went ahead and marked off the calendar, our Google's
all
doc
right.
calendar for 14
Well, I
weeks,
will
starting
talk when
June
we're finished
2nd,
here
which
with
is
Ms.
Monday
Taylor,
for Goldberger.
without
We can,
state present
you should
in a
be able
closed
to go in
hearing.
here and edit this yourself.
Um,
I invited you.
What else do we need to talk about today, or do you want to talk about today?
Yeah, you're one of my contacts. Did you not get the invite?
Nothing comes to mind right now, Judge. I know that there will be plenty of opportunity for other discussions. As far as your meeting with defense ex parte, do you want the state for any reason to stay around, or would you like us to get on the road back to Moscow?
Are you flying or driving?
Driving.
Okay. Well, why don't you hang around just in case we need to, if I'm able to make a decision based on that, I can inform you what that is at least.
Yes, sir. Thank you.
Anything further, other than your your motions regarding the death penalty? Do you have any outstanding motions and the motion as it relates to Mr. Koberger's attire?
Your Honor, there's no outstanding motions right now. I do anticipate filing several motions in the motion to compel deadline. As far as discovery goes, I anticipate there may be some follow-up motions. I, of course, will first try to speak with the prosecutor to resolve those.
It looks like you've already done it, but if you go into our Google Docs,
I think you'll
see.
find I'm
We'll talk
probably
about it later.
more inclined to hear things more
But I have a
quickly
color for
than
trial,
you're
color for
perhaps accustomed
hearings
to
and things
in this
like that.
case. So just be aware of that. It'd probably be more along the usual, 14-day timeline with respect to motions. If there's a lot that needs to be done with respect to them, we can talk about that. But okay.
On that point, Your Honor, as you can see, they're a multifaceted team, and on motions, we try to assign them to specific attorneys. On various motions, would it be acceptable to the court for those attorneys who are not actively arguing the motions to be able to participate remotely, or would you like us to be present? We're happy to do either.
I'm fine with that. I just prefer those that are going to be arguing to be here, just because it makes it easier to have that dialogue. So,
okay, thank you.
The others, if they want to appear remotely, that's fine.
Thank you.
And same for defense as well, depending on what defense wants to do. Okay. All right. Then if there's nothing else this morning or this afternoon, I guess we will be adjourned and have a discussion in a few minutes. All right.
Thank you, Your Honor.
Back in a few minutes once the courtroom is cleared.
All right.
Okay, guys. How long did that last? 40 minutes ago. So we went live. 2:45. I'm trying to keep up with my stuff so we know when things happened. It was important to me that we do that. Oh, no, hearing. It's a hearing. There we go. Save. Okay. Wow, y'all, we are still in a watch for verdict. However, my personal opinion is we may be getting close to the verdict if they're asking questions in that packet. There was like so many sections, and they're further down in this section. So today we've had, we also had the Turtle Boy hearing. Y'all, we've had a lot today. We've done a lot. Oh my gosh. I'm trying to keep everything. I'm trying to be organized. You know how that is. You know how hard that is, right? Yippers. We're going to just, I say it was 2. Okay, save it. There we go. Business. You know how that goes. Okay, so we got that. So I have that marked down for June, but it probably will change. So how is everybody doing? Is it dinner time yet? I'm looking for updates, guys. Give me a second. I'm still thinking about that show last night. That was a good show. I normally don't one who remembers and thinks about those things. So y'all got to go watch the new Matlock. We have a lot of counties who are now declaring state of emergencies prior to the landfall. Y'all, it's going to hit about 9 o'clock our time. It will start hitting. The eye will be fully impactful. That's 11 o'clock. By midnight, the full eye will be on land in Florida. It did fall a little bit south of what they said it was going to initially. Y'all, I'm going to other lives. Give me a second. We just have so much going on today. Oh, let's go look at this.
Yes, sir. And this is what your ring camera showed? Yes, sir. On May
This
7th,
is in the
2023?
fatal incident in the jealous husband murder trial. A ring camera. The new Matlock is fabulous, y'all. Some people may not like it, but I'm hard to impress, and I like it.
I guess you can hear it. It wasn't what I thought it was gonna be. Rory Trimmer is live. Well, everyone's still waiting on this trial. Kohlberger's just ended. Yes, y'all, I'm getting warnings. Helen is a very big and large and dangerous. Oh, I love this. I love this RA. Top Mark Media. This is awesome. Awesome, awesome. That is breaking news.
So, Judge, we are on the record, the state versus Danielle Dolph. We are here for a plea this morning. We're going to start by having counsel identify yourselves for the record, please, starting with counsel for the state. Bethany Rand, please, your general's office. Good morning, Megan.
Good morning.
Good morning, Your Honor. Benjamin Faulkner for Danielle Dolph.
Good morning, Your Honor. David Georgian for Danielle Dolph. Okay. Good morning.
It's only in one ear.
Stephanie,
Sorry,
we're going to
not in
start by
stereo.
having you stand, and I'm going to ask that you state your name for the record. Thank you. If you could raise your right hand the best that you can. Do you swear to tell the truth, the whole truth, and nothing but the truth under the pains and penalties of perjury?
We've seen this lawyer before. Trying to remember where.
Your attorney has submitted an acknowledgement, a waiver of rights, and also a waiver of sentence review. Did you go through that?
Head is
before with
tender
your
today.
attorney?
It's like
Great.
one
On
hair
those
that's getting
forms,
pulled
there
and I
is a
can't find
signature
it.
line above where it says defendant. Your attorney has electronically added your signature. Has that been done with your permission? Thank you very much.
You know how you get one
I
hair and you
understand
can't
that you
find it
intend to
that's
plead
being
guilty
pulled.
today? And this is a capped plea, correct? So what I'm going to do is I'm going to ask the state to explain what it is that they will be seeking, and I'm going to come back to you and ask if that's what you expected to hear, okay?
Your Honor, I'm sorry. We do need to be seen. With regard to it.
Please approach. My apologies.
I'm glad she's doing this and not putting everybody through a trial. I know it saves everybody money, and it's one of those things that you just, oh, there it goes. Don't you hate that when you have one or two little hairs that's getting pulled and it's so distracting. Her hair looks good. Her celly must have done that. Yeah, pulling up the pant. Nervous, popping her fingers. Okay, Danielle Dolphus is quit it. Elijah Lewis's mother is pleading guilty to his murder.
Okay, so will the state please describe what sentence it will be seeking?
Absolutely, Your Honor. With respect to this capped plea, the state has offered the defendant a cap.
She's 38 years old.
Charge of second-degree murder knowing that cap is 55 years incarceration to life. The state would
And 2 counts of witness tampering, second-degree murder.
In addition to that charge, the defendant is pleading guilty today to 2 counts of tampering with a witness. Each of those has a penalty of 3.5 to 7 years incarceration.
incarceration. The tampering with witness charges would run concurrently to one another, but the defendant has agreed that the 3.5 to 7 year sentence for those together would run consecutively to any sentence imposed on the second-degree murder charge. So the state at sentencing will be seeking a total sentence of 58.5 years to life incarceration.
Okay.
Between September 27th through September 21st September 27th of 2020 through September
course.
21st of 21, Elijah was assaulted, starved, isolated, and neglected. He was tortured. Oh, wow. Oh, what a precious child.
Okay, I'll ask that you stand. I have a couple of questions.
He was
for you
reported missing
for the
on
moment.
October
Are those the
21st.
terms that you
5-year-old
were
boy
expecting to hear?
remains were discovered later that
Do you
month,
understand that a
buried
separate
in the state
sentencing
court in
hearing
Abingdon,
has been
Mass.
scheduled for after your plea of guilty? And at that hearing, the court will listen to arguments and hear evidence from both your attorney and from the state as to what sentence should be imposed. And then after considering all of the evidence and arguments,
I
the
just
judge
read it,
presiding over that
honey.
hearing will make a decision as to what the appropriate sentence will be. Do you understand that under the terms of the capped plea, the court will be able to impose any sentence up to the cap? Do you further understand that if it turns out that the judge agrees with the state and imposes the maximum allowed under the terms of the cap, you will not be able to withdraw your plea even if you disagree with the court's decision? All right, you may be seated for the moment, and I'll turn to the state. If this had proceeded to trial, what facts would the state have been able to prove beyond a reasonable doubt?
Your Honor, if this case had proceeded to trial, the state would rely on the following evidence to prove that the defendant is guilty beyond a reasonable doubt of the crimes sought here, which is second-degree murder knowing and 2 counts of tampering with witnesses. Because this is a bifurcated plea and sentencing hearing, there will be additional facts of guilt the state would rely on at the sentencing phase, but we will not present them all here today. On May the 26th of 2020, 4-year-old Elijah Lewis was moved from Arizona to New Hampshire by his father, Timothy Lewis. That evening, Elijah's mother, the defendant, Danielle Dauphiné, seated to my left at trial table, met Timothy Lewis in the parking lot at the Pheasant Lane Mall in Nashville. Timothy Lewis at that time left Elijah with the defendant and her boyfriend, Joseph Staff. Elijah was carrying a single backpack containing a few of his belongings, and the defendant had not seen Elijah in over 3 years. Your State's Exhibit 1, which has been agreed on as a full exhibit, shows how Elijah appeared shortly after he arrived in the state of New Hampshire. This is Elijah as he arrived in May of 2020, looking healthy, looking happy. Timothy Lewis, after he dropped Elijah off with the defendant, returned to Arizona, and Elijah began living at 7 Sunset Drive in Merrimack with the defendant, with her boyfriend, Joseph Staff, with their 2-year-old child, a female daughter named J.S. Joseph Staff's mother, Joanne Staff, owned the home that they lived in, and she resided on the 1st floor, while Ms. Dauphiné, the defendant, Mr. Staff, and the children lived in the basement. The defendant was the primary caretaker for both Elijah and J.S. She stayed home most of the time, and Mr. Staff primarily worked outside of the home. The investigation in this case revealed that at least between September 27, 2020 and September 21, 2021, the charged period of conduct with respect to the homicide, Elijah was assaulted, starved, isolated, and neglected. He was tortured. If called to testify at trial, Dr. Cindy Christian of the Children's Hospital of Pennsylvania would have testified that child torture refers to a child who endures an extended period of time characterized by at least 2 physical assaults or one extended assault, 2 or more forms of psychological maltreatment, and neglect, which results in prolonged suffering, permanent disfigurement, or death. Dr. Christian reviewed the case file for this case, and she concluded that Elijah suffered from torture, repeated physical assaults, ongoing psychological maltreatment, including emotional rejection, denigration, isolation, and denial of care. She found severe physical neglect, all of these things resulting in Elijah Lewis's death. Your Honor, before we turn our attention to the death of Elijah Lewis here today, it's important that the court understands some of his background while he was in New Hampshire and how investigators in New Hampshire even became involved in this case. On January 15th of 2020, before Elijah was dropped off in New Hampshire, at a well child visit with his pediatrician in Arizona, Elijah was measured to be 3 feet, 1.25 inches tall, and he was found to weigh 30 pounds, 2 ounces. Elijah's birthday, the day he was born, January 7th, 2016, means that at that time he had just turned 4 years old. Moving forward to after he arrived in New Hampshire, in early October of 2020, Timothy Lewis filed a complaint with the New Hampshire Division of Children, Youth, and Families about concerns he had that Elijah wasn't receiving proper medical care. That complaint opened a DCYF assessment and documented that Elijah was living in New Hampshire with the defendant at 7 Sunset Drive in Merrimack. Text message communications recovered during the investigation show that on October 14th of 2020, the same month where that complaint was filed, the defendant sent an image of Elijah to Joseph's staff via text messaging, saying, "Look at this fucking kid's face." In the photo, Elijah has an apparent bruise on his forehead. His eyes appear swollen and partially closed. The next day, October 15th, the defendant sent a message to Joseph's staff saying that she had just received a call from their DCYF worker and that her heart had dropped because she thought maybe someone called on us. On October 28th, 2020, the day before the scheduled DCYF assessment meeting, the defendant sent a text message to Joseph's staff saying, "I had to be easy on Elijah today because of what's going on, so I gave him a bubble bath with toys." And even staff agreed, yes, we have to be careful. From records obtained during the investigation, it's apparent that Elijah was taken for medical treatment only one time while he resided in the state of New Hampshire with the defendant. That visit occurred on November 22nd of 2020. The records from that visit give us 3 important pieces of information. First, at the time of that visit, Elijah weighed 32 pounds, 3 ounces. Second, the defendant told the doctors that Elijah was leaving New Hampshire the next week and would be moving back to Arizona, an event that was not planned to occur and did not happen. 3, doctors noted bruises on Elijah's face, his left eye, and his right arm. These bruises prompted doctors to report observations to DCYF, which opened a second case about Elijah. Moving forward to January of 2021. On January the 8th of 2021, the defendant in a phone call with her DCYF worker reported to DCYF that Elijah no longer lived with her. She stated that Elijah had been sent to live with her sister, Tracy Dauphiné, in California. This option had been discussed with DCYF, with Tracy Dauphiné, and indeed with Timothy Lewis over the course of the open investigations. In fact, Timothy Lewis signed over custody of Elijah to Tracy Dauphiné, the defendant's sister, but the defendant never completed the paperwork to do that. Because of the defendant's lie to DCYF, the investigations were closed. Moving forward much further, October the 7th of 2021. On that date, the defendant gave birth to an infant boy during a home birth inside of 7 Sunset Drive in Merrimack. On October 10th of 2021, 3 days later, Joseph's staff.
We've got something.
I don't know what we've got, but it's happening. Oh, yeah, I know, right? This has been going on for quite a while. I actually forgot about it, but she's pleading guilty. But I think we may have a verdict. Everybody's coming in. Okay, we'll go back over here. When I see the judge, I'll pop it on.
Catholic Medical Center in Manchester. This began
Coming up on
DCYF
4 hours.
into
We're at 3
Joseph
hours,
Staff,
51 minutes, and
Daphne,
42
and the
seconds.
residents of 7 Sunset Drive. On October 10th, officers with the Merrimack Police Department went to that
Elijah
home
was a cute
where they
little
met with
man.
the
I saw
defendant
this
and Joseph
picture.
Staff,
He was a
as well as
cutie
with Joseph
patootie.
Staff's mother, Joanne. If called to testify at trial, Officer Dudash of the Merrimack Police Department would state that the defendant and Joseph Staff told him that they had originally lived in the basement, but had moved to the first floor because of renovations happening. But when he went to look in the basement, they stopped him from doing so. Officer Dudash would testify that as he looked around the first floor of the home, there were no signs that a little boy had lived there. 4 days later, on October 14th, the Child Protective Services worker was assigned to the infants case and reviewed the history of family assessments with respect to the defendant, Ms. Daphne. At 8:07 in the morning, according to the phone records, that worker called the defendant and asked her where Elijah was. The defendant told the worker that Elijah was gone, that he had left. The worker asked her what that meant, and the defendant said, he's gone. The worker confronted her again and said, a 5-year-old doesn't just walk away. The defendant then said that Elijah was with her sister, Tracy Daphne, in California. The defendant then began sending messages to and calling Tracy Daphne. The defendant's phone records, in fact, show 87 contacts, messages, and phone calls between the defendant and Tracy Daphne on October 14th between 8:25 a.m. and 12:47 p.m. At 12:45 p.m., the DCYF worker would testify she called Tracy Daphne in California and asked her about Elijah. Tracy Daphne reported to that worker that she did not have Elijah, had never had Elijah, and that she hadn't seen him over video calls in months. She expressed her continued desire to have Elijah. Tracy told the worker and later told investigators with the New Hampshire State Police and Merrimack Police that the defendant had contacted her earlier the day of the October 14th, 2021, and that in those contacts, the defendant asked Tracy to lie. She asked Tracy to tell investigators that Elijah was with her when he was not, and Tracy refused to do so. At 1:03 p.m. and again at 1:18 p.m., again on October the 14th of 2021, according to cell phone records, the defendant was again confronted by DCYF workers about Elijah. She asked why. The worker told her that Elijah wasn't in California with her sister, at which point the defendant told the worker that she had sent Elijah to her brother's house. In bits and pieces, question by question, she told DCYF that her brother's name was Bruce Rowland. He was later identified by investigators as Bruce Scherzer. She told investigators that Bruce lived in Texas and eventually provided a phone number for him, but could not give an address. The defendant told the worker that Elijah had been in Texas since September sometime. And looking at her phone records, investigators found that there were 17 contacts, messages, and calls between the defendant and Bruce Scherzer on October 14th, 2021, between 1:12 p.m. and 8:36 p.m. At 1:45 p.m. on October the 14th of 2021, according to DCYF records, the worker called Bruce Scherzer, and he said he did have custody of Elijah. Notably, Mr. Scherzer could not provide any information about Elijah. No school, no location. He said he'd had Elijah in Texas since September. because he couldn't provide workers with information they were asking for, he was told to call them back. And he never did. Shortly thereafter, DCYF responded to the lobby of the Merrimack Police Department and reported that Elijah Lewis was missing. After several hours, and with the assistance of officers from the Merrimack Police Department and the Fort Worth, Texas Police Department, investigators were able to find out that Bruce Scherzer did not have Elijah Lewis with him in Texas, and that he never had. Bruce Scherzer spoke with officers and advised that he last knew Elijah to be in the custody of the defendant in New Hampshire. He told officers she had contacted him on October 14th of 2021 and asked him to lie to investigators and say that he had Elijah. He agreed to lie. Further, Mr. Scherzer sent investigators during his case copies of text messages that were sent to him by the defendant in which she asked him to lie. Your Honor, States Exhibits 2A and 2B, which are admitted as full exhibits here, show Bruce Scherzer's exchange of messages with the defendant concerning Elijah. The first message was received by Bruce at approximately 1:26 p.m. New Hampshire time. You'll see on the screen at the top of each message that it says 12:26. New Hampshire time is actually 1 hour ahead. And stated in that message, the defendant wrote, September 10th, Friday, you came and got him. You drove up and got him. In States Exhibit 2B, Your Honor, which is attached there, you can see the moment where Bruce Scherzer starts to go back on his lie. In fact, he's confronting the defendant and asking her what she got him into and telling her to get him out of it. He didn't know that it was more than just a wellness check, and she needed to have people stop blowing up his phone.
Well, guys, I guess they don't have a verdict.
Contacted the defendant
Excuse
at
me.
3:16 p.m., so 2 hours after she had provided Mr. Scherzer with information about saying you have Elijah. During that phone call at 3:16 p.m., the defendant and Joseph's staff agreed that they would respond to the Merrimack Police Department by 4:30 p.m. in order to sign paperwork related to their infant child. They did not respond to the Merrimack Police Department. In fact, Your Honor, records recovered during this investigation show that at approximately 3:16 p.m., as shown in States Exhibit 3, which is as a full exhibit, shows that the defendant and Joseph's staff, while the defendant was on the phone with the Merrimack Police Department, were at the Digital Federal Credit Union in Nashua, New Hampshire, where Joseph's staff used Joanne Staff's credit card to take $1,000 out of her bank account. The defendant and Mr. Staff did not respond again to the Merrimack Police Department after this withdrawal, but they went to the Target store in Burlington, Massachusetts, States Exhibit 4, Your Honor, where they purchased new cellular phones to replace the devices that they were currently using. At the Target store, they purchased clothing and toiletries. They were in the Target for approximately 1 hour. And Your Honor, based on the investigation to date, at this time, the body of Elijah Lewis was in the back of Joseph Staff's truck, parked in the Target parking lot. Your Honor, investigators were able to trace the defendant and Mr. Staff's whereabouts through their phones and through their social media accounts, and this is through their original phones that were known to investigators. Records showed that they had gone to this Target location, and investigators were able to find information about these new phones. So investigators were then able to use their new phones to follow their new fits further. The records from their phones show that the defendant and Mr. Staff traveled through Boston and then arrived at the area of
Y'all, let's see what this is. Y'all ready? Reached a verdict.
We have a verdict
4 hours.
to the members of the public. If you don't think you're going to be able to not show any emotion during the reading of this verdict, I ask you to remove yourself now. There won't be.
Just under 4 hours.
The court won't tolerate any outbursts of any sort from anyone. You will bring me here?
You notice they're sitting back there with him this time. Yeah, we all know the answer. What is the answer going to be? Guilty. No, I'm kind of being facetious, but I really don't see how this could not be guilty. Now, I don't know if they're going to do the sentencing phase or not. While we're doing this, I've been editing my paper. I'm trying to finish it. As soon as this is done, I'm going to have to get off and finish my stuff. He was.
Ladies and gentlemen of the jury, have you reached a verdict? You have your four person. If you would stand and read your verdict, please.
Why isn't he standing?
We, the jury, find the defendant guilty of conspiracy to commit first-degree murder as charged in count 1 of the indictment. We, the jury, find the defendant guilty of first-degree murder as charged in count 2 of the indictment. And we, the jury, find the defendant guilty of convicted felon in possession of a firearm as charged in count 3 of the indictment.
Thank you. Juror number 1, is that your verdict? Juror number 34, is that your verdict? Yes. Juror number 35, is that your verdict?
Yes.
Juror number 11, is that your verdict? Yes. Juror number 14, is that your verdict?
Yes, ma'am.
Juror number 17, is that your verdict?
Yes, ma'am.
Juror number 27, is that your verdict?
It is, Your Honor.
Juror number 33, is that your verdict?
Yes.
Juror number 25, is that your verdict?
Yes.
Juror number 44, is that your verdict?
Yes.
Juror number 23, is that your verdict?
Yes, ma'am.
Juror number 28, is that your verdict?
Yes, ma'am.
Thank you. Ladies and gentlemen, I want to thank you again for your time and attention to this matter this week. Our system of self-government would not work without your service and sacrifice that you made. Thanks again for your time and attention. You are excused.
Jurors excused.
Yeah, they knew they were going to get it. She looks like she's going to cry. You knew he was going to get guilty.
Mr. Johnson, the jury having found you guilty of conspiracy to commit first-degree murder, and convicted felon in possession of a firearm. As the 13th juror, I affirm this verdict. As to the first-degree murder, I sentence you to life in prison. I will set punishment as to the conspiracy and the convicted felon in possession of a firearm after a sentencing hearing. The date for that hearing will be
Did she say life already? And then they're going to set up another hearing for possession of a firearm? Okay.
November 1st?
Yes, Your Honor.
November 1st. There's nothing else to take up?
We will prepare the judgment sheet and pass that forward, Judge.
Thank you. And the pre-sentence report. The order for the pre-sentence report.
Sir, let's move that. We'll get those to you.
Thank you. You may adjourn court.
All rise. This honorable court stands adjourned to Monday morning at 9 a.m.
But she didn't say you have a right to an appeal, you have 30 days. It's none of that. That's strange to me. That is unusual, honestly. And I would expect them to go over that information, but I guess not. They're happy. It must be the family, that guy right there.
Mr. Hagerman, have you heard from Mr.
I've
Roy?
been texting with him, and he hasn't given me a date yet. My sense is next week is not good.
Okay, that's something different. All right, guys, guilty. All counts. We done with that one. So we're going to delete all of the little doodads that I have for it. We knew it was going to come up guilty. We'd be foolish not to at this point. It's a matter of formalities, I guess. Okay, well, there goes that. Life in prison with his friends. Not technically, his friends can't be in the same prison with him. They cannot be in the same prison. So, okay, guys, I've got a lot to do. Appreciate you hanging with me today. And don't know what's going to happen tomorrow. Do we have anything tomorrow, Ronnie? I don't think we do. Don't we have the Sarah Boone motion tomorrow? Yes, we do have the Sarah Boone tomorrow at 2:00. That one did get changed to 2:00 tomorrow in the afternoon. So we will be live for that for sure. I don't know. I may take the day off otherwise. I've got a lot of things I got to take care of. Yes, and it is a Zoom meeting, so we'll get on with that. But we'll see whatever breaks. We'll play tomorrow by ear. So with that, you guys have been amazing. We appreciate you. Y'all go and have a good evening. Those of you who are in the path of the hurricane, our hearts and best wishes are for you. Please stay safe. Do not do anything stupid. Take care of yourself and your neighbors. And we will see you in the morning. And hopefully you will all have homes. I know it breaks my heart. And this is for the last time in remembrance of Young Dolph, Adolph Robert Thornton Jr., passed away November 17th at the hand of 2021 at the hands of Justin Johnson, who is now going to be serving a life sentence. With that, farewell. See you on the flip side tomorrow.